All right. Well, I lost my deputy. Why don't you just go let him in? Okay. I did that on purpose. Oh, Gino council time to shop.
Yeah, she was loving
Sure. Germans.
No, we returned ours yesterday. That's right.
Take home jar packets.
No.
And we gave them all,
Just making sure.
Yeah,
One
yes.
last
Yeah,
call.
yeah.
Okay,
we gave them all yesterday.
These chairs are really like.
You can
Okay.
This,
Like, why is
you
it-
can stop it here. This,
Yeah, it's not, it's, neither way is great.
Just control your own.
Yeah.
Lean.
It's a full day core workout.
Like sitting on a balance ball.
Rise for the jurors. Here's the president comment for you, Your Honor.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. As I understand, unfortunately, my predictions about some traffic for many of you came true, but I do want to thank you for making your best effort because I know we received some phone calls very early in the morning about these concerns. And so, again, thank you for letting us know that. And if you think it's going to be a recurring issue, you can flag that for us. We can see what we can do, or if you have any other requests. With that, as I mentioned yesterday, we're now ready to begin opening arguments. And I'll remind you again, as I did yesterday, that opening arguments are not evidence, and it's simply just, to be a preview of what the evidence is expected to be. So with that, as a plaintiff presenting an opening argument in this case. All right, floor is yours.
Court, counsel, ladies and gentlemen of the jury. We are here today because the Piedmont Park Conservancy prioritized money over safety. By now, you're familiar with our client, Be Our Guest, which owns the Nook across from Piedmont Park. They opened in 2009 and have been very profitable and successful ever since, especially for a small business. The Conservancy, as it sounds like many of you already are aware from juror selection, is one of Atlanta's most powerful and influential boards, comprised of Atlanta's leaders of top businesses and corporations. Back in 2016, our client, Be Our Guest, which is Mr. Roulette, Mr. Dooley, and a third partner who is not here, Mr. Edgerton, won a bid to expand its operations over to the community center at Piedmont Park. You will hear that the Piedmont Park Conservancy, and for sake of efficiency, I'll call them the Conservancy, is a owner of that community center and is the landlord of that community center. So the Conservancy Center awarded the bid to our client because of their past success. In 2018, our client started construction, specifically in June of 2018. Within a month, our client had to halt construction because a sinkhole was discovered under the foundation of one of the two restaurant spaces they were opening. Our client consulted its general contractor. The general contractor said there's a safety risk here posed by the sinkhole itself and the possibility of other sinkholes under the building signaled by this sinkhole. And that safety risk is to the construction workers on site, to park goers, and to potential future restaurant goers. Our geotechnical, or excuse me, the contractor had engineers on site as well. A structural engineer and a geotechnical engineer. You'll learn in the course of this case, the structural engineer looks at the safety of buildings. Geotechnical engineer, and I know some of you know this because you're in this world, look at the soil condition and the safety of the foundation. Both of those engineers were consulted. Both said the safety risk is too high to move forward with construction. On top of all that, our client had taken out a $1.3 million loan to build. And the bank said, we are not going to continue to advance funds because the safety risk is too high to move forward. Our client prioritized safety and followed their advice. Immediately, our client sought to work with the Conservancy to help out because it already had its contractor, its crew, its engineers on site. And there was cooperation at the beginning. For some reason, a few weeks later, August 7th, the Conservancy took over the investigation. It was their right to do so. The Conservancy owned the property. Under the lease, they had the obligation to keep the foundation in good repair. Our client had no choice. And so our client trusted that the Conservancy would operate in good faith and do the right thing. It turns out the Conservancy was not interested, though, in safety. It was interested in its bottom line. And so the first thing the Conservancy did was try to get the city of Atlanta to take over the investigation. The city of Atlanta, you see, is responsible for the sewer system underneath the city. And there was a thought maybe the sewer is the cause. And so the city of Atlanta came out not once, but twice to inspect the sewer lines, did the standard testing. You'll hear from witnesses during this case, concluded the sewer system is not compromised. This is not the cause of the sinkhole. But on that second visit out, the city did something that would really change the course of events. They dumped grout into that hole. Grout, for those of you not construction folks here, if you're like me, had to learn this going forward, is a cement-like substance that can be used to replace soil. The Conservancy then got a formalized memo from the city that explained what had happened, handed that to our client, said, BOG, be our guest. With this report, you should move forward with construction. Everything's good. It was about a 1 to 2 page report. Did not have any engineering report attached. Did not say that the site was safe. It was limited to say backfill had been dumped in the hole. So our client did what you would expect. She consulted her general contractor, consulted her geotechnical engineer, both of whom said, sorry, we've read the memo. This is not sufficient. We cannot tell you that this site is safe to move forward. And so our client prioritized safety and she followed their advice. And by the way, the bank still would not lend money for the same reasons. Then you're going to hear that a few months later, in February of 2019, the Conservancy came back to our client with another report. This time from a structural engineer, and you'll hear during the course of this case, as I mentioned, structural engineers look at building structures, geotechnical engineers look at the ground and below. The structural engineer basically said in his report, the site is safe, you can continue building. So our client did what you would expect. Went back to her general contractor. General contractor looked at it. It said it does not identify the cause of the sinkhole. And it indicates, it does not identify the cause of the sinkhole. It's from a structural engineer. It's absent information we need to feel comfortable to move forward in this case. It is still not safe for you to build. You need to have the Conservancy give you a report from a geotechnical engineer who has done an inspection to determine the cause and the scope of the sinkhole. Our client really wanted to get to work. Brought in another geotechnical engineer, hoping maybe somebody could say, no, really, this is okay. The next geotechnical engineer came in, looked at that report again and everything else, said, sorry, you cannot move forward. It is not safe to move forward. We need a geotechnical engineer to conduct an investigation, determine the cause and scope so that whatever needs to be done can be done to move forward safely. The lender still would not advance funds either with that report. It turns out that our contractor and our engineers were more right than they might have even understood at that point not to move forward. Because one of the remarkable things you'll learn during the course of this case is that engineering report that had been provided to our client to say it's safe to move forward was not the only engineering report. That same engineer had drafted an earlier report of that same date, signed, had a seal affixed to it. And that report, which we only discovered years later during litigation, also concluded that geotechnical engineer needs to be involved and that the cause needs to be identified, the scope identified to safely move forward. It was dated the same date as the sanitized report given to our client, but our client never saw that report from the engineer, which agreed with our engineers. So what you'll learn is by this point in the case, everybody who had been consulted about the sinkhole, the contractor, our engineers, two of them, a third engineer was brought in, and as it turns out, their engineer all said, this same thing needs to happen before it is safe to continue construction. And as of May or July of 2019, the lender said the same thing. There was only one entity in this entire matter you will hear during the course of this case that said it was safe to move forward building, and that was the Conservancy. And ladies and gentlemen, that is why we are here today. Our client prioritized safety over the bottom line, following their experts and people on the ground. And they're here today seeking to be made whole for the hundreds of thousands in lost construction costs. They're here to ask for future lost profits because they had a 10-year contract to be followed by two that never got to be realized, 2 5-year contracts that never got to be realized. They're also going to be asking you for attorney's fees because we're here 5 years later and they've had to litigate this all the way here to get to you to seek justice. Let me tell you a little bit more about some of the details of this case, as well as a little bit of the evidence. So if we can, all right, here we go. So we have a timeline up on the screen. Hopefully you all may be able to see that. I'm realizing it kind of small writing. But we'll try to sort of talk through this and I'll try to stay chronological, but may not be entirely. So as already discussed, our client is Be Our Guest. I've already shown you who our folks are. Everybody here by now has certainly heard about the Nook if you weren't aware already from our juror selection. I think an important point to understand in all of this is that the Nook wasn't up until then, the 10 years until the build started, to this day, very profitable small business. We've already talked about the fact that the community center is owned privately by the Conservancy. The two restaurants that were being built out were called Walker's 1834 and Soulshine. And those were references back to historical Piedmont Park or current Piedmont Park. Our client, you're going to hear, was very invested in Piedmont Park. In fact, you're going to hear that up until this dispute, they were very much aligned. Our client had fundraisers on behalf of the park at the Nook. You'll hear that they had a special drink at the Nook called Drink for the Trees, whose proceeds of which would go directly to the Conservancy. They were very, very close up until the time of the dispute, and is part of the reason that they were chosen to occupy this space. You'll hear that the parties signed a lease to move forward, and as already indicated, the lease was going to be for a period of 10 years, with the possibility of renewing twice for 5 years each after that. And that's because the Conservancy was so bullish on our client and the success they expected to happen. In fact, they were so bullish about our client, you'll hear, the Conservancy didn't do a traditional rent payment. Part of the rent payment was based on the anticipated profits of our client. That was how the parties went into this, believing this was going to be a great, great success. You'll hear that in June of 2018 is when the construction finally started. And then the sinkhole was discovered about a month later. We put up a picture of the sinkhole. On the right is sort of how it looked at the time it was discovered. What happened is that the general contractor, who you'll hear from in this case, the guy by the name of John Norton, in fact, he'll be the first witness you hear from in this case, worked for a company called J.M. Williams, that I found a double slab at the floor of the building. For some of you, that'll mean something. For many of you, it may not. Long and short of it, it was something that had to be addressed. When they knock it out of the way, lo and behold, they find this sinkhole. Now, as you can see here, it was very hard for anybody really to observe what was going on in the sinkhole. So initially, folks are looking, making observations. But what they sorted out is this appeared to be about 6 to 8 feet wide, 10 feet long. It goes down maybe 12 feet, maybe more than 12 feet. What you're seeing on the left, by the way, is at a later point in time when the city come out to do its work and to put some siding up to sort of protect the hole from caving in. But that's what the sinkhole looked like. And so what happened then is that John Norton, again, the general contractor in this case, did what he was supposed to do, immediately called the Conservancy, specifically Mr. Banta, the gentleman sitting at the table over there with counsel, said, hey, discovered a sinkhole, what do we do? And as already indicated, the party's first instinct was to work together because John Norton's already at scene with his whole crew, his engineers and everybody else. So that's where this started. You'll hear that during the course, especially of these early days, that Mr. Banta was actually relying on our engineers to move forward. All the parties were relying on our engineers to move forward. And you'll hear that by about July 19, our engineers had concluded, hey, what needs to happen is the walls of this hole need to be shored up so the investigation can be conducted to figure out what's going on for purposes of safety. And in fact, you'll hear on August 6th of 2018, Mr. Banta declared this a life safety emergency. A life safety emergency. This is how the parties viewed this problem. August 7th, the parties thought they had reached a plan to handle the investigation, but by that evening, you will hear that the Conservancy changed direction. And again, as it was entitled to do as the owner of the premises, took over the investigation. You recall, investigation with tail going to the foundation, which they're responsible for, and possibly out beyond the spaces our party had leased. So again, for which our party had no permission, absent the Conservancy's granting access to do this. So what happened from that point, from August So one of the things that happened from that point is you already heard a little bit about. The city of Atlanta went out to the site, and you're going to hear some of the folks on the stand in this case. And they conducted what they will tell you was standard testing to drop a video line down into the sewer system to see could this be the problem. They also did separately a test called dye testing, separately a test called smoke testing to see if you put those things in, if it comes out somewhere to show that there's a hole or, that the structure has been compromised. And that they did that and they concluded there was not compromised. The sewer system was not compromised. It was not the cause of the sinkhole. And they relayed that back to the Conservancy. And so you will hear that the Conservancy then tried to find other possible solutions. Right, as I said, they had taken over the investigation. Our client is not involved at this point in the investigation. But the Conservancy tried to directly work with our contractor and engineers because, again, they're on site. It's sort of the easiest thing to do. What you'll learn is between July and September of 2018, the sinkhole expanded by about 3 feet at the top, maybe a half foot going down. And so with that, our contractor who was negotiating with the Conservancy said, hey, we need an insurance provision in any agreement with you to protect our workers who are on site before we can let them keep working here. And the Conservancy would not agree to indemnify their workers. And so the general contractor said, sorry, we can't do the work then. And this is the point at which you'll hear that there was a true impasse. Basically, the contractor told our client, we can't move forward. Can't move forward, guys. And so there was a stop work order issued. From this point, you'll hear how the city then went and put the backfill in. And during the course of this case, you will get to see the report, the formal memo from the city of Atlanta. You'll get to see it yourself. And you'll see what it does and what it does not do. And what you'll see is that report does not indicate the cause of the sinkhole. Instead, it indicates that backfill was placed in there to fill the hole and to stabilize the area. But it does not say it is safe to build. And you'll see that report yourself. Now, let's pull up, please, the Hagberg chart. So I referenced earlier that the Conservancy had an engineer who handed a report to our client in February of 2019, said safe build. You heard a lot about this guy, but see him on the stand during the course of his trial. His name is Eric Hagberg, and he works for something called Palmer Engineering. And what you'll hear during the course of this case is in November, after the backfill had been applied, the Conservancy asked Mr. Hagberg to go out and determine the safety of it. And what you'll find is here's the first thing that happened. He issued a first report. And this is the report I referred to earlier that was never given to our client, except we discovered it during the course of litigation much years later. What does this one do? First of all, I'll use the word sinkhole. You'll see why that's important in a moment. It recognizes that additional monitoring and probing is needed with respect to the sinkhole because of potential future erosion that every engineer in this case was concerned about. You'll hear that future sinkholes could form because of erosion pathways, meaning the water flow that was going through this hole. One thing you'll hear during the course of this case from the witnesses is that people were on site, you could hear water gushing when you were standing near the sinkhole. So people knew there was an issue of water and erosion. So this recognizes that may be an issue. The thing you heard me say probably 15 times or more now, neither a geotechnical engineer referenced in this first report. Admittedly, it is not as stated as aggressively as in some of the other reports. It is in there. You'll get to see this report yourself. And it's dated November 15th, which we think is when it actually was drafted. But the only party that got that one was the Conservancy. Let's put up this next one. You're gonna hear about Hagberg 2. What is Hagberg 2? That's just what we're calling it. The Hagberg 2 is the one that was actually given to our client. You see that at the bottom, one that was handed off to the Conservancy. What is different? Well, you'll hear evidence that it uses the word void instead of sinkhole. Just a quick detour. What I've learned during the course of this case, which many of you who are construction folks already know, a void is erosion that occurs on a man-made landscape. A sinkhole is what the erosion that may occur like in Florida when it's a geological erosion of soil. So man-made versus geological. Colloquially, they're often referred to the same way as a sinkhole. That's how you'll hear us refer to it during the course of this case. I think the sinkhole may have certain connotations. You'll see that they replace the word sinkhole with void. Here, instead of saying need for additional monitoring, additional probing, it says no future erosion exists. You'll see it minimizes the concern about future sinkholes. In other words, much more assertively stated about concern about future sinkholes in the report given to us. Looks like much less of concern. You'll see critically, there's not even a reference in the second reports given to our client to a geotechnical engineer. The one thing that the drumbeat they heard over and over from their people is now missing. No one is given to them. And then you'll see, though, even though it was finished being prepared in February of 2019, it was backdated to November 15th to make it look like this was the first investigation that was done by Mr. Hagberg. At least one reading it could reach that conclusion. All this notwithstanding, you're going to hear, I should add one more thing, sorry. You will hear during the course of this case from Mr. Hagberg that between Hagberg 1 and Hagberg 2, the one finished in February, didn't learn any new information. He never went back to investigate the site. No additional inputs. You'll hear that he hammered out Hagberg 2, working with counsel, with the client, and some PR people. And that's when he made those changes. Let's move to the next. Let's see, where are we? Sorry. So, yeah, sorry. Let's go to the get back to work slide. Now, what you're going to learn during the course of this case is that our client, it basically, especially Ms. Drolet, put her life savings into this project. It meant everything to her to get back to work. And so she tried everything within her power to do that. The caveat being she wasn't going to do it if you couldn't do it safely. So I'm not going to read this off to you. There's a lot of stuff up here. But I think a few of these ideas have already come through already. She revisited not once, not twice, at least 3 times with her contractor or engineers, whether she could get back to work safely. Every single time consistently, the answer was no. You'll hear that she got a new geotechnical engineer, hoping maybe he could look at it a different way, maybe come up with a different conclusion. That new geotechnical engineer said no. You'll hear about her efforts. Maybe the city had an engineering report that I'm not aware of. The Conservancy would never give her an engineering report, but maybe there's something on file. You'll hear about multiple open records requests to the city, maybe to see if there's an engineering report. You'll hear that there wasn't. For our client this day. And so those bubbles, boxes, whatever you want to call them, reflect the many ways our client was attempting to get back to work because this was her passion project, if you want to call it that, where she invested her savings. So what we expect the evidence is going to show effectively is this. Well, sorry, I need to cover one more thing. So what we think the evidence is going to show during the course of this case is from about October 2018. The Conservancy actually never had an intent to get the site safe. From that point, their goal was to get our client back to work, whatever it takes, thus the city to plan a memo, thus the Hagberg report. And what you're going to hear is at least some of this was motivated. Stakeholder slide, please. To protect the image of the city. I'm sorry, of the Conservancy. So you'll hear, what you already heard at some length, our client was told, hey, this is repaired. You're gonna hear also, the Conservancy said that to the public. This is in January of 2019, that the Conservancy tried to convey to the public, hey, everything is safe here. And what you're gonna learn during the course of this case is they had to revise that press release at the urging of the city of Atlanta to remove any reference to the city of Atlanta, which did not want to be referenced in that press release, is supporting this conclusion. And you're going to hear that the Conservancy even told parents of a community center located, or of a children's camp at the community center, that this has been repaired. So the Conservancy is telling the rest of the world it's repaired, while our clients trying to actually get it repaired. You'll hear that during the course of this case. We'll wrap up with just a little bit about some of the evidence you can expect to hear during the course of this case. We have talked about the city report, the fact you're going to get to see that yourself. And you'll see with your own eyes, it doesn't reference, it specifically says the sinkhole or the sewer is not the cause of the sinkhole, does not identify a cause of the sinkhole. You will see that it does at some point use the word repair, but when you get to see the report yourself, read it in context and find out about the city, what happened afterwards, you'll find out that whatever it was not repaired, and there was no engineering report or anything to indicate this was safe to build, as confirmed by our clients, contractor and engineers. You're going to get to see for yourself during this case something. So trials are not always fun and exciting. Maybe they're never fun and exciting. I don't know. But one thing you have to bear through are attorney invoices from our clients. Our client lost a lot of money in litigation, and our client's view is they didn't have a choice. They weren't going to lay down, take it. They believed in safety, and they were going to prioritize that, and they weren't just going to back down. They invested too much in this. And so we've had years of litigation in front of you, and we're going to be asking that our client cover that during the course of this case. And you're going to see all the invoices. I've heard of attorneys. It's been a lot of years. We hear a number of attorneys. We'll talk about the invoices that happened during the course of this case. Kind of boring, but unfortunately a necessary part of our case. You're going to get to see the lease yourself. Without seeing the lease, you'll hear that it's common for something like the sinkhole, something underground, to be the responsibility of the landlord. But also it's the case that the lease makes that clear. In this case, you'll see it. And further, the investigation that would have had to happen would happen outside the two leased spaces. Ultimately, if we put up the cause slide, please. And is this. We're going to put up most of these witnesses that you see on the left here. In fact, actually all of them. You're going to hear directly from them during the course of this case. And what you're going to hear uniformly, Mr. Norton, the contractor, Mr. Erickson, the structural engineer on site, Harper, the lender, Mr. Settles, the geotechnical engineer, the second one that was brought in spring of 2019. Mr. Bauer, the original geotechnical engineer on site, is that one thing was needed. One thing that was needed that was never provided to our client. A report from a geotechnical engineer that this had been investigated, the scope and cause, so we knew how to move forward. And you're going to hear actually from Mr. Hagberg, and you're going to hear that he had a September report before the backfill was added. That's more or less the same thing. Then you're going to hear Hagberg had what we call Hagberg 1, that first report, plus there's either 5 or 6 other versions that said we need it. There was only one report, the final one by Mr. Hagberg, number 7, the 7th turn, that finally didn't say, hey, this is needed. And so you're going to hear that during the course of this case. You're going to hear it's because of that. You're going to hear it's because of Mr. Hagberg especially. You're going to hear because of what the Conservancy knew, but instead told our client. Because of what the Conservancy knew, but instead told the public, the parents, that we are contending that the Conservancy in this case did not operate in good faith, but in bad faith, and that is the basis for our client recovering attorney's fees. In fact, You're gonna hear, as galling as it is, the Conservancy has actually countersued our client in this case, dragging the litigation out further, trying to make them responsible for what happened here. We're gonna be asking you at the end of this case to return a verdict for our client, as well as the fees for their sunk construction costs, for the future lost profits, for the attorney's fees they've incurred because all they did was insist on safety in this case so they could build a restaurant that people could enjoy. Thank you very much.
Defense ready?
Yeah.
May proceed.
Ladies and gentlemen, good morning. Let me be perfectly clear. The allegation that the Piedmont Park Conservancy, my client, prioritized money over safety is utter nonsense. What this case is really about is the tenant, Be Our Guest, who was well over budget and substantially behind schedule in its restaurant build out, using the discovery of a sinkhole, you're gonna hear more about that, and an alleged safety issue as a means of forcing or leveraging the Conservancy to pay it money in order to salvage what was clearly a failing business enterprise. Mr. Halsey referenced the lease, but he didn't talk a lot about it, other than to tell you it is a 10-year initial term with 2 5-year extensions at the tenant's option, assuming the tenant is in good standing under the lease. Mr. Halsey alluded to lost profits. What he did not tell you is what he's going to ask for and what has been demanded of the Conservancy throughout the years is that the Conservancy pay Be Our Guest 20 years of lost anticipated profits. Anticipated profits of a business that never opened its doors. A business that never had any revenue. A business that had early expenses that were radically different than that were budgeted. And a business, you'll see Be Our Guest was formed for the purpose of exploring restaurant opportunities in the city of Atlanta. After the termination of the lease, my client did eventually terminate this lease. After the time to be paying rent and after the time to be operating had been long past. After the termination, did Be Our Guest, as you would expect, continue to explore restaurant opportunities in the city of Atlanta? No, it's done nothing. And it's going to ask you to pay it, to have my client, a nonprofit, pay it 20 years of made up anticipated profits to the tune of $4+ million. Running a restaurant is hard work. I don't know if any of you have any experience. Most of us have worked in one at some point. But again, 20 years of lost profits is what they want. Let me pause and make some introductions. I'm Jason McClary. I think I've introduced myself to y'all. I'm with the law firm Troutman Pepper here in Atlanta. I have with me in the courtroom my co-counsel, Brett Mason. Sitting to her right is Mark Banta, the recently retired CEO of Piedmont Park Conservancy. You're going to hear a lot about Mr. Banta. Mr. Banta is going to endure, and you're going to hear from him. You're going to hear from him later in this case. The plaintiff brought this lawsuit, and the way that rules work, they get to put on their case first. We have to wait and go second. As you heard Mr. Halsey say, we have a case too. We are also asking for attorney's fees. We're asking for attorney's fees on 2 bases. One, bad faith of Be Our Guest. Be Our Guest was willing to go on camera to yell far and wide, there is a life safety emergency. The Conservancy is endangering park patrons. The Conservancy is endangering anyone who comes near this building. There will be no credible evidence of a safety concern in this case. Not a single engineer, that you heard Mr. Halsey talk about is going to testify that the community center is unsafe. This is a picture of the community center as it sits today. You're going to hear all about it. You can see a little bit the Willie's logo, and it says Howlin'. Don't ask me how a burrito place got into the chicken or hot chicken market, but that's what they've done. Willie's has operated throughout this. In fact, Willie's has operated in this building for going on 20 years. The location where there was going to be what's called Soulshine, it was going to be a grab and go type restaurant. That location is where the void was discovered. Willie's Howling Chicken, once the lease was terminated, wanted to get into that space as quickly as possible, has been successfully operating there ever since and to this day. They looked at the same information, as did Shake Shack, the exact same information that was provided to be our guest. And they determined they were ready to go to work and they were ready to operate their businesses. Also wanted to introduce in the courtroom, Ellen Sachi. Ellen is the lady with the purplish pink jacket on. She's the immediate past chair of the board. And Doug Widener. Doug is the current CEO of the Conservancy who took over after Mr. Banta's retirement. You're going to hear a lot in this case about Mr. Banta operating outside of the purview of the entire board. That has been a theory of Be Our Guest since the beginning of this case. What the evidence will show is that is fundamentally untrue. I also want to go through the sequence of events here because putting things in order and understanding what happened when is critically important for your understanding of this case. Before we do that, let me just pause and say thank you very much for being here. I know this is not what everyone wants to be doing for the next several days. I appreciate all of you. I very much appreciate those of you who live in northern Fulton County or far southern. We've got a long county, and I know some of you it's not convenient to get here. So thank you. So February of 2017 is really when the lease negotiations between the Conservancy and Be Our Guest began. There were several other national, very well capitalized, very experienced chains that were interested in this site. The irony of this case, really, as I've seen it, is all of the bad things that have been said about Mr. Banta, all of the mud throwing, all of the allegations. Mark Banta was the biggest cheerleader for Be Our Guest. You've heard about the sophistication of the board of the Conservancy. That's true. There are a lot of impressive folks on this board. There are a lot of folks who have a lot of experience in commercial real estate. Lot of experience in commercial leasing to restaurants. There were a lot of folks who on the front end of this thought Mr. Banta was crazy. Why would you go with a small local operator who's not well capitalized, who we have concerns about their ability to get this across the finish line when you have national well-capitalized groups beating down your door? Mr. Banta continuously pushed back against these board members. The desire was to go with someone local, to go with someone that we knew, and to go with someone who was coming in with a fresh concept consistent with what Mr. Halsey said in terms of a park-centric theme. Walker's was one of the early landowners who at some point conveyed the land that became Piedmont Park. Soulshine, I've seen reference to, it pays respect to music in the park over the years. I assume there's an Allman Brothers song, Soulshine. So that's what the park was looking for, something park-centric, something new, a distinct concept. They certainly weren't looking for, as you're going to hear, and this has shifted over the years, they certainly weren't looking for an extension of the Nook. That only began in support after this litigation was filed. We started to hear about an extension of the Nook because that's the only possible way Be Our Guest can argue for lost profits. You're going to hear an instruction from the judge before deliberation on this issue. Again, 20 years of lost profits, no effort to mitigate those damages, no effort to open restaurants anywhere else. Let's move forward. So I want to talk a little bit about the lease. We're going to show it to you. You'll be able to have it in evidence and review it. You didn't hear about these provisions in Mr. Halsey's statement. It's an as-is lease. This is a 100-year-old building. The Conservancy is not a commercial landlord. They are technically, but that's not their main job. They're protecting the park, they're improving the park, they're doing programming in the park, they're doing fundraising, which is important. This is a donor-funded organization. And they don't have professional property managers. They're not able to be responsive to issues with tenants like you might expect at an apartment building. So that was important, as is. The landlord has no obligation whatsoever to construct any improvements. You take this building as is, and you, tenant, hire your contractor, hire your architect, and you do whatever build out is necessary. And to the extent you uncover things that cost more money, as you probably will in a 100-year-old building that's been used for many purposes over the past century, that's on you. That's on you. And frankly, you're going to hear the way people handle this is you have a contingency. No contingency here. This was hard bid to the contractor. The contractor had a right to change orders or to more money when it ran into issues. There was no contingency to fund those. Be Our Guest. The landlord makes no representations regarding the condition of the building, and the tenant is responsible for all improvements needed for the tenant's business. What you're going to see is the sinkhole was the tenant's means to try and shift that obligation to the Conservancy. Couple more lease provisions. Landlord's sole maintenance obligation is to keep the exterior walls, excluding the storefront. What we're interested in here, of course, is foundations. We don't deny, of course, the landlord was required to keep the foundations in good and tenable repair. That is the sole maintenance obligation of the landlord. What's a self-help right? It's so important to the Conservancy. Again, if it's not able to get out and perform a repair that it's obligated to perform under the lease, it's provided for that in the written lease that Be Our Guest agreed to. If after 30 days notice, I think it's 5 days or maybe even 2 days, we'll see if it's a safety issue. But if after 30 days from notice that there is a base building, that's what we're going to refer to this as, base building concern. If the foundation is not in good and tenable repair, the tenant has the express right to perform whatever work they think they need to and seek a rent credit. That didn't happen here. And again, it's a little confusing because no one is here suggesting to you Be Our Guest needed to perform the full repair of this void. That's not what we're saying. What we are saying though, and you're going to hear a lot about this, you heard about the request for geotechnical reports and certifications of safety from engineers in the city. You're going to hear, first off, and some of you may know this if you're in the construction business, engineers and the city of Atlanta, they don't certify safety. They issue reports that always have limitations because we're not all knowing. Engineers can say the building is structurally sound for the foreseeable future. They will not say the building is safe. And certainly the city of Atlanta is not going to say the building is safe, no matter what they do. But again, you're going to hear all this plaintiff needed to go back to work and fulfill its obligations under the lease, i.e. to open and to begin paying rent was more information from a geotechnical engineer, a report saying that there was, that the condition was safe. Again, that's an impossibility, but that's what the requirement and the demand was. I'm gonna leave you with a question at the end. I've got more, but I'm gonna leave you with a question. Plaintiff had 2 geotechnical engineers on retainer. You've heard that. These geotechnical engineers were offering the plaintiff, be our guest, numerous options to explore the subsurface, to learn more, to either A, confirm that there is no further concern, or B, show that there is a concern and bring it to the Conservancy to address it. What the plaintiff is going to show you here, you're gonna hear the word possible a lot. It's possible that there are other voids for it. Well, it's possible that lightning could strike me down as I walk out of this courtroom today. Anything's possible. That's not enough. After the Conservancy and the city of Atlanta said that this void was repaired, to the extent the plaintiff had more concerns, they needed to show us those concerns, not say it's possible there are more sinkholes. And again, if they wanted to say that, why didn't they show us evidence? There were tons of things. They had proposals to do ground penetrating radar. They had proposals to do electromagnetic testing. You'll hear about this from the experts. They had proposals to do grout injection along the sewer line, much of which is not covered by this building. That's where you should start your investigation. Not putting holes every 5 feet in the floor of an operating building. You start where you just put a probe in the dirt outside. They never did that. We've asked the engineers, why didn't you ever do that? Wouldn't that be a good thing to do? Their answer is going to be our guest never asked us to. Be our guest never asked the Conservancy to do any of this destructive or non-destructive testing. Instead, they've demanded millions of dollars. So the rent commencement day was 300 days from the approval of the plans. We got a little ahead of ourselves. That puts us at October 2nd, 2018. There were discussions to extend this. You're going to hear there were issues early on. The Conservancy was working with Be Our Guest. So we're not pointing to that date, but at some point in time after this was repaired, we needed the tenant to go back to work and begin operating, or we needed to move on. Let's go to the next slide. So right out of the gate, January of 2018, there's a 6-month gap from the last slide negotiations in the summer of 2017. Presumably this is when the design work was done. The design work is done. Be Our Guest puts those plans out for bid, and the bids come in very high, obscenely high. Be Our Guest is telling this to the Conservancy. They're having trouble with permitting. That's costing more money. Their expediters are at their wits' end. April 2018, again, delays and cost overruns continue. Be Our Guest comes to the Conservancy and asks for concessions under the lease. They need help. The Conservancy is willing to help. Conservancy didn't have to. Conservancy said, I'm sorry you're having all these troubles, and I'm sorry the bids are high, and I'm sorry you're having trouble with permitting, but that's your responsibility under the lease. That's not what the Conservancy did. Conservancy was very willing and even had its lawyer draft up an amendment to the lease that provided additional rent abatement, provided extensions of the time in which operations were to commence and rent was to be paid. So project is over budget, project is behind schedule. Parties are trying to make it work as partners. 2 weeks into construction, the void is discovered. They're saw cutting the slab. to install plumbing. And as you can see here, the slab tilted into the ground like this. You've heard this described, or you will hear this described as a massive sinkhole. You just heard Mr. Halsey criticize the Conservancy for changing a reference in a report, and I'm going to get to that, from sinkhole to void. You're going to hear every engineer, and Mr. Halsey alluded to, you're going to hear every engineer here say, technically, this is not a sinkhole. A sinkhole forms, as Mr. Halsey said, naturally. The typical cause is in, for example, Northwest Georgia, you have limestone as instead of granite as bedrock. Over time, water and chemicals can erode that limestone such that there are natural chemicals. And that's how a sinkhole forms, is there is gravity, water, rain, and a place for earth to erode to. That's all we're talking about. Whether it's formed by a karst geology, which is what I just referred to, natural forming, or whether it's caused by an old 100-year-old city of Atlanta sewer pipe, really doesn't matter. What all the engineers agree is that in the city of Atlanta, we sit on granite. We don't have naturally occurring sinkholes in the city of Atlanta. So to call this a sinkhole, I'm not going to quibble with it. It's just wrong. And all the engineers will tell you that. So there's nothing nefarious about an engineer actually using the right terms in a final issued report. So sinkholes discovered. You're going to hear, you just heard Mr. Halsey tell you this is 12 feet deep when it's discovered. What Mr. Halsey showed you was a picture of probably 12, maybe more, of excavation that the city did after the sinkhole was discovered. When the sinkhole was discovered, you can see the cone, and you'll see some more pictures. Was this a concern? Absolutely. Did it need to be addressed? Absolutely. Is it 12 feet deep, as the plaintiff wants you to believe? Absolutely not. So, the saw cutting, you're going to hear these saws that cut into the slab are very loud, like jet engine loud. Not appropriate. You're also going to hear there is a kids camp that is run in the Conservancy Community Center called Enviro Ventures. And that's in the summer. We're in the summer here. You can't have someone saw cutting with a jet engine decibel level saw while kids are, right on the other side of the wall. So saw cutting's going on at night. It is the evening of, the clock is blocking, but it's the evening of July 11th, 2018. My understanding, about 10 o'clock at night, phone call is made to Mr. Norton, the contractor who you're going to hear from the subcontractor who's working. Slab just pivoted into a void under this building. We need to stop and figure this out. Luckily, no one was hurt. No equipment was lost. That, of course, is everyone's first concern when you have something like this. Was anybody hurt? Luckily, no. Next day, Mr. Banta is notified at noon. Within the hour, Mr. Banta has visited the site and he's offered to help. He asked to be updated after the contractor's soil engineer reviews this. Construction stops at this site, of course, but continues in the walker space. The walker space is probably 30 feet or more away from the Soulshine space. There is a community center function that the Conservancy uses in between. So you're going to hear from Piedmont Geotechnical. This is be our guest geotechnical engineer who was already part of this project. Again, some of you have some experience in construction. Anytime a contractor is digging foundations, doing anything in the soils that has to be filled, you'll hear about this concept of compaction. You want to make sure that the dirt is compacted such that it is firm and stable and appropriate to bear weight of a building that's put on. Geotechnical engineers are routinely on construction projects to perform what's called compaction testing. So Piedmont Geotechnical was there. They had staff at the site throughout this process, throughout construction And throughout the continued construction in the Walker space, it went on for 2 months after the void was discovered. Everyone thinks that this is caused by the city of Atlanta's underground infrastructure. The city of Atlanta, and this is well known, we have aging infrastructure in the city. The sewer at issue here is a combined sewer. What that means is it accepts stormwater, rain, and it also accepts sewage. When you turn on the sink in the building, it goes down the drain and comes out into the sewer. So 100+ years old, this is before precast concrete construction. This is literally built with slabs of granite and mortar. It's rectangular, about 4 feet tall, 4 feet wide. Mr. Norton agrees. Go to the next slide. So of course, we want to get the city involved. Everyone thinks this is caused by the city's asset. You heard about a dye test. Let me tell you a little bit more about that. A dye test is a test to determine if there is a connection, essentially, a pathway for water to flow. You saw the tilted slab we're going to get to after the city excavated all the way down to the top of the rock sewer. But the first thing the city did was go out, put a hose in the void location, put some dye in there, and look at the manhole downstream and see if you see colored water. The evidence is going to show that in July, there was a positive dye test. There was a connection between the void and the city sewer. You heard Mr. Halsey allude, the parties are working together at this point. There was discussion with our guest contractor in order for them to perform the excavation work. You heard about the shoring work. The shoring work is really just to make sure that as you excavate to go see what's going on down here, you can do it safely. That's what we're talking about. So we're working together towards that end. All of a sudden in September, BOG issues a stop work letter. You heard Mr. Halsey talk about a stop work order. To be clear, a stop work order is issued by the city saying stop work. That's not what happened here. The stop work order was issued by BR Desk to its contractor. The city, who had obvious knowledge, they're out there working on this. If they thought there was an unsafe condition, they had a duty to issue a stop work order. It never happened. So when work stops, again, we're 11 weeks into a 14-week build schedule. BR Guess is less than 10% complete on the Walker's construction schedule. There is no recommendation by any engineer that work be stopped. And there's no indication of any void or other issue in the Walker's restaurant space. How do I know that? Let's see what the Walker space looked like at the time work was stopped. The slab was removed. There's a little bit of it left, but that's all dirt. These are not great pictures. Sorry, they're snipped from a report that you'll see. If BR Guest wanted to do some probing to determine if there were additional sinkholes or safety issues in Walker's, I think they could have done it. Of course. They never asked to, they never did. They had care, custody, and control of this site, their leased property, throughout this entire period. Again, if you want to know something about the subsurface, do you think you need to start putting holes in your other tenant's restaurant? No, you start here. Never done. So in September, after BR Guest stopped work in the Walker space, BR Guest said, if you give us an engineer's report that says it's structurally sound and construction continues, we'll go back to work. So what does the Conservancy do? They bring in Palmer Engineering. They chose Palmer because they had plans from a renovation back in 2000, 2001. Palmer was the engineer of record. Palmer was the structural engineer. Palmer understands the structure and the loading and how this building is supported. So it made sense to bring them in, right? So, Mr. Hagberg comes out. He evaluates, he agrees, we need to figure out what's going on with this void. But based on my professional experience, there is no reason that work cannot continue in Walker's. And there is no concern with the structural integrity of this building. Boom, puts his engineer stamp on that. That means something. When an engineer stamps a report, it means you can rely on it. And if they're wrong, there's lots of liability for that. So Be Our Guest does not go back to work. The city's contractor, Ruby Collins, you're going to hear from a representative of Ruby Collins in this case. They're on site in September to repair the void. You see the man hunched over in the void site. This is obviously the first thing they did was remove the slab. Unless that man's 24 feet tall, I'd submit to you, ladies and gentlemen, this is not 12 feet deep. I saw it with my own eyes. I stood in it. It's about 3 feet deep. Next. So here we are after excavation's begun. What they're doing is they're excavating down. Picture Mr. Halsey showed you was at the conclusion or near the conclusion of that process. What they're trying to do is go down. We know the city's 100-year-old sewer is 16 feet underneath this location. So we want to go down and see what's going on. Everyone thought we'd find some obvious repair or some obvious defect or structural collapse in the sewer. That's not what we found. The city, despite the positive dye test, in September, they said the investigation we did not indicate it was our asset. They didn't say it wasn't their asset that caused this. No one can say that. This void could have formed before anyone on this jury was born and just been sitting there. All the experts agree with that. It could have been repaired years ago through all of the work the city of Atlanta has done in its sewer system around Piedmont Park. There's interior lining work that's been done. There's interior grouting that's been done over the years. You're going to hear, this is gross, but it's true. 30 years ago, every time it rained an inch, every time it rained an inch, Piedmont Park was covered with 200 plus Olympic-sized pools of sewage. That's been fixed. That doesn't happen anymore. There's been a lot of work done inside these sewers. This void could have been sitting there since, again, before we were born. And if that's the case, we have to identify the definitive cause before Be Our Guest will go back to work. That's called an impossible condition. Next. So about this time, Be Our Guest asked for a meeting. They're not concerned with safety. They're concerned with money. There are problems with the grease trap, problems with roof trusses, plumbing issues. We've got corn backing up into their sewer exit pipe. Presumably what we think is that their contractor plugged into the wrong pipe, plugged into Willie's sewer pipe. And so we've got salsa coming down. Mold. I put mold in quotes. You're going to see some pictures of this. One, if there was mold, it was for the tenant to deal with. Two, what they view as mold, they never did any testing, was immediately behind some water pipes that had been soldered. We believe it's simply burn marks from the torch that was used to connect the metal piping. Be Our Guest tells the Conservancy these are 6-figure issues, and the Conservancy needs to get out the checkbook. So, September 28th, 2018, Mr. Bantham notifies Be Our Guest that the repair is complete. Now, This is not somebody just backed up a cement truck and poured in some cement and said, we're good. This was an engineered cellular flowable grout. You're going to hear from an expert in this case who's going to tell you that this is a routine way of fixing sinkholes. It has a consistency that is almost like a milkshake, maybe a little bit thinner. And the whole point is it goes in and it flows and it fills. And whatever the source of the sinkhole is, whether it's a small abrasion in the sewer, whether it's a small abrasion somewhere else, it stops the mechanism of flow. It plugs it. You're going to hear all about we have to know the definitive cause. Otherwise, we don't know if it's fixed. That's not true. You're going to hear from a geologist who identifies, investigates, and repairs sinkholes for a living. He's going to tell you, no, that's nonsense. That's in a perfect world, of course. You'd like to know exactly what caused it and fix it. But that's why you have products like this flowable film. What we know definitively is this was caused by something man-made. We know that there was a cavity somewhere that accepted sediment as rainwater flowed. And you're going to hear reference to a throat. The throat is where the sediment is flowing into whatever area will accept it. All you need to do is block that throat, plug it, and arrest the mechanism. And that's what was done here. You know, you think about it. You go out, you've got this slurry material, it flows like water. If you can't fix whatever is causing this pathway, this doesn't fill up. You call another truck in because all your grout has disappeared. And if you keep doing that, eventually you might need to do more. The mere fact that this flowable fill engineered mix approved by the city of Atlanta, installed by the city of Atlanta's contractor, city of Atlanta's approval, all you have to know is it was able to set up and cure. By definition, it has arrested the flow. October, again, be our guest looking to set up a meeting to review the list of outstanding items we have regarding this project before we will put shovel to dirt again. Again, it's not, we need insurance that this site is safe. We need money. PPC, you'll hear me call the Conservancy PPC sometimes. We were never shrugging our responsibility. To the extent the project was delayed because of issues with this void, we were willing to give schedule relief. We were willing to give financial relief. You're going to see the Conservancy was willing to pay for all of the engineering, was willing to pay for the repair. Didn't end up needing to. Who paid for the repair? To the tune of about $80,000, City of Atlanta. So at this meeting, be our guest. Again, we're sitting at the community center. Meeting is at the site. Be our guest strolls in to this nonprofit's building and says, we want you to put $2 million in escrow in order for us to go back to work. Not a word uttered about safety. A real estate lawyer who wrote the lease was at this meeting, wrote the lease for the Conservancy. And after hearing the litany of demands for money and $2 million for Be Our Guest to correct all of their alleged deficiencies in this building that have nothing to do with the board, he says, have you read your lease? That was the tipping point. Ms. Drolette at that meeting slams her notebook down, points at Mr. Banta, and says, we'll fix it. storms out of the meeting. I call this a pivotal meeting because it was a pivot in time. Now is when this becomes a safety issue. Now is when Be Our Guest is hiring PR professionals to tell their story far and wide to try and coerce the Conservancy to pay them off. So Be Our Guest appropriately was asking for information about what the city did. They were asking for reports. The Conservancy was saying, we're going to give you whatever we get. The city issues a memorandum, and I've quoted it. To repair the void, full stop. To repair the void, the contractor backfilled the sinkhole utilizing a cellular grout to fill the excavation and stabilize the surrounding soils and subsurface conditions. All experts agree with what I just told you about this flowable fill. A lot of what's wrong or what went off in this case, and I feel bad about it, it's Be Our Guest's failure to understand and speak the language of engineers and understand the limitations of what a structural geotechnical engineer is willing to say. Engineers don't say, I guarantee this building will be safe in perpetuity. They can't do that. They can look at what the conditions are and they can use their professional judgment. They've all done that. All of their professional judgment is this was caused by the sewer at some point in time. The next day, after getting the city's memo, Be Our Guest rejects it immediately. At this point in time, they have proposals from their geotechnical engineers to go out and do non-destructive testing. You heard Mr. Holsey say numerous times, Be Our Guest wanted to go back to work. Well, if Be Our Guest wanted to go back to work, why didn't they do a single thing with the geotechnical engineers they had on retainer who was telling them, here are all these things we can do? You're going to hear all these engineers say, yes, we wanted to do this. Why didn't you do it? No one asked us to. These are not big, expensive, high dollar things. Be Our Guest had a proposal to do ground penetrating radar throughout the site for $4,500. Never asked to do it. Never asked the Conservancy to do it. Instead, it spent 10 grand on a PR firm setting up media opportunities. Again, no engineering investigation, report, documentation of any kind saying that the city and its contractors' repair was inadequate. By the way, the city's contractor, Ruby Collins, you're going to hear from, they have an annual contract with the city of Atlanta. What that means is they have a base contract and the city issues them task orders to go out and fix things like this. You're going to hear Ruby Collins say, well, how often do you get one of those task orders? Daily. This is routine. Ruby Collins is out fixing subsidence, loss of ground, voids caused by the city of Atlanta's aging infrastructure every single day. Again, the Conservancy does request Be Our Guest go back to work. They had an obligation to be paying rent. They had an obligation to be operating. Mr. Banto's getting questions from his board. Why is this taking so long, Mark? Why aren't these people out there working? This building's been sitting here forever. And Mark is again, he's the cheerleader for Be Our Guest. He's saying, let's give them more time. Let's give them more time. Let's give them more money. We want to make this work. So again, following the repair by the city, Mr. Hagberg again confirms the structural soundness of the community center. Mr. Hagberg, who you'll hear from, understands cellular flowable grout and how that stabilizes soil, just like the city's memorandum says. Based upon that stability, the foundations in question, the community center is structurally sound. I I think it's important here too, because you heard Mr. Halsey spend time on these two engineering reports. They call them Hagberg 1 and Hagberg 2. And in their mind, I think they do believe this. In their mind, these reports were prepared for Be Our Guest. That's not true. That's not what happened. What happened was Be Our Guest was told no. We're going to help you with the void issues. We're not going to write you a check for $2 million for all of these issues you're responsible for under the lease. Mr. Ouellette goes on camera and says, this is unsafe. The Conservancy is putting people's lives at danger. The Conservancy is putting children at danger. And, you know, you need to contact the Conservancy and tell them they need to make this right. It became a safety issue only after they were told no. So people see things on the news, they hear, you know, this about their organization, and board members start saying, what's going on? What is Be Our Guest talking about? Is there a concern with this building? So Mr. Hagberg's November report is done at the request of the Conservancy's board. And what did the board want to know? The board wanted to know, and the board at this time is trying to make a decision. The time that Be Our Guest is in default under the lease has long passed. The board is asking itself, do we want to continue with this tenant? Do we want to continue attempting to convince them that this repair is adequate? Or do we want to cut bait and go with somebody else? Ultimately, and so it's natural, the board wanted to know, Mr. Hagberg, what are some things we could do? Give us a menu of things we could do if we want to convince Be Our Guest that there's no reason not to go back to work. That's what Mr. Hagberg did. This was an iterative process. You're going to see my name on emails. I was involved in this process. The board was presented the first draft of the report. You're going to hear Mr. Hagberg say he was an error in saying the first report was final. It was a mistake. You're going to hear that the board was presented with the first version of the report that talked about some geotechnical work, that talked about putting some holes in the floor. You're going to hear the board says, no, we don't want to do that. What can we do without disturbing Willie's? What can we do without disturbing our camp operation with putting holes through the concrete slab every 5 feet? Let's talk about something non-destructive. As the board ruled out things it didn't want to do, the report was revised consistent with the board's reasonable decisions. This report was not created for Be Our Guest. Be Our Guest only got this report after one of its lawyers, who I happen to know, called me and said, Jason, I hear there's some second report. Would you mind sending it to me? So I sent it to him. There's no conspiracy. There's no cover up here. There's a shakedown. That's what this is. So again, the PR firm activity continues. They're looking at advertising, targeted advertising. So when you open up your Facebook page, you're told to call the Conservancy and tell your friends and neighbors that they're doing wrong. Let's move on. Mr. Ballard, the geotechnical engineer working for Be Our Guest, receives the Hagberg report. What does he say? Well, you were waiting on a go back to work letter. I think you have it. You're going to hear Mr. Ballard say, this was the best Be Our Guest was ever going to get. No geotechnical engineer, no structural engineer, City of Atlanta, no one is going to ensure and guarantee safety. That's just not how engineering works. Engineers don't do that. So I've alluded to, don't want to harp on it. Again, more recommendations for non-destructive testing. You heard reference to the second engineer that Be Our Guest brought in, purportedly in hopes of that engineer saying everything's okay, you can go back to work. That is not what that engineer did. What that engineer did is say, here's a proposal for some more testing we could do. That was never provided to the Conservancy. The Conservancy was never requested by DRGS to do any of that testing. You're gonna hear that that second engineer wanted to inject grout to determine if there were areas that would accept the grout. And you're gonna hear him, he corrected me at his deposition when I said this was to identify potential additional voids. He said, wait a minute, yes, but it was also to ensure they were repaired by injecting grout. He didn't say anything about the cause being unknown. So ultimately, 6 months has passed since BR Guest had promised in its lease to be paying rent, to be operating. It was very clear to the board of the Conservancy, there was nothing we could do. There was no amount of scientific proof. There was no amount of engineering that was going to get BR Guest back to work. The choice was write a multi-million-dollar check or exercise our termination for default rights under the lease. We chose the latter. You've heard about attorney's fees in this case. We believe that the plaintiff's failure to take any self-help actions authorized under the lease and instead going on camera and alleging a safety issue, we believe that's bad faith. We believe the Conservancy had no choice but to defend itself in this litigation for years. And this litigation has been extensive. So the Conservancy is also asking for attorney's fees. We're asking for it for bad faith, but we're also asking for it under the contract. Because we have a right to attorney's fees if you find that BR Guest breached this contract. So again, it continues. Over the course of summer 2019, more than $15,000 on a PR firm. BR Guest is creating Facebook groups to campaign against the Conservancy, a website to promote its narrative. This is a vendetta. And inflammatory informational packages are delivered to the homes of every board member on the Conservancy, telling BR Guest's side of the story under the premise that the board doesn't already know what's going on. Mr. Banta is this rogue CEO who is not conferring with his board. So after summer 2019, we do terminate the lease. We hire another construction company to come in and essentially clean up a mess. You saw what the site looked like, how BR Guest left it. We needed to hire somebody to get it cleaned up, to put in a leasable space again. That's Gay Construction. The Conservancy paid them a little under $100,000 to do that. That's also a claim of the Conservancy's in this case. Willie's chomping at the bit to get into the very space that BR Guest contends is a safety issue. They have their engineers look at this. They look at the very same materials that was presented to BR Guest. They build out. They're operating today. City of Atlanta doesn't condemn, doesn't issue a stop work order. They issue a building permit and a certificate of occupancy. Willie's is successfully operating, probably getting ready for lunch right now. Same with Shake Shack. Shake Shack, sophisticated organization. They want to understand. Everybody knows about the sinkhole. Sinkhole void, again, it's not important. Everybody knows about this. Shake Shack has its engineers look at this. Same information. You're going to see evidence they did a ground penetrating radar survey. No concerns. They're in operating after their building permit, certificate of occupancy granted by the City of Atlanta, who knows all about this, who repaired it. To the present day, you're going to hear last ditch efforts. And this is just to show that BR Guest was not going to back down. I agree with that. They filed an emergency petition in this court in September of 2023, 5 years after this was repaired, 5 years after park patrons People coming to the restaurants, Willie's and Shake Shack, no problems, no evidence whatsoever. The Conservancy monitor building, of course, that's what you would want to do. You don't tear a building down because there might be a problem. You watch, you see if there's any evidence. Are there cracks? Are there areas that are sagging? Are there other sinkholes opening up out in the yard? We're watching. There's no evidence of that. But the PR firm says, hey, the media is looking for content leading to Music Midtown. This is our opportunity to pitch our story again. Ask the Conservancy for more money. So that's where we are. I mentioned to you, ladies and gentlemen, I get to go second. I don't get to call my witnesses first. I get to ask some questions of be our guest witnesses. But I'm asking you, wait and hear the whole side of the story. Don't prejudge this. As you're listening to the evidence come in, these are the three things I want you to keep in mind. I want you to ask yourself why, to this day, has Be Our Guest never requested access for its engineers to conduct any further investigation BOG wants. We've been in litigation. This case was filed in 2020. If Be Our Guest wanted to go onto this property and do investigation, destructive or non-destructive, had a right to do so under Georgia law. Had a right to ask Judge McAfee to order it. Did it do that? No. Why did BOG's experts completely ignore evidence in their files of a positive dye test in July? That tells you what caused this. And again, before asking you all to award it millions of dollars for 20 years of operation and work it didn't do, why didn't they make any effort to find new spaces for these two restaurants? There's no shortage of restaurant spaces in Midtown. Why didn't it do that? That's what I leave you with. Thank you, ladies and gentlemen. Look forward to working with you.
All right. By show of hands, any members of the jury want to take a break before hearing the first witness? Seeing none.
I would like to take a break, Your Honor.
All right. Then I'll say let's take a quick 5 and let us know when the jury's ready to proceed.
All right, for the jury.
Charles, you can go ahead and step out.
Thank you.
And if plaintiff could also go ahead and just bring in their witness and have them on the stand ready to go.
Yeah, I am too. I'm Scott.
Oh, okay, cool.
Is this being streamed?
Not sure it's going back to. Yes.
Let me get a minute. I'll be right back. I'm not taking forever.
You shall see.
It's been a long 6 more days. That's the case. So. Exactly. It's not in the middle. So it's. I'm going.
You too.
So where have the defense lawyers camped out? Hi, I'm Joe King. Frederick said.
Joe, I don't know if you remember, we had a case, I had a
Right.
case against you in
10 years.
2014.
Right.
I thought I recognized you. I was like, no, I'm Brett Mason. Yeah, we had a
Yes,
case a year
yes.
ago. Yeah, so this is where we are. We're on this side here.
Or
Good to
read
see you.
something else then, but.
It's Harvard, yes,
Right,
yeah.
right.
Yeah, so that's so funny. I thought I recognized you, and now it's so funny because just hearing you talk and how you're talking, you sound like something.
I had
You're
more
the same.
hair back then.
This is Frederick's dad.
Hey, I'm Joe King. How are you?
Which I recognized him when he came in because we had a case. Latest attorney, and so that's when I was representing hospitals, so he's just,
Who won?
check it out.
Well,
I think we settled. I'm imagining we settled.
yes,
Yeah.
we did. We worked the trial together,
Yeah.
so we would have
It
settled.
wasn't one of the really complicated medical ones. I think this was more of a slip and fall on the hospital premises, if I remember correctly, but yeah.
Right.
Good to see you.
We're gonna get Frederick to go here.
Yeah,
What?
Frederick.
Get Frederick to go.
That's
Yeah.
right.
Okay, and that's what I stopped by to see. You've got him hidden away someplace.
Well, he's come over at lunch, because he's just getting some more documents and things figured out.
It may be.
I don't know if we'll get to his witness today. We'll see.
Oh.
It looks like he's number 3 on.
Are they
their list.
broadcasting this thing?
They are. Well, so the court now live streams, all of their trials on YouTube.
Oh,
So that's what's happening here and.
good opening statement. I
Yeah.
understood the case after you finished, and so
Thank
I'm
you.
ready to deliberate right now. I'll let you guys get back to work.
Thanks, Joe. Thanks for
And
sitting
since Frederick's not in the building, I am probably going to leave you guys alone and try and find this thing on the
Yeah,
live stream someplace.
I think this, where's the best way we can direct people to watch the live stream?
It's streaming on YouTube right now.
Which we just search Judge Mackey's courtroom?
YouTube.
What is it?
Okay.
Oh, okay.
Alright.
Another way to find it is through the court website. You can go to live proceedings and you can find Judge
Oh,
Mackey's
okay,
website on
good
there.
enough. Thanks a lot.
Alright. Thanks, Joe.
Good seeing
You
you.
too.
I'm worth it.
Yeah, this is
Good
Alex.
to see you.
Yeah.
Good to meet you.
Yeah, it's fun.
Oh,
Well, it's good.
good to see
You,
you.
you're probably watching live stream. You won't make arguments.
I don't think I make perfect.
Okay, I just told Frederick.
Oh, yeah. All right.
Yeah,
See you later.
bye-bye.
I'm gonna say hi. Sometimes I advance the slide picture. Oh.
Thought they went the wrong way.
I will, yeah. Because I was watching here. And the mouse and the click is on this area, but they're not doing it. It just looks a little bit on there.
Deputy Scott, are you checking on?
So.
Right.
Dr. Jerry. Like I said, it's here, stand up. Yeah, yeah.
Thank you, Deputy Scott. We're back on the record. The jury is present. Plaintiff may call their first witness.
Thank you, Your Honor. We call John Norton to the stand.
Please state.
John Norton, Norton.
Mr. Norton, obviously said your name. Could you introduce yourself to the jury, tell them what you do?
Sure. I'm a general contractor. I was the contractor for the project for both the Walkers and the Soul Shine space.
And how old are you, sir?
I'm 50.
And how long have you been a general contractor or in the construction business?
Since I got out of college, so 25 years.
And what is the company that you work for?
Norton Contractors.
And at the time in question of this case, who were you working for?
I was working for J.M. Williams Norton.
And are there particular industries in which J.M. Williams works?
We do a lot of high-end restaurants and self-storage and automotive facilities.
You said you've been doing this job or type of job since college. Where did you go to college? Did you get a degree that was specific to this industry?
I went first 2 years at University of Hawaii, and then I've got my undergraduate degree from Georgia Southern in economics. I have a master's in business administration from Kennesaw, and I have a PhD in the School of Hard Knocks.
And have you sort of worked your way through the ranks in construction?
Yes, sir.
And where did you start? And then tell us a little more about when you became a general contractor, what that entails.
Sure. So I started, even before college, I just worked in construction throughout my life, hanging gutters, painting, putting on trim, that kind of thing. Didn't pursue construction in college, but construction kind of has a way of pulling you back. So in college, right out of college, I worked for a general contractor, Hardin Construction. We were building high rises here in Atlanta. Worked there for 2, maybe 3 years. Then I worked for CB Summer Construction. That's where I learned the restaurant construction. We did a lot of restaurants, the Mo's, if you're familiar with those kind of projects. We did a lot of fast casual kind of restaurants, some medical, some office building. And then J.M. Williams, we did all kind of sorts of projects from self-storage, again, restaurants, car dealerships, that kind of thing.
And you said you're now a general contractor. Can you explain what that job entails?
Sure, we manage the project, so we're construction managers. So we hire subcontractors, we work with architects, engineers and owners to build a project. That's from lease negotiations all the way to, final clean of the project and turning the project over. Construction, shop drawings, engineers, RFIs. That's RFIs, a request for information, if you're not familiar with that. Just managing the project in general. Pay apps, all that.
Came into the project with our client be our guest. At that point, you were working as a general contractor,
Yes, sir.
and you've been in that role on other projects before.
Yes, sir.
Can you estimate how many such projects?
Maybe 300, 350.
And how much of that was restaurant specific?
Probably 250 out of 350, maybe.
Is there a lot of things that go with restaurant construction that makes it different from other types of construction?
There's a lot of vendors. For example, you have Coke and you have CO2, carbon dioxide for your Coke. You have chemical sanitation for sanitizing, your cookware. You've got point of sale systems for ringing up, orders or drink orders, those kind of things. That all has to be coordinated. And if you're not familiar with just building a project, if you're not familiar with doing that, there's a lot of hiccups that can really trip you up, because there's a lot of clearances that you have to be concerned with, health code regulations that you have to be concerned with. It's a little more than just standard building a building.
How did you specifically get brought into this project? Did you already know Mr. Ouellette or Mr. Dooley, or was it something else?
I believe we were originally contacted through our bank. They had this, I guess, Be Our Guest had the same bank that we were using, just for our everyday checking account with the business. And that's how we got introduced to the project.
Was that like the capital?
That was.
And what was your understanding of the scope of the project when you started it?
Well, it was two restaurants. So you're building Walker's, which kind of had an outdoor kind of atrium facility. Soulshine was more like a panini kind of project. So Soulshine was interior, Walker's was interior, and then we were also building a structure outside for dining.
And I would like to approach the witness, Your Honor. I'm going to show you a couple of exhibits. And these exhibits have already been provided to counsel before today for counsel's awareness. These are actually your exhibits 120 and 121. I know these have been provided to the court as well. If I may approach, Your Honor.
You may, and no need to ask for permission if it's your witness.
You'll take a look at both of those and tell me if you're able to recognize those exhibits, sir.
I am.
How is it that you're able to recognize those?
Just being familiar with the project.
What is it that you're looking at?
I'm looking at the Soulshine space.
Before we show it to the jury, just tell us. what
Okay.
you're looking at.
I'm looking at Soulshine space and the Walker space without the exterior work. So this is the base building that we started construction in.
A fair and accurate diagram of the site that you were asked to work on.
Yes, sir.
And then can you look at the other one I handed you as well? Number 121.
Mm-hmm.
And what is that, sir?
That's just an overall of the building. That's basically from a bird's eye view looking down the top of the building. Just shows the outline of the building.
Representation of the diagram of that building.
It is.
Your Honor, we tender into evidence, actually defendants 120 and 121.
Objections.
And just going forward, should we retain the label that this is a defendant's exhibit, even though the plaintiff's introducing it? Is there any preference there?
think we should keep the labeling as
Okay.
is. We may introduce a plaintiff's exhibit and we'll refer to it.
All right, fair enough. All right, without objection, defendants 120, 121 is admitted.
We would ask to have those published to the jury, Your Honor.
All right, you may.
Let's start with 120, please. And it's going to pop up, well, I guess on the screen. So, sir. So what is this we're looking at?
This is the Walker's space here. And the space A is the Solshine space. And this is, you're looking at kind of a top view of the building, not the entire building. It's just showing a section of the building. But if you're looking down on the space, the Solshine would be space A and the Walkers would be space C here.
Within that diagram alone, I know you said it doesn't reflect the entirety of the building, but just within the part we are looking at, there are spaces other than Walkers and Solshines?
That is correct.
And what do you recall as you sit here today, what some of those other spaces were?
I believe this space here, that's not labeled down here in the bottom left corner, was Willie's Mexican Grill. There was educational facilities back in the back. So the Piedmont Conservancy had classrooms back here in the back for kids, not daycare, but some kind of camp that they put on.
Right. And then looking at this diagram, where was it that the sinkhole opened?
It was right here at space A, pretty much where the big A is. That's almost exactly where the sinkhole was.
Can we bring up Defendant's Exhibit 121, please? Okay, can we also blow that up, please? So what are we looking at here, Mr. Norton?
So this is the Walker space here. So that kitchen is kind of, that area was right here. It's the Walker side. The Solshine space is right here, comes in. So the sinkhole would have been right about where this ridge line is in the building.
This is showing the entirety of the community center, sir?
Yes, sir.
Can you orient us from here? Where would Piedmont Park be and where would the streets be?
So Piedmont Park is here and the road is just outside of here.
Thank you, sir. So, do you recall getting started on this project back in June, I guess, June of 2018? Does that sound about right?
Sounds about right.
All right, and what did it entail to get started? What all happened, let's say, over the following month?
So the first thing that we did in both spaces was demo the spaces. The Walker space was an existing restaurant. I don't recall what that was. The tenant had already moved out. And then the Solshine space was kind of like a small ballroom. So, but we had to demo both of those spaces out.
What does that mean to demo a space out?
If there's any interior walls, you're taking those down. Any electrical that's there in those walls, you're safing those up. You're removing the sheetrock from the studs. Any plumbing, you're capping that off, maybe tearing the ceiling out. It varies from project to project.
To undertake this sort of work, how many folks do you have on the scene?
We had two superintendents. One was full-time, one was kind of part-time, jumping between this project and maybe another one. And then we would have a number of subcontractors. So we would have electricians, plumbers, HVAC, fire sprinkler, concrete guys, plumbers. I mean, everybody.
Is the scene such that you have to block it off from other people making entry? Is it visible to any passerby that this is being worked on?
We had both areas fenced off. Construction is inherently dangerous. And so we wanted to keep the public away from that, so that a kid couldn't get in there and get hurt. We had a fenced area kind of around here, around the Walkers and then around the Solshine space.
Now, you've already referenced a place where there was a sinkhole, so let's go ahead and move to that.
Okay.
So you said you did discover a sinkhole. Tell us a little bit about how that got discovered in this case.
Sure. So we were having to saw cut the slab at night. There was, and this building is unusual. There are two slabs inside this space. I don't know if we've covered that yet, but we saw cut, after we completed the demo, we saw cut the slab. And that's how you get the plumbing in the ground.
Just to take nothing for granted, we do have some construction people on here, but
Okay.
folks that are not, and myself not being construction person, what is a slab?
Sure, it's the concrete floor.
Okay. It's cutting through a concrete floor.
We're cutting through concrete floor. So, on or about the 1st of July, give or take, we saw cut the slab. And then we pulled the slab, which means you pull you cut a trench basically in the slab and you're pulling that concrete out to get your plumbing lines in. Well, what we discovered, after doing that is that there's another slab about 6 inches below the bottom of the first slab, give or take. That's unusual. In my career, I've never had that happen before. So
Falls on that point. Why is that unusual? And yeah.
you just don't find somebody that pours a slab on top of another, concrete slab. It's just not done. It's kind of a waste of money. Why would you do that? I don't know. So at that point, we had to bring in a specialty contractor with a much larger saw to cut down like 14 to 16 inches to get the second slab, because we already had all these trenches open. So we had to have a specialty contractor come in there, cut the slab with a specialty saw, and we were doing that work at night because it is extremely loud. We did have the city of Atlanta put some noise restrictions on us, like we couldn't work after 10 p.m. So it was from like 6 to 10 we were working. Anyway, about 9 o'clock at night, we cut a square in the concrete, and the concrete literally just fell into a void underneath the building.
I am going to show Mr. Norton, plaintiffs 85. So if you can take a look at those photos, please.
Okay,
And do you recognize those photos?
I do.
Can you tell the jury how you're able to recognize those photos?
I believe I took those photos. It's pictures of the sinkhole in the building and the slabs.
Fair and accurate representation of the sinkhole as you saw it when you photographed.
Yes, sir.
Your Honor, I'll tender for admission into evidence, plaintiffs 85.
Objection.
Admitted.
We'll ask the publicities to the jury. So let's start with the first photo, please. And can you tell us here what we're looking at, Mr. Norton?
Well, this is after the fix, if you will. This is the grout that they, and I say they, the Piedmont Conservancy, their contractor poured into the hole, the void.
Give me just a moment. We'll try to keep this sequential. So let's move to the first picture that doesn't have the grout, and we'll be coming back to that later. But if you go to the first picture, it doesn't involve that. Are you able to recognize this photo?
I am.
What is this?
This is a picture of, it's sideways, obviously, but it's a picture of the sinkhole. So this is the slab that you're looking at here. This is the void. So it's dropped down the back, it's tilted on like a 45-degree angle. So the back of the slab has fallen into the hole. It's probably 8 feet deep at the depth on this end here, and it comes up, and you'll see in some other pictures where it's sticking out of the slab in the other direction.
What was sort of the dimensions from the, not the depth, but the width and length of the hole?
It was, I think the hole was roughly, that we cut was roughly 10 by 10, or maybe it was 12 by 12, something like that.
What is this we're looking at here, sir?
We had, so you're looking at the edge of the sinkhole, which is right here. This little corner here, if you guys can see that. And then we had this stick in there measuring how deep the hole was on this end. And we were kind of tracking the erosion by this stick. Well,
Recall approximately how deep it was, at least at that spot?
I want to say it was roughly 10 feet deep.
Next photo. While we're moving to the next photo, did the sinkhole end up having different sort of depths in it? Like in other words, some parts were more shallow, some deeper?
We really couldn't tell. This is this side here, which would be the west side. So here's the entrance. If you guys see the light up here, that's the entrance as you walked in off Piedmont Park. And so this would be the west side. This is the only area that we could really see. And you really couldn't see. We could kind of stick a 2x4 down there just to see how deep it was. But we couldn't see on this side because obviously the concrete is blocking our view at that location.
Let's move to the next picture. Here.
So here again, you're looking kind of down at the hole. He's standing on the north side of the sinkhole. There's that 2x4 again. You're kind of seeing the void, you know, down on the west side of the sinkhole.
That's it. Let's see, it looks. And what, okay, there, sorry, there was one I guess we want to take a look at. I think you went past it. That's what, I thought there was a different shot of it. I guess from the, just a different angle here, sir.
Yeah, so I'm on the one side looking at the back side of the sinkhole again. And here again, you know, the slab, you're looking at the slab, it's difficult to tell, but it's kind of at maybe a 35 to 45 degree angle sitting in the hole like this, if you will.
I noticed you took quite a number of photos. Why did you do that?
Well, this is not something that you commonly run into. This is, we wanted to document it in case we ever got to this point. So we had, we took a number of photos to not only show our engineers, insurance companies, just let everybody know what we discovered.
So did you make the parties aware of the sinkhole after it was discovered?
We did. And the other issue here I want to point out is that the columns for the building, there's a column in this wall here. This is a wall coming up this direction. So you have a slab in the wall. So the columns for the building were here, and on the other side of this, kind of where this cursor is, maybe. And so we were concerned about safety as well, that the building might collapse.
Elaborate on that. How, first of all, do you recall approximately how close the columns were to the sinkhole?
Pretty close. I mean, within 5 feet maybe. And I think on your other exhibit shows where the columns are. That'd be your exhibit 120.
Let's go back to 120.
So this little square, you guys can see this. This is a column, and this is a column for the building. And above this is all the rooftop units, not rooftop units being HVAC units. They're not like at your house, but typically they're large units up on a roof. They sit in this there's a little courtyard up on the roof here, and all this weight, and those units are very heavy, probably I'm speculating, but probably a couple tons worth of weight sit here. And with this sinkhole being here, we were concerned that we would undermine the footings, or it would undermine the footings of these columns, and the building had the potential of collapsing.
Your Honor, I'm going to object to this witness providing any testimony about a potential collapse of the building. This is not an expert witness. Mr. Norton is not an engineer, and Mr. Norton has no understanding of how the structural loads of this building are dispersed.
All right. And Mr. McCleary, for a more extended objection, just ask to approach next time. Mr. Halsey, do you need to respond to that? Well, I mean, the testimony is already out, so to the extent it's kind of a moot objection, I would say. We'll move on, but unless you've got further testimony on this point.
I don't know if we have further testimony on this.
All right. Then you can ask your next question.
So we talked about alerting the parties. Do you remember if you did that, how you did that, how soon you did that?
I think this happened, the discovery of the sinkhole happened at, I don't know, 10 o'clock at night, if you will. And the next morning, I sent out an email to the tenant, to Mark Banta, probably my boss. I probably copied everybody that what we discovered. That was the very next morning.
And do you see him here in court today?
It's been a long time since I've seen him, so there he is right there. Yes, sir.
All right. The record will so reflect.
Let's talk about, look at exhibit, plaintiff's exhibit 21, please. Don't hold up quite yet. I need that first to show. I'll show you plaintiff's exhibit 21. Actually, take a look at that, sir. Sir, do you recognize that exhibit?
I do.
And tell me how you recognize it.
It was an email I sent on July 12th at 2018.
And that was the day after you discovered the sinkhole.
Yes, sir.
And who is this directed to?
To Mark Banta and Mark Niels, who was, or Nielsen, I'm sorry, Mark Nielsen, who was the kind of the liaison, the construction liaison that we were dealing with on parking issues and where to set dumpsters and that kind of thing there it's on site.
And is that a fair and accurate representation of the communication that you directed to Mr. Banta?
It is.
We would have to enter into evidence plaintiff's exhibit 21.
Objection.
21 is admitted.
So let's put this up on the screen, sir. And maybe just a little bit bigger, please. And what is it that you wanted to convey in this email to Mr. Banta?
Well, that we had uncovered an anomaly is basically, put everybody on notice so that we could, come up with a potential repair. And what are we gonna, what's the next step, if you will? What do we do from here?
So with that, what did happen next?
Well, over the series of next week to 2 weeks, we had a number of engineers, our insurance company, architects, all come out and look at the slab and the issues that we had found, and write up reports and what's the next steps, how are you gonna fix this?
That process, were you working with our client, Ms. Drillette?
Yes,
Through that process, were you working with the Conservancy's representative, Mr. Banta?
yes,
Was this, at least at this point, sort of a cooperative effort?
it was.
Were you providing these sort of reports, including engineers report to all parties here?
I was.
Were you giving guidance as to how to move forward?
Well, I don't give guidance on how to move forward. Really, we're not engineers, but we say, hey, we need to get an engineer in here. We need to get structural engineer, soils engineer. We need to come up with a game plan. They provide the prescription, if you will, and I just follow it.
And let's just talk briefly. You've mentioned two kinds of engineers, a structural and geotechnical engineer or soils engineer.
Right.
What is the difference?
Structural engineer, his domain is from the bottom of the footing to the top of the structure. And then you have a soils engineer that goes from the bottom of the footer down to whatever's below us. And so they have to work in conjunction because the structural engineer, he'll say that, you know, in order to build this building, we assume that the dirt will hold X, 2,500 pounds per square inch, if you will, or whatever. They have some kind of prescription there. And so the soils engineer says, when we dig a footing, for an example, they'll come and they'll probe the dirt and say, yes, you can, this dirt will support the load that the structural engineer is counting on, or no, it won't, and here's what we need to do to fix it.
Even absent a sinkhole, it is common to have both sorts of engineers providing advice on how to move forward with the structure.
Yes.
And who were the engineers you had on site helping you, the structural engineer and the geotechnical engineer?
The M2 was the structural engineer for the tenant. They're the ones that designed the Walker's kind of atrium, if you will, dining room. And then we had geotechnical, I believe. I'm sorry, Piedmont Geo. They've changed names a couple times, but they were doing soil borings or soil tests for us.
And first about this, do you recall the structural engineer was it Mr. Nils Erickson?
He was, yes.
And then for the geotechnical engineer, was it a pallet?
Yes.
And so you yes, how quickly did you get advice from them about what next steps to take? Do you recall? Was it hours, days, weeks?
I mean, we called both of them probably the very next day, and then within probably 3 or 4 days, give or take, I don't remember the exact, but with pretty quick, both of them came down. We had meetings on site showing them what we discovered.
All receiving actual written reports from both of them?
Yes.
And with that information, what was the identified path at that time for moving forward?
Well, we could not see what was in the hole because the slabs were still covering up the hole. So the first step was to shore up the building to make sure the building did not collapse. That was step number one. And then we would remove the slabs and then determine what the next steps were to fix whatever was causing the sinkhole. We didn't know at the time what that was.
How far did you get into any of those steps you just identified?
We received shoring shop drawings. In other words, for you guys that don't work in the business, there's an engineer that designs how to shore up a building. It's not just some guy going up there with a bunch of 2x4s and say, yeah, this will hold the building up. It's actually designed by a structural engineer or a shoring engineer. And so they give you a design on how to do that. And I think that's as far as we got before it was kind of, we were told to step away.
Well, you said you were told to step away. Tell us more about that.
We had provided pricing for what we knew we didn't know what was causing the sinkhole. So we just provided pricing for the shoring, engineering. I don't think we actually, installed any shoring for the building at all. We provided pricing for that to the Conservancy. That was ultimately not approved. They said that they would take over, and that's kind of when we backed away.
Do you recall sort of the timing of events? I know it's been a long time. Was this hours, weeks, months?
It was within a couple weeks, I believe. I mean, it takes time to design a shoring for a building. That's not something you just do in an afternoon. There's a lot of calculations that have to be ran. So, you know, by the time we got the approval to do that, and then the actual design was completed, was probably a 2-week span.
back to we'll come back in a minute to the Conservancy, yes, taking over. But before that, I want to follow up on the reporting you got from the engineers. Do you recall, you talked about their suggesting shoring for the hole for safety purposes? What was the ultimate objective of the reports they gave you? Why shore up the hole? What was the point behind doing that?
Well, we weren't shoring up the hole, we were shoring up the building to make sure it did not collapse.
Your Honor, objection.
All right, same ground, 701. All right, why don't we have council approach? I want to flesh this out. And were you able to take this down? Are you recording it anyway, or we just summarize later? Okay, is everyone fine with that? Okay. All right, Mr. Halsey, you may ask your next question.
At this point in time, again, before the Conservancy took over, had you been able to identify the cause of the sinkhole?
No.
Was that important to you in your job?
Yes, I mean, we want to know what caused it so that we can potentially fix it, repair it.
Advice from your engineers on that point?
We never got we never got access to the hole per se, so we didn't know what caused it. And so our engineers, I think in the reports, there's engineering reports out there that they were all waiting for the slabs to get out of the hole so that they could figure out what was causing the problem.
Did not happen, at least up until the point the Conservancy took over.
That's correct.
Before we go to that part, I have a sort of a separate question. You indicated that you shared the same bank as our client.
Yes, sir.
And did you, in this process, well, let me back up. Did you understand that that bank to be lending funds to our client for this project?
Yes, sir.
Did you yourself have interaction or discussions with the bank about moving forward?
I think that we had a
Objection.
We can give you the rule or the grounds generally in hearsay. All right, Mr. Halsey.
I'll try to rephrase the question.
All right.
As part of your process, as a contractor moving forward, you indicated you were talking to multiple stakeholders. Without telling me what they said, was the bank one of those stakeholders that you were consulting?
yes.
And did you receive information, without telling me what it was, information from them about moving forward and about lending funds?
Yes, sir.
That's fine. We'll have a witness from the bank come in. I just want to
Okay.
know if you have that knowledge when you were moving forward through this process. So let's go to the point that you made a moment ago. You said at some point you received instruction to stand down. Conservancy was taking over.
Correct.
What, if anything, was your understanding of the stand down? Why stand down?
I never really got a clear answer on that. I felt like it was, had to do with being, financially,
Well, I don't as you speculate, did you receive information?
No, I'm just, no reason really.
Did the Conservancy communicate to you directly about them taking over the investigation?
They just said, stand down, we'll take it from here. And that was pretty much it.
You said you've done lots of construction projects. Would that be normal for the landlord or owner to take control of a project that involved something like a sinkhole?
I'd never encountered a sinkhole before. But typically, if we're the contractor on site, the landlord will typically have us do whatever landlord work needs to be completed for the project.
That did not happen in this.
That did not happen in this case.
At some point, did you become aware that there was a sort of sewer system under this building?
I did.
Let's look at- We'll be showing Mr. Norton latest 3. Lauren, if you look at that and tell us if you recognize it.
I do.
How do you recognize that, sir?
Well, just having worked on the project, I know that the footprint of the building. So that's the building with the sewer lines highlighted.
Is the exhibit you're looking at fair and accurate representation of your understanding of how the sewer lines were oriented at this time?
They're fairly accurate. I believe there's some other lines that aren't shown on this diagram, but they're fairly accurate where the lines cross underneath the building.
Or first of all, maybe we consider that any evidence, any objection?
No objection.
Admitted.
Pull that up, please. And can you explain what we are looking at here, Mr. Norton?
Sure. So you're obviously you're looking at the top view of the building. This is the Soulshine space here. And then the walkers is here. And then these green dots represent manholes. And then the lines, the sewer lines underneath the building. Now, I know that this manhole is a little bit further north than this diagram shows, but it's basically how the lines, sewer lines run up under the building. And there's some other drawings that show additional lines as well. These are just some of them.
Was there a belief at some point in time shared by yourself and or the parties that the sewer line might be the cause of this sinkhole?
That was the logical, thought at the time. Yes, sir.
Why do you say that was the logical thought at the time?
Well, you could hear in the sinkhole, standing inside the Soulshine space, roughly here, you could hear running, and that's typically when it's not raining, you feel like that's a sewer line that's going underneath the building.
Were you aware of that sewer before construction began?
I was not.
What steps, if any, at all, did you take vis-a-vis the sewer line? Did you have any involvement in checking out the sewer line?
I did not.
Did you become aware at any point of anybody checking out the sewer line?
Well, once we found the sinkhole, the city of Atlanta started doing some investigating, dye test, smoke test, to see if they could determine, what caused the sinkhole.
You privy to the city of Atlanta's testing and what it was doing?
We knew roughly what they were doing, but we were not really involved. We were kind of looking at it, standing away, looking in, so to speak. So we knew kind of what they were doing, but we were not involved in that process at all.
At some point, were you made aware that the city had put grout or backfill into the sinkhole?
Yes.
Who made you aware of that?
We were monitoring the site at this time, we probably dropped by once or twice a week. We're no longer on site manning it daily. And we came by and saw that they were working in there and then ultimately filled the hole up with grout.
And you said you were not working, you were monitoring but not working on site. Why is that?
Well, because we were told to, be gone, so to speak, until it got repaired. And then we would get back to work. That was kind of the thought, that.
Effort between you and your company directly with Mr. Banta to come to some sort of agreement to continue, identifying the cause of the sinkhole?
Can you ask that again?
Sure. At some point, I realized you were ultimately working on behest of our client, Mr. Lett. Was there a point in time where you were having direct negotiations with Mr. Banta for your company and you and your engineers to actually work on the sinkhole?
We only got to the design portion of that, to the shoring, like I alluded to earlier. And then that's when we were told to stand down and they would take it from there. So we never actually did any, quote unquote, repair work to the site.
Do you ever recall them trying to retain you or your company for that purpose?
We were talking about it briefly and then told to stand down and they would handle it.
I'm gonna show you plaintiff's exhibit 50.
We have 51 that has fit on behind it. It's like that.
Take a look at this, please.
Okay.
Do you recollect this email?
Yes.
And how do you recollect it?
Well, I've been involved in this case for 5 years or so. So, I mean, I've had it in my files for a long time.
This email directed to you.
It was. Yes, sir.
Who is it from?
Mark Banta.
And this is a fair and accurate reflection of the communication that you did receive from Mr. Banta at that time.
Yes, sir. It is.
And well, first of all, Your Honor, we would tender into evidence plaintiff's exhibit 50.
It appears that plaintiff's 51 was disclosed, but at quick glance, it looks like the same thing, different format. No objection.
All right, 50 is admitted without objection.
Can you tell us, sir, what is the email you're looking at? Let me actually start by asking the date.
It is August 7th, 2018, looks like.
Tell us what you understood this as the recipient to be.
That, I mean, in summary, that Mark Banta is going to release us to get started with the engineering for the shoring, that's the shoring of the building. That's kind of the first paragraph, and then he kind of goes and talks about, getting the city of Atlanta watershed management to figure out what's causing the sinkhole.
Is what you were referring to earlier when you said you had an understanding that you were no longer part of this investigation?
Well, not at this point. He's asking us to get started with the engineering, and that's as far as that we ever got with, solving the problem, fixing the problem, or anything. So he's just giving us the go-ahead to say that, get our engineers out there to shore up the building, to get a design to shore up the building, which we did. And then that's when we were asked to, kind of stand down.
Closest time from this email to the time you were asked to stand down?
Probably within a couple weeks.
Do you ever recall negotiating a insurance provision with Conservancy to do work?
Yes, sir.
Tell us about that.
In our, because we were concerned with the building collapse, we had our insurance company come down and review the building, look at the sinkhole that we found. And so when we gave a proposal over to the Conservancy, it included a pretty premium for insurance coverage for the building. If we were going to take the liability to shore up the building, fix the hole, we didn't know what the cause was. We had to, make sure that we were going to be able to insure the building, which carried a high premium.
And you were not able to reach agreement on that?
We were not.
One more question for you about this email. I'm going to point you to a specific part. You see the fourth paragraph down, references a failed sewer line. Do you see that?
I do.
Can we blow that up a little bit? Do you see this as, where, yeah, I'm just gonna read it. PPC is, so PPC, do you understand what PPC stands for?
Piedmont Conservancy, yes, sir.
And it says, go ahead and keep working with the city to acknowledge that this condition was caused by a failed sewer line. And then so forth. At this point or at any point, did you ever receive an indication that this was a failed sewer line?
We did not.
At some point in time, you indicated you became aware that backfill or grout had been applied to the sinkhole.
Yes, sir.
And were you asked by Mr. Rowlett or anybody to take a look at that, or have your engineers to take a look at what the city had done or whatever report they might have generated to determine whether it made sense to move forward?
We did not. No, sir.
Did you ever provide the city memorandum? You recall?
I don't recall that. No, sir.
Let me show you the memorandum we're talking about. It's exhibit 109. Don't pull it up yet. I need to show.
I do recall receiving this and seeing it. Yes, sir.
And what is that you're looking at, sir?
It's kind of the summary of the findings of the city of Atlanta, I guess watershed management, their dye test, smoke test of the sewer lines.
And how is it that you were able to recognize that document?
I mean, I'd received it. I can't tell you when I received it, but I received it sometime during the course, probably on or pretty close to the date here, October 10th, 2018.
There be a fair and accurate representation of what you do recall you received?
Yes, sir.
Evidence, plaintiff's exhibit 109.
We're going to object on hearsay grounds. I took this witness's deposition, so.
All right. Yeah, we'll just start right there. Unless there's an exception to the hearsay rule, Mr. Holzer, you think this is a business record of some kind? I don't know if I've heard adequate foundation.
Our purpose in inquiring about this is not so much about the truth of what's this, but more so about what steps as the general contractor, Mr. Norton took in response to it and whatever direction he may have given in response to it.
All right. All right. At this time, the objection to tender exhibit, I believe it was 109, is sustained. And so plaintiff may ask their next question.
So we're not going to publish this to the jury. I have a limited question is have you seen this memo?
I have, yes, sir.
And you think you received it at or near the time it was prepared?
Yes, sir.
And do you recall who provided to you and what you were asked to do in response to that memo?
I don't recall who sent it to me. No, sir.
Did you use that memo to take steps in connection with the sink?
No, sir.
Do you recall if that's something you showed to your engineers or talked to Mr. Roulette about the memo?
I'm sure that I would have sent it to all the engineers. This is a pretty important document, in my opinion, so I would send it to to the client. If they didn't send it to me, I'd send it to engineers, everybody that was on, kind of the team, so they'd have a record of it. Yes, sir.
And we showed you some photos earlier that you said had the backfill reflected in those photos. Do you remember that when we started today?
Yes, sir.
Is that something you observed yourself, the backfill in those? Right, so let's.
I did. Yes, sir.
I'm gonna bring those back up. Okay, and what are we looking at here, sir?
This is the grout that they poured into the hole, if you will, after the slabs had been removed. They poured that into the hole.
For the record, we're back to one of our earlier exhibits. We're displaying some of the photos within plaintiff's exhibit number 85. And that is something you observed yourself?
I did not see them actually pouring it in there, but I saw it after it was installed. Yes, sir.
Let's go to the next picture, please. What is this?
It's just another picture of the fill that they installed.
And next photo, please. What are we looking at there, sir?
Is the same, is basically a cylindrical hole, and they just filled it up with this grout. You're looking at the edge of the slab here. And then there's the other slab, which would be kind of up here that you can't see, but you're just looking at the grout that they poured in the hole.
This backfill we're looking at, also discussing this evening, we're looking at it. That's something you ever advised at any point during this process to happen?
No, sir.
Did your engineers give you advice that you relied on to suggest this should happen?
No, sir.
Did Mark Banter, the Conservancy, coordinate with you in connection with applying this grout or backfill to this hole?
No, sir.
Did the city of Atlanta coordinate this with you?
No, sir.
You said you still, at some level, had monitoring of the site. Was it unusual, in your estimation, not to have been contacted, coordinated with any of these parties in connection with this backfill being applied to this hole?
It was a little unusual. Usually they tell us, maybe not, they won't give us all the details, but hey, next week we're gonna fill the hole up with grout. Okay, but we never received any correspondence. We just came, monitoring the site maybe once, twice a week, and saw that this had been completed or installed.
So now you've seen backfill applied to this hole. Did you advise our client? Did your engineers advise you? Okay, everything is safe here to keep building.
I think that we asked for a soils engineer's report on this.
Did you get one?
We never got one, never received one.
Make sure we're talking the same language. You say soils engineer. Is that the same thing I've been calling a geotechnical engineer?
Yes, sir. Yes, sir.
Why was that important to you as the general contractor to get that geotechnical report?
Well, we want to make sure the dirt is stable, that we can build on top of it.
Did you get it at that particular time? Did you receive a geotechnical report?
No, sir.
Did you ever, in the course of this case, receive a geotechnical report?
No, sir.
You know whether during, well, let me back up for a minute. No, you indicated someone you no longer had control over the investigation. Conservancy.
Yes, sir.
From that point forward, were you ever given the reins back to take the lead, or any role for that matter, on the investigation of the sinkhole?
No, sir.
Just so we can picture in our mind kind of what you're doing from the point the Conservancy takes over. You've talked about being on site monitoring and whatnot. Did that continue into the foreseeable future where you had your site set up and you would go back and check on it from time to time?
We did for a number of months afterward. Yes, sir. We were still paying for construction, rental, fence rental. And we were still hoping that we would get started back with construction. But we're just stopping by, once a week, once every couple of weeks, whatever.
Was there a point in this entire process where you actually did continue construction on some parts of the community center?
I think that we started back on the Walker's side for a brief, maybe 3 or 4 weeks. That's been a long time ago, but I think we were still working when we discovered the sinkhole. We were still working on the Walker side for a number of weeks afterwards. Soulshine had stopped, kind of shut down, and we were still working on the Walkers. I don't remember the length of time. Maybe it was 5, 6 weeks. I don't know.
Do you recall during any point when you still had sort of active control over the scene? So not the subsequent monitoring and whatnot, but when you actively were in control of the scene, if the sinkhole had grown?
It appeared that it had grown some. Yes, sir.
Tell us a little more about that.
Well, we were monitoring it, and it seemed to be getting larger. I think there's a couple of emails and some of the exhibits that I've seen that our superintendent referenced that it had grown some. And then the city of Atlanta was trying to figure out, what the problem was, and they were pouring water down the sinkhole, which was further eroding the sinkhole.
And what impact, if any, did that have on you in terms of either your investigation or advice you're providing or anything?
Well, we provided an email that to Mr. Banta that said, we strongly discourage them pouring water down the sinkhole for fear that it was going to continue to erode.
You said you stayed with the site for some period of months. Was that into, even when you were less active or just monitoring, was that into 2019, do you recall?
I believe it was, yes, sir.
Do you recall at some point in time becoming aware of a engineer by the name of Eric Hagberg?
Yes, sir.
Okay, and who was Eric Hagberg?
He is a structural engineer with Palmer Engineering, as I recall.
And how did you become aware of him?
He provided a report to the structural soundness of the building, if you will.
Is this a report that you yourself ever had the opportunity to review during this case? Or not during this case, but back in the time all these things were happening?
Yes, we received his report. Yes, sir. One of his reports. Yes, sir.
And do you recall the reason that you received that report?
I think he was supposed to be evidence for us to get started with construction again.
Do you recall who provided you that report?
Not specifically, but it's probably Mark Banta, but I don't recall exactly.
I'll show you an exhibit. It's going to be exhibit number plaintiff's 133.
Sure. Can you ask your next question, Mr. Halsey?
Do you recognize that document, sir?
I do.
And how is it you were able to recognize it?
I received it, on or about the date that it's dated. I mean, I can't tell you who sent it to me, whether it's Mark Banta or Be Our Guest. I don't, but I do recall the document. Yes, sir.
Did you use that report to make some determinations whether you might be able to move forward with the project given the sinkhole?
Not really. Palmer Engineering is a structural engineering company. They don't deal with subsoils or geotechnical soils. So they're basically saying, yeah, the building is structurally sound and get back to work, but that doesn't tell me anything about the dirt underneath the building. And if the dirt gets washed away, the building collapses, this doesn't mean anything.
We'd like to actually, at this point, Your Honor, tender as plaintiffs 133 into evidence.
Objection.
133 is a minute.
Incidentally, does the report you're looking at, what's the date on that report?
November 15th, 2018.
Blow it up a little bit. Can you tell us, I guess, first of all, who is this directed to?
Mark Banta.
And the author is Mr. Hagberg.
Yes, sir.
And yeah, sort of, let's just get to the punchline. Does this indicate that the site is safe for building?
Absolutely not.
Well, let me rephrase that. Does this on his face say that the site is safe for building? Is that the conclusion of Mr. Hagberg?
I think he is saying that as it pertains to the structural stability of the building.
What you indicated, the fact he's a structural engineer was a concern of yours. Any other reasons that you were concerned about relying on this for moving forward with the sinkhole?
Well, I think there were several different drafts of this letter that I've seen. As it relates to the sinkhole, I mean, again, he's a structural engineer. He doesn't do anything with dirt, other than say that the building is going to sit on a foundation that has to be 2,000 PSI per square inch or whatever the prescription is. So just because he's saying the building is stable, again, doesn't mean that it is based on, the dirt below it. Dirt's got to be stable too.
Objection, Your Honor.
Just a second, Mr. Halsey. We got an objection. You just give me the rule, then I'll have some frame of reference here
Sure.
or the concern.
Opinion testimony. This is not an expert witness.
All right, Mr. Halsey, I do believe that would be sustained.
More targeted question. Did this report identify a cause or scope of the sinkhole?
It speculates to the cause of the sinkhole.
Does it give a definitive explanation?
No, sir.
Let's actually drill a little bit further on that. I'll take you to the conclusions and recommendations. We can fast forward to that. If we can blow up the second to last paragraph, please. Let me ask you to take a look at this specific paragraph. It starts with, there are no. Does this paragraph speak to a possible cause of the sinkhole.
It does not.
Do you recall seeing anything else in the report that identified the cause of the sinkhole?
He's already answered that question. Next question.
You said you received this on around the date of this report.
I believe so, yes, sir.
Did you receive any other reports from Mr. Hagberg at the time of these events dated the same date, November 15th?
I believe I did, yes, sir.
You received them at the time.
No, not at the time. They've
I'll be
been,
very precise on my,
Okay.
so not during litigation, not during, as in real time, you're on the ground with events happening. Did you receive a separate report from Mr. Hagberg with the same date as this report?
I don't recall. I don't think I did.
Actually, let me just show you and
Okay.
make sure we're on the same page on that. And what's been marked as plaintiff's exhibit 97.
Thank you.
That over and see if you recognize that.
Okay.
I'll ask you the same question now that you've had a chance to review plaintiff's 97. Is that a report that you received at or near the time or of any of the stuff we're talking about, the sinkhole, at all?
I don't believe that I received this report.
I'll ask for the point.
Okay.
We'll move on to a slightly different topic. We've talked a lot about the sinkhole.
Yes, sir.
Do you recall, I'm gonna be specific just so we can get to the point, issues coming up relating to roof trusses, mold, sanitary lines, grease lines, things like that during the course of this matter?
Yes, sir.
And tell us what it is that you're able to recall about that.
Well, there were a number of structural issues with the existing building that we uncovered. For example, there were a number of roof trusses that were cut. You can't just cut, for you guys not familiar, you can't just cut a roof truss because you want to. They're engineered. So we discovered a number of those after demoing the project. The sewer lines were either flat or actually flowing back into the space. There was mold that we uncovered. There was a wall that we were having to cut to install a door, and there wasn't a footing underneath the door. There was a beam that we found inside in the slab, a steel beam in the slab. What that's doing there, no one knows. And then the footing for the walkers was a big piece of granite, not necessarily a poured footing, which is all just indications of either, kind of shoddy construction or not typical construction, I would say.
Are these issues that were or significant issues or kind of limited issues based on your experience? How would you describe those issues?
Well, there's some, anytime it deals with structure, they're significant.
You alert the Conservancy to these issues.
We did.
And how did it respond to your raising these issues?
I think the response was, we'll see if it's our financial responsibility to do this or if it's the tenants.
That came down.
It came from Mark Banta.
Yeah, and do you know how that was resolved?
I don't know that it was ever resolved, not while we were on site.
At some point in this case, did you issue, and I may not be using the right terminology, a stop work order?
We terminated the contract for convenience, I believe is the terminology. And that was probably maybe a year after the sinkhhole. We hadn't been on site in probably 8 or 9 months. We weren't getting anywhere. And then so we terminated the contract.
I'm gonna bring you to an earlier point in time, so I am using the wrong terminology, so I'm gonna show you a document.
All right, let me pause you there, Mr. Halsey. How much time do you think you have remaining on this direct?
Probably no more than 20 minutes of that.
All right, we're gonna pause at this point. I believe, members of the jury, we've gone into, want to make sure everyone remains well nourished. So at this point, let's take our lunch break for today. We'll resume, let's be back at 1:30 and we'll take it from there. Any issues to take up? If not, we'll see you then.
There's a cafeteria. Yeah. It's like sad. Yeah.
All right, Mr. Norton, you can step down and I'll remind you not to discuss the case with any other witnesses while we're on break. All right? Okay, anything we need you to perfect the record before we recess until 1:30? From behalf of the plaintiff, on behalf of the defense? All right. Well, then we'll be in recess.
Jason.
Yeah, I can't.
I'm sorry, I think I'm like the wrong. I'm sorry. I was. You're just standing there. Check the internet, this should be.
Hey, John, can I tell you about the strategy? So. Anything on the water?
Thank you all. Please be seated. Thank you. All right, we're back on the record. Any reason we can't resume and bring in the jury from the plaintiff?
No, sir.
All right, anything from the defense?
Your Honor.
We can bring in the jury. Yes, ma'am. Do you think that would help? Do it. We can put it up there right now if you want to. You got multiple microphones? Just one. Just, yeah, just come around and so you could just leave the microphone here and keep typing away.
Yes.
We'll do that.
Okay.
And then just wave at us if you can. Here, so I can also pass the microphone around. Would you be able to hear it then? Well, we're gonna do that.
About the jury.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, members of the jury. Plaintiff may ask their next question.
Show you what's been marked as Plaintiff's Exhibit 24.
Okay.
And I'm just trying to get the timeline clarified a little bit. The sinkhole was July 11th, is that correct?
I believe so. Yes, sir.
Okay, the document we're looking at, what is this document? How do you recognize it?
It's just a field report from Piedmont Geotechnical Soils Engineers. Basically, we had them come out to, and, just preliminary investigation of what we saw. This is just their report.
And is this the report you received and acted upon at that time?
Yes, sir.
All right, I would ask to tender in evidence, plaintiff's exhibit 24.
No objection.
Submitted.
All right, and I guess we can pop this up quickly. This references Piedmont Geotechnical. Who were they?
They were the geotechnical engineers that we had on the Walker side, I believe. They were already kind of involved in the project.
Identified previously as Mr. Ballard.
It is.
Oh, yes.
Oh, this is Sharp. I'm sorry, this is Mr. Sharp.
Did Mr. Sharp work for Mr. Ballard?
Yes, sir, I believe so.
You pull it up to the paragraph. We can blow it up. And if you could just tell us what is the recommendation here that you received at that time?
He's saying that we recommend having the pipe video to identify the location and what's causing, I'm summarizing here, but identify what is the cause of this. And there's some speculation as to what the cause is, and then further recommendations will be given, I guess, basically saying.
And did you try to follow the advice given to you by your engineer?
Yes, sir.
And did you give advice in turn to Mr. Roulette?
To Mark Banta?
Mr. Roulette?
Oh, yeah.
And were you still coordinating at that time with the Conservancy?
Yes, sir.
This is 2 days after the sinkhole.
Yes, sir.
I'm going to show you what's been marked. Plaintiff's exhibit 41. Take a look at that, sir. And do you recognize this?
I do.
How are you able to recognize this?
This is just a report that was given to us by the our structural engineer, tenant engineer.
And is this a report that you received at or near the time of the sinkhole?
It is dated July 25th.
Is it a report that you relied on?
Yes, sir.
I'll tender this in evidence, plaintiff's exhibit 41.
No objection.
Submitted.
And if we put this on the screen, please. So this reflects M2. Who is M2?
They were the structural engineer for the tenant's design for their restaurant.
And did this include Nils Erickson as the I guess actual engineer?
Yes, sir. He was the engineer that wrote this report.
You've indicated earlier that, usually you'd have a geotechnical engineer talk about, sinkhole structure. This is obviously a structural engineer. Why is it that you're also leaning on a structural engineer?
Well, because we were concerned with the safety of the building, that the building would collapse.
And did you receive recommendations upon which you relied from this engineer?
Yes, sir.
And what were the recommendations upon which you relied?
Well, we started engineering to shore up the building, and that's as far as we got.
This was within, about 2 weeks of the sinkhole? Is this something you share with our client?
Yes, sir.
Is it something you were still cooperating and sharing with the Conservancy at that time?
Yes, sir.
As of that point in time, had the Conservancy, or anybody for that matter, had the Conservancy followed your recommendations about what to do?
Objection. Your Honor, I've allowed it, but the questions are getting very leading.
All right. If it's to leading it, at this point, I'll overrule. You can renew it if necessary. You can answer the question if you recall it.
What was the question again? I'm sorry.
At least as of this point in time, you said you would convey the recommendations, to the Conservancy. Did they take steps at this point in time to do anything?
They, Mark Banta sent me an email saying, start with the design of the shoring for the building.
I'll show you the defendants, this defendants exhibit number 55. Here's take a look at this, please. Same questions. Do you recognize this? And if so, how?
Yes, sir. I recognize it.
Okay. And how is it you recognize it?
Well, it's addressed to me.
And who's it from? We'll move to the tender defendants exhibit 55 in evidence, Your Honor.
No objection.
55 is admitted.
So first of all, what is the date we're looking at, sir?
July 16th.
Is this still
18.
the timeframe where the parties are working together?
Yes, sir.
Okay. And what do you, I guess I'm gonna ask you very specifically, does this talk about the need for a soils engineer report?
Not the need, but he's talking in reference to the soils engineer report that we just went over.
So the note about the soils engineer report is the engineering report that we looked at a moment ago.
Correct. Yes, sir.
So at that point, you provide that to Mr. Banta.
Yes, sir.
Okay, thank you. You should have on the table in front of you plaintiff's exhibit 50, if you don't mind looking through those. This is what we talked about a minute ago. I just want to draw your attention to a couple of things. Can we put this on the screen, please? It's already been admitted. Can you tell us what the date of this letter is?
August 7th, 2018.
So not too long after the prior email.
Correct.
I want to bring your attention to the final two paragraphs. And can you tell us what you understand to be being conveyed to you? You are the recipient of this email, correct?
Yes, sir.
All right. What's going on with these last two paragraphs?
Mark Banta is saying, please forward us the shoring engineered drawings. Those are the drawings to shore up the building. And then he's asking about trying to kind of figure out who is going to be responsible as far as cost, or what the cost is going to be. And that's essentially it.
Okay. And does Mr. Banta describe this as a life safety emergency in this email?
He does.
And what did you heard that phrase, and what does that mean to you when you hear that?
Well, I mean, it's certainly an emergency. You know, we're here again, we're concerned that the building might collapse, and there's tenants in there, there's kids in there. It could potentially be a major problem.
Go ahead with the market plaintiff 64. Sir. After you looked at it, can you tell me if you recognize this document?
I do.
And how do you recognize it?
This was given to us. We were working with Ed Smith, who was working for the Conservancy. He was kind of their construction manager or consultant when he was brought on board after the sinkhole was discovered.
Communicated with him about this?
About the sinkhole?
Yeah.
Yes, sir.
And this email, is it a true and accurate representation of the communication that you recall having with Mr. Smith in this matter?
Yes, sir.
introduce into evidence, tender for into evidence, plaintiff's exhibit 64.
No objection. For the record, Mr. Halsey, I heard you say plaintiffs 4. I don't know if I misheard,
Plaintiff
but
64.
plaintiff 64. No,
All
no
right,
problem.
64, plaintiff 64 is admitted.
Sure. This is a little bit of a longer one. Let me have this place on the screen, the first page, please. Actually, I take that back. If we could start at, Bates number 567. So this, on what you're looking at effectively will be the back of the first page. Mr. Norton to the following page. And obviously, we don't want to waste the jury's time reading this issue by issue, but can you tell the jury, first of all, what is the date here of this communication with you and Mr. Smith?
This particular date is August 21st, 2018.
All right, and you said that Mr. Smith is who again, sorry?
He was the consultant brought on by the Conservancy once the sinkhole was discovered. Now, he may be on retainer, I don't know, but he got involved with us after the discovery of the sinkhole.
And then this refers in the subject line to a OALC meeting. What is an OALC meeting?
Owner, architect, client meeting.
And I guess can you just explain what that meeting is? Are they common?
They're common. It's just getting the whole team together, the owner, architect, landlord, contractor. We're just all getting together in a room and discussing next steps and what's coming up and what we've done and schedule and cost and just those kind of items. They're pretty common, probably once every 2 weeks on most projects.
That signal in a situation like this, that the parties are trying to still work together to move the ball forward.
Correct. Yes, sir.
And without reading it in entirety, what are the sorts of issues that are under consideration in that page and the following that you all are working through?
Well, we're talking about the sanitary sewer line that we found that was incorrect. Are falling backwards. Looks like there's some rotten studs that need to be replaced, some mold that was discovered. There's a footing that was missing under a CMU wall. And then I think that, Ed's stance is that we should have had monies in the project to address those issues, those unforeseen issues.
Go to page 5, Bates 568. Keep going, please, to the bottom paragraph. And are these viewed based on your reading here as being serious issues, not so serious issues? How
These are serious issues.
did Mr. Banta or Mr. Smith see this?
Well, I mean, I'm writing what's in blue here. So he's basically saying, well, we should have had, monies in the budget to cover unforeseen conditions. And we don't, we can't anticipate everything. So if it's something minor, we might cover it. But with what we were discovering at this particular site, it was way more than minor.
And this is the following day, it looks like August 22nd.
Yes, sir.
And what's the gist of this message from Mr. Smith to you?
Basically he's saying, he wants a successful project, but he's cautious about taking responsibilities for items that are, he says, covered under our scope and our responsibility, and they're not.
And then the in regards to the soul shine, sorry. Sorry, the paragraph starts in regards to soul shine lease area. What's the conversation you're having with Mr. Smith there?
Let me just read it here for a second. We had sent him I guess, a proposal at this point to shore up the building. And that was probably it at this point.
Sir, I'm going to show you what's been marked as plaintiff's exhibit 80. You recognize this, and if so, how?
Yes, this is just an email that I sent to Mark Banta about trying to get some numbers together for him to shore up the building and get the slabs out.
Tender for admission, plaintiff's 80.
No objection.
Admitted.
And if we put this on the screen and scroll down to the first email of the two. And what is this?
So at the time, we'd had a number of subcontractors and specialty subcontractors come out, look at the sinkhole and what it was going to take to shore up the building and get the slabs out at this point. And then we provided those quotes to the Conservancy.
And did the Conservancy ever act on that?
I don't know. They had somebody come out and do something, but I don't know if it was one of our subcontractors or one of the guys that we had here. I'm almost certain it was not.
Showed you previously plaintiff's 109. Bottom of that is the city memo from October 10th.
Okay.
And may we approach your honor?
Just a second, we're gonna do the microphone.
So you were confused that this would not this like this is a
There's, can you leave it up there? Or is it better?
So, Mr. Norton, we talked about this a little bit ago. Before we get going, I do want to tender into evidence plaintiff's exhibit 109 with respect to, guess really it's page one only, page one only.
The objection to page 1 of 109,
No objection.
admitted.
You said this is something upon what you've been asked to look at and help you make some decisions.
Yes, sir.
What I want to bring your attention to, if we can put 109 on the screen, is blow this up. So I think this is what we're calling the city Atlanta memo, but what's the date on this?
October 10th, 2018.
Who's the recipient identified?
Mark Banta,
And then who is the author of this report?
Chris Lewis,
And who does Chris work with according to this?
Department of Watershed Management.
Okay, I want to bring your attention to the, I guess, third paragraph. You can scroll down, please. And in this paragraph, let me start by asking the final line, if you'll look at that. Did this report, upon which you relied and made decisions, indicate the cause of the sinkhole?
It did not.
What did it indicate about that?
It just basically said that all their tests came back negative and did not indicate that the sewer caused the sinkhole formation or any sewer caused the sinkhole formation. Pretty much sums it on the bottom line of that. Starting here.
And with that information, what did that allow you to do or not to do in moving forward?
Well, it didn't tell us what formed the sinkhole. So, and with that, without having a soils engineer report, pretty much means we can't get back to work.
I'll show you what's been marked as plaintiffs 97. It's something you recognize, sir.
It is.
How do you recognize it?
Well, I believe I was provided this during one of the many depositions for this case.
You recall looking at this closer in time to the events, or do you recall only receiving it during the litigation?
I believe during the litigation. Is this different? No, it's the same one. Okay.
So yeah, if you need to look at reference the other, please take your time.
Okay.
So I guess my question is this something you received in real time, meaning at the time, at or near the time of events, or is this something you recall in only?
I believe this particular document I saw only during litigation.
What, hand you what's been marked as plaintiffs at 107? Is this something that you recognize, sir?
It is.
How is it that you're able to recognize this?
It's a document I created.
Right, and what is the document?
It's just a letter. Let me finish reading it real quick. Okay. It's just a letter, I think we were asked to kind of get back to work, but we were not provided any kind of,
Oh, wait, before you get into it.
Okay.
I wanna make sure. It's a letter, okay.
Yeah.
Let me first see if I'm here, there's some evidence, plaintiffs 107.
I'm looking at plaintiffs 107. I think what was disclosed to us is plaintiffs 175, which appears to be the same thing.
Got it.
Yeah. No objection. Thank you.
107 is admitted.
Let me bring your attention, put that up on the screen, please. What is it? All right, who's to and from, and what is the date of this?
October 17th, 2008, and to Catherine Drollet, the owner. This is for me. Yes, sir.
Let me bring us to the first paragraph, please, and I want to look specifically at the last sentence of that. What is it you're conveying to Ms. Drollet there?
That a geotechnical engineer, geotechnical engineer determined that let me just read it real quick. The geotechnical engineer is just saying that, we need to remove the slabs, and I'm paraphrasing here, but we need to remove the slabs and then figure out what the cause of the sinkhole is. Can't do that until the slabs are out of the hole.
And up to this point in time, had the investigation been taken over by the Conservancy at this point in time?
I believe it has.
To your satisfaction, had that been done? What you just read, the geotechnical engineer determined that the cause be, to help out determine the cause.
We never received a geotechnical report saying that.
Let's go down to the third paragraph. And what do you understand, looking at your first sentence, to be going on there?
Yeah, the engineers that we had on site, after the discovery of the sinkhole, they basically prescribed that the building be shored up and the slabs removed, and then the source be identified of the sinkhole.
At that point in time, did that happen?
By the time of this letter, it had not.
Let me ask you to look at the third paragraph, the final paragraph, the second sentence. Starts to date.
Right. Yeah, as of the date of this letter, we had not received any engineering reports that explain, what repairs the cities had made, what they found, or that the soils were stable.
The city memo, in fairness, was dated October 10th. Had the grout been put on in the sinkhole before that?
I don't know the date the grout was put in the hole.
Was it put in before the date of this letter?
I don't know the date exactly.
Okay, well, let me ask you this. At the time of this letter on October 7th, had you looked at the grout put in the ground by the city?
I remember seeing the grout in the hole. I can't tell you what date. That was 5 years ago. And I can't tell you what date it was.
That's fair. Well, let me ask you a different question. After the grout had been put in the ground, did you ever from that point forward, receive a report from a geotechnical engineer indicating that the cause of the sinkhole had been determined?
Yeah, we never received a report stating the cause or that the soils were stable, ever.
Did you ever advise Ms. Drollet before then, or at that time or after then, that you would recommend that she move forward with construction on this site?
No.
Did your engineers that were advising you ever recommend before, at that time, or after that it was safe for her to continue construction on that site?
No.
Was that conveyed to her?
Yes.
Marked as plaintiff's 175. You recognize this document?
I do.
And what is this document?
It's a document that we're terminating our contract.
And, well, first let me start. We would tender, Your Honor, plaintiff's 175 into evidence.
Objection.
Admitted.
So you're terminating your contract. And why is that?
Well, basically, we hadn't been on the site in, almost a year, probably a little over a year. It's dated October 16th, 2019. So a year past this previous letter. And we weren't getting anywhere. And we're still incurring cost at that point, so terminated the contract.
And anywhere from the letter from a year ago we just looked at, up until that letter, ever a geotechnical engineer?
We've asked that question. Next question.
A bit ago, we talked about the Hagsburg report from this dated, let me rephrase, dated November 15th. So that is that would be exhibit number plaintiff's 133. Is that 133? 133, Hagsburg one. Plaintiff's 133, you have that on the table in front of you.
Yes, sir.
And you indicated that that was a report that you had received and were asked to make decisions upon.
Correct.
Was there a point in time after you received this report that you actually reached out to Palmer Engineering to try to get more information about what went into this report?
I did reach out to them by phone.
And what happened?
It was a very kind of short conversation. And we'd worked with Palmer Engineering on other projects, so we were familiar with them. But it was a very short conversation, and as I recall, it's been 5 years ago, but
Objection, Your Honor. This is hearsay.
Sustained.
Oh, it's a different question. Based on that phone call, did you feel comfortable from that point moving forward with the construction project?
no.
We talked a little bit ago about the mold, the trussles and that sort of thing. I guess we understood the letter to suggest there was a disagreement between the parties about whose responsibility that fell in.
Correct.
What was your position?
My position was that it was a responsibility of the landlord, the Conservancy, to repair those items.
What about with respect to the sinkhole?
It would also my feeling that the landlord should be responsible for that.
Did you work again? Let me rephrase this. Did you have a good working experience with Ms. Drolet?
I did,
Work with her again?
absolutely.
That's it, Your Honor. Nothing further for this witness.
Cross-examination.
Undistributed. Your Honor, I'm going to ask if Ms. Mason's going to approach and give the witness a binder, also providing one to opposing counsel. We'll provide one to the court. Good afternoon, Mr. Norton.
How are you?
Well, nice to see you. It's been a while.
Been a minute.
Mr. Norton, you just testified about your view that the Conservancy was responsible for certain work associated with what I understand to be a rotting beam or trussle, as well as what you believe to be mold in the building, correct?
That's correct.
You don't have any basis to understand as between the tenant and the landlord who's responsible for what, because you haven't read this lease, right?
I think I have read the lease at some point.
Have you read it since I took your deposition?
I can't say that I have.
Okay. Do you understand this is an as-is lease?
I don't recall that.
You understand that the tenant was responsible for all improvements necessary to operate their restaurant business?
I don't recall that.
You don't know.
I don't know.
Okay. You don't know that the landlord's sole responsibility under the lease is to maintain the building's exterior walls, excluding the storefront, the foundations, and the roof in good and tenable condition.
I don't know that.
Okay. If that were to be the case, your position that things like mold and the trussel problem, you would agree that is not associated with the exterior walls, excluding the storefront, the roof, or the foundations.
I mean, I don't know the lease. I've read it maybe once years ago. I can't speak to it now. What was in it?
You learned after starting this project that you were working in a building that was over 100 years old, right?
That's correct.
And it's routine when working and doing renovations inside 100-year-old buildings to run into unexpected things, right?
Correct.
And I think I heard you testify under your contract, there was no money for those types of unexpected things, right?
That's correct.
Meaning you, J.M. Williams, would be entitled to a change order from the tenant, increasing the contract sum, right?
Either that or some change order or stipulation from the Conservancy to fix the problems. Correct.
There was no contractual agreement ever between the Conservancy and J.M. Williams, right?
I think that's correct. Yes, sir.
And so to the extent you found some mold or you found a trussel problem or you found problems with a grease line or any of that, all of that would cost the contractor more money, right?
Correct.
And the tenant who had the contract with the contractor would be responsible for funding that, right?
In most cases, no,
No, tell me why not.
because generally the landlord is responsible for the structure of the building. It's got to be in good working order. And this was not, this building was not.
You say generally, but you don't know the terms of this lease, right?
I do not know the terms of the lease.
Okay. Would you expect there to be contingency in the owner's budget to account for the unknown and unexpected things that were identified during the build out of a restaurant in a 100-year-old building?
I would.
You know that there was no contingency for those types of things in the owner's budget.
I did not know that.
Okay. You should have before you, sir, what was admitted as plaintiff's exhibit 50. If I'm pulling that up, Mr. Norton. If we could put that on the screen, please. And like we do sometimes when reading old emails, Mr. Norton, if you could start at the last page, that's the beginning of this email. And this is an email from Mr. Banta to someone at the city named Abed Mayer. Do you see that?
I do.
You know Mr. Mayer?
I do not.
Okay. You were copied on this email, correct?
It appears I was. Yes, sir.
And this is referencing some inspection that the city of Atlanta's crews had done on the sewer line sometime in the month of July 2018. Do you agree with that?
It appears that way. Yes, sir.
Okay. And Mr. Banta is conveying to the city of Atlanta, if you look at the beginning of the second paragraph, he says they conducted several dye pack tests and confirmed verbally that the sewer line ran underneath the building and the void underneath the collapsed slab also connects with the line. Did I read that correctly?
Yes, sir.
You would agree with me that to the extent dye was seen in the line that was introduced in the sinkhole or void area, that would indicate that there was a connection with the old City of Atlanta sewer, right?
I never saw a report that said that.
But you saw this confirmation or statement to the City of Atlanta, did you not?
I see this written here, but not in the memorandum.
Okay. We'll get to the memorandum. Moving forward, Mr. Believe it's Mar Abed. I'm a little confused as to which is the first and last name, but Mr. Abed responds to Mark, and he says, this repair is beyond our crew capabilities, so we will solicit assistance from our contracted support to complete the repair. Did I read that correctly?
You did.
Okay. He doesn't say there was no positive dye test, Mark, does he?
He does not. He doesn't reference the dye test there at all.
Okay. If you look up to the next email in the chain, I want to focus on, well, let's start with the second sentence. Mr. Banta says to Mr. Abed, we are concerned that we haven't heard anything from the contracted support or your team for the last 2 weeks regarding the void and collapsed floor in the community center building. Do you see that?
I do.
And I think you testified that at this point in time, everyone was working together towards the common goal of getting this issue resolved, right?
Yes, sir.
And Mr. Banta was following up with the city, trying to encourage them to respond and act faster. Fair to say?
Sure.
Okay. Look at the second sentence. It says, we believe that this sinkhole and undermining of the collapsed floor meets the criteria of a life safety emergency. Do you see that?
I do.
Did you ever have any conversation with Mr. Banta about why he used those specific words?
I did not.
Mr. Banta never told you that those were prescriptive words used to get the city to act quicker.
He did not.
Okay. We're going to come back, but go to the first email here. I want to look at the second to last paragraph. There we go. You see in this paragraph, Mr. Banta is also saying that the shoring engineering drawings that he's requested would be useful to provide to the city to encourage them to move faster. I'm paraphrasing, but that's the gist of this, right?
I don't know. It doesn't say to move faster, but he's asking for the shoring engineer drawings. Yes.
Okay, well, he says in the last sentence, he wants to use this as re-emphasis that time is of the essence from a construction cost perspective. Do you see that?
I see the cost perspective. Yes, sir.
Well, do you not see the time is of the essence?
I do.
Okay. And before that, he repeats life safety emergency. Here, he's not talking to the city. The city's been dropped, right?
Correct.
And he puts that in quotes. Do you see that?
I do.
Okay. Did that have any meaning to you?
The whole thing was a life safety issue, in my opinion,
At the time,
at the time. Yes, sir.
you have no reason to believe there's any safety concern after the injection of the grout, do you?
I do.
No engineers told you that, have they?
They have not.
Okay. Let's go back to, I'm going to use the Bates ending in 97. And if we could go up just a little bit.
Is this still the same exhibit?
Yes.
Okay.
Yeah,
sorry.
I'm referring, Mr. Norton, the numbers at the bottom right.
Oh, I got you. Okay.
Those are called Bates numbers. It helps me get you to the specific page. And I'm looking at the one that ends 3597.
I don't have a 3.5. I got
This is,
770.
plaintiff's 50. Or I'm actually on 51. That's the confusion. It's the same document.
Okay, I'm sorry. Same document. Okay.
Let me get my team to put it back. That confusion was the same document as plaintiff's 50 and 51. It's the August one we've already had up. This one. Y'all are on the wrong. Okay. Okay, just above this. Sorry about that. You see this is an email in the same email chain we've been looking at from Mr. Banta back to Mr. Abed. He says, thank you for your note from July 23rd. You see that, Mr.
I see that.
Okay. And if you look at the second sentence of the second paragraph, Mr. Banta says, last week during the heavy rains, water could be heard rushing in the void underneath the collapsed slab. Do you see that?
I do.
And that's not surprising, Mr. Norton, is it?
It's nor here nor there.
You understand this is a combined sewer?
I don't. No one's ever told me that.
Okay. You don't understand that when it rains, stormwater flows into that sewer?
Flows into a sewer, but I don't think this one was ever identified.
The city of Atlanta sewer underneath the sinkhole was never identified?
There's multiple sewers up under that building, from what I understand. They never found the cause or what was causing the sinkhole. I can't say for certain that what was found, that there's one sewer there, but there could be another one.
There could be, but that's just your speculation, to use your words.
That's my speculation.
You don't know.
I don't know.
You have no information to say there's any other sewer under there.
Other than the documents that were previously given, I don't.
And the documents previously given identify the sewer that we're talking about and no others, correct?
They identify a sewer.
Okay. You have no expertise in the repair of subsurface voids or sinkholes, correct?
I do not.
You don't understand what flowable cellular grout is typically used for, do you?
I do.
Okay. What?
Well, it helps to fill voids. It gets into crevices.
Stabilizes the area?
It can, yes, sir.
Okay. I want to go back to the city's memorandum. This is I believe plaintiff's 109. This one, Mr. Norton, have you got it?
I got it.
Okay. We could put that up. And I want to focus you down to the same language Mr. Hulsey just asked you about, but I want to go one sentence before the one he asked you to read. The second to last or penultimate sentence to the penultimate paragraph. Do you see it says to repair the void, the contractor backfilled the sinkhole utilizing a cellular grout to fill the excavation and stabilize the surrounding soils and subsurface conditions. Did I read that correctly?
You did?
Okay. And it does say the results of the investigation did not indicate any of our sewer assets as the cause for the sinkhole formation, right?
Correct.
They don't say our sewer asset did not cause this. They say the results of our investigation didn't confirm it, correct?
I mean, you're splitting hairs there, but I agree.
And you've worked with a lot of engineers over the course of your career as a general contractor, right?
I have.
Okay. And you agree with me that it's not uncommon for engineers to need to make conclusions to a reasonable degree of professional certainty, correct?
I'm not an engineer, so I can't really answer that, but
Well, sometimes you just can't find a definitive cause for an issue, right?
that's true.
Okay. And if you look back up, about midway through the paragraph that we're looking at after the number 2, it says 2 large concrete slabs that had fallen into the sinkhole, and they're talking about what they did, performed a vacuum excavation to expose the top of the rock sewer in an effort to identify any structural deficiencies. You see that?
I do.
What do you understand a structural deficiency to be?
I mean, it could be a break in the line, a collapse.
No structural deficiencies were observed, right?
That's what this indicates. Yes, sir.
Okay. This doesn't indicate that sometime over the course of 100 years, there wasn't a small hole in that sewer, does it?
It does not.
You agree with me that this void could have been caused before we were born?
Sure.
You've talked a lot, Mr. Norton, about shoring the building and the efforts that you took to obtain an engineered shoring plan, correct?
Correct.
Okay. And what we're really talking about is 2 columns that were in the vicinity of the void area, correct?
That's correct.
Okay. And the shoring that you're talking about is to allow a safe excavation to go down to that sewer to observe what's going on, correct?
No, not necessarily.
That wasn't the purpose of the M2 shoring engineering?
Well, it was to shore up the building because the footings were within the hole, the sinkhole. So we were concerned that they would be undermined and the building could collapse.
You were concerned.
Yes, I was concerned, and so were the engineers.
Well, I think you testified there was a September Palmer Engineering report that looked at that specific issue. You didn't receive that in September of 2018?
The one dated September 18th, I do not recall receiving until litigation.
Okay. Wouldn't you think if that was sent to, that's plaintiff's 133, is that correct?
No, that's 97. If I'm reading correct.
You're looking at, oh, I'm sorry, you're right. Plaintiff's 97. This is dated September 18, 2018. It's addressed to Mr. Banta, correct?
Yes, sir.
To the extent this was provided by Mr. Banta to the tenant, Be Our Guest, do you find it strange that Be Our Guest would not have forwarded it on to its general contractor?
I would.
Okay. And I want to focus down, it's the sentence beginning at the very bottom of the first page. And maybe I should have you read the sentence before. It says several are reinforced with LVL beams to support mechanical units. There are 2 steel columns, one each side of the space that is approximately 17 feet wide. You see that?
I do.
Do you understand those to be the 2 columns in question?
I do.
Okay. Says these columns support a steel roof beam that supports a mansard roof screening the mechanical units on the main roof. Do you know what a mansard roof is?
It's just a pitched roof, if you will.
Okay.
That's layman's terms.
And you understand Palmer Engineering had been the structural engineer for renovation work performed in the community center about the year 2000.
I didn't know that. No.
Didn't know that. Okay. Did you know that Mr. Hagberg had a thorough understanding of how all of the loads were dispersed and the associated forces with those loads throughout the community center?
I don't.
Did you ever have a chance to meet Mr. Hagberg?
I don't think I ever have.
Okay. If Mr. Hagberg were to testify that based upon his knowledge of this building, if those two beams were to collapse, all that would happen is the decorative mansard screen might fall over on the roof. Would you have any basis to disagree with that?
I would disagree because directly above the space are all the mechanical units.
Right, but those are supported by a different beam. If you go back, right?
I don't think so.
You don't know, do you?
I'm not a structural engineer, but I'm pretty sure that the load is directly above the space.
You're pretty sure, but you don't know, right?
No, I'm pretty sure. Yeah. We can go
Okay.
back to the picture if you like.
Okay. So you would disagree with the building's engineer of record, a structural engineer, if he said that if these columns would have failed, a decorative roof piece would have fallen down?
Well, I'm not a structural engineer, but I would, just hindsight looking back, I would disagree with that.
Okay. But if an engineer were to come into this courtroom and offer that testimony, you don't have the expertise to refute it, do you?
Your Honor, objection, he made this point, I think, 3 times.
Waiting for, overruled. You can answer it if you remember it.
I'm not going to go against the word of an engineer.
Okay. If you look down to the third paragraph under existing conditions, it reads, it is our understanding that the city of Atlanta came to the site shortly after this was discovered to investigate. It is our understanding that they flushed water and dye down the hole with a hose to determine where the water went and had observed dye in the sewer downstream from the void in question. You see that?
What paragraph is that again? I'm sorry.
That's the third paragraph under existing conditions. If you look on the screen and we've got it highlighted.
Okay.
You said you found that it was strange that this was not provided to you to the extent the tenant had this information in September of 2018. That would have been useful to know that the engineer and Mr. Banta and many others were under the belief that there was a positive dye test. That would have been useful information for you, right?
That would have been useful information. Yes.
You had some concerns about the city putting water into the void, correct?
I did.
And that was because when you put water in loose soil, it can erode and slough off, right?
Correct.
And so when we talk about this sinkhole is growing and is 3 feet bigger than it was a month ago, the logical explanation for that is the city's crews putting water in the hole, right?
Not necessarily. I mean, it could be a symptom of that, but there's something's carrying the soil away.
Okay. And it's possible that that soil, as it was getting carried away, this is before the void is excavated and cleaned up, right? The city is putting the hose and the dye in before it's cleaned up, excavated, correct?
Correct.
Okay. And it's possible that in that process, do you know how many times the city performed a dye test in July of 2018?
I think their memorandum, I don't remember the number, but it was a number of times. Smoke test and dye test, their memorandum says that.
The memorandum's talking about the testing done in September of 2018, right?
I don't remember the date.
My question, Mr. Norton, is during that time, the city's putting water in and dye into the, I'll call it native, pre-cleaned up void. It's possible that some of that water and dirt could have flown down and sealed whatever little problem was causing the loss of soil.
I mean, I guess anything's possible.
And if that were the case, it would not be possible to prove definitively what caused this, right?
I guess not. I don't,
And Mr. Norton, you're aware, or maybe you're not, in a heavy rain event, that actually pressurizes or fills up this old sewer such that if there's a little crack, it might shoot water up like a water pick. You familiar with that concept?
you can.
Okay, and then when the rain stops, the water might come rushing back down and pull a little bit of soil with it, right?
Sure.
And that phenomenon could have been happening from before we were born.
Correct.
Mr. Hagberg, if you go down to evaluations and recommendations, he says in the first sentence here, beginning on the third line, we believe this void has been formed by soil erosion over a long period of time. Did I read that correctly?
I'm sorry, where are you on this?
The first
Evalu-
paragraph under evaluation
Okay.
and recommendation.
So ask your question again.
Yeah, I'm reading from the third line. It reads, we believe this void has been formed by soil erosion over a long period of time. Just wanted you to confirm I read that correctly.
Yes.
Okay. And if you go down to the next paragraph, it looks like Mr. Hagberg is describing the same phenomenon that you were concerned about. He's addressing the potential growth of the void. And he says there's moisture from wet saw cutting. You see that?
I do.
Is that accurate? These big saws, I think you testified they were really loud.
Correct.
Are they also using water in order to cut?
They are.
And that water gets in, if there's a void underneath the slab, that water would get into the void.
Correct.
And then he mentions the washing of the dye to identify the water pathway as well, correct?
Correct.
And he says the addition of this water is the likely culprit causing the sloughing. You see that?
I do.
Okay. And want to go down a little more. There's been a lot of talk about geotechnical engineers. You're aware that a geotechnical engineer is a PE, professional engineer in the state of Georgia.
Yes.
And so is a structural engineer, right?
Yes.
And they're both in the discipline of civil engineering, right?
I wouldn't consider him civil engineer. No, structural is a structural and civil is civil, site work.
Okay. But they both get a degree in civil engineering, right?
I don't know what the official degree is.
That's fair. Are you aware of the concept of multidisciplinary engineering?
Sure.
What does that mean?
Well, it means that you can have an engineer that's both a plumbing engineer and an electrical engineer or mechanical engineer or whatever.
Just has to do with their experience and competency, right?
Well, they have to pass the test and get certified and yes,
You believe there's a different test to be a soils engineer versus a structural engineer?
sure.
Okay, if a engineer were to testify that's incorrect, you wouldn't disagree.
I would not disagree.
I want to focus on the general recommendations for repair. If we could go down just a little bit and we'll try and help you along, Mr. Norton. Again, I wanted to come back to this issue. Item 3, Mr. Hagberg is recommending that the Conservancy engage a geotechnical engineer to confirm the sidewalls of the void are reasonably stable to perform prep work and underpinning activities. You see that?
I do.
And you understand what Mr. Hagberg is saying there is we want to have a geotechnical engineer confirm that the sidewalls are safe such that we can excavate down, right?
That appears to be what he's alluding to.
Okay. And you would agree with me, would you not, Mr. Norton, that once the excavation is done and the flowable fill is installed, there is no longer a concern with respect to those two footings?
If an engineer prescribed that, then I would say that is correct.
Okay. If we could go to the next page, it says building use considerations. This is a September 18, 2018 report. So is it fair to say this is issued about 1 week after you received a stop work order?
Again, I don't think I saw this particular report until litigation.
Oh, understood. But it's dated about 1 week after you were told to stop work.
Roughly, I think so. Yes, sir.
And just to clear things up, the city of Atlanta can issue a stop work order as part of the building permitting process, right?
Correct.
That didn't happen here.
That did not happen.
When we talk about a stop work, that was a letter written to you by Be Our Guest, right?
Correct.
It was Be Our Guest's decision to stop work.
It was, yes.
Okay. And at this point, Mr. Hagberg is saying, based on observations made on site, we believe this void to be a localized issue resulting from soil erosion due to a hole in the storm sewer below the building. We have no reason to believe there are other holes or voids under the building resulting from other holes in the sewer at this time. The city inspection of the sewer will inform this understanding. As a point of comparison, there is a significant length of this sewer line that is not under the building, and no voids are observed in the exterior grade or flat work. Did I read that correctly?
You did?
Okay. And do you understand that that is a true statement, that there are hundreds of feet, linear feet of this sewer running not underneath the community center building, but running just out towards Piedmont Avenue and out into the park?
Correct.
And you would want to investigate those areas before you started doing destructive testing inside the building, right?
Not necessarily.
You don't know.
I don't know. I mean,
Okay. Mr. Hagberg goes on in the second paragraph, since this is a localized situation, it is our opinion that the remainder of the building and the construction site on the southwest corner of the building can continue and resume normal activities. The southwest corner of the building, that's the walker space, right?
that is correct. Yes.
Okay. And if you look down, Mr. Hagberg affixed his professional engineering stamp to this report, correct?
That's correct.
Okay. We can put that away. Thank you, Mr. Norton.
Your Honor, we would actually think it makes sense to go ahead and tender that in evidence since there's been significant discussion around it. So
Plaintiff's 97.
It's been tendered.
Oh, I don't have the note of
if
that.
it hasn't, we would ask that it is.
I actually don't have a note of that, but there's no objection to, even if it has been, to retender it, I suppose.
I thought it was in.
All right. To the extent it has not already been admitted, plaintiff's 97 is admitted.
Thank you, Your Honor. I want to ask you to pull back up plaintiff's 64, if you could, Mr. Norton. And I want to look at item 3 on the next page here. And it looks like to me, Mr. Norton, again, you identified this as an email conversation with yourself and Ed Smith. Who was Ed Smith?
As far as I know, he was the construction consultant for the Conservancy.
Okay. And it looks like this is one of those emails where at least the parties are attempting to use different colors to respond to statements. I say attempting, Mr. Norton, because it looks like something went haywire here.
I agree.
But maybe we can tell who's talking and who's not. Again, I think you testified that Mr. Smith was sort of downplaying these issues. Is that fair?
I would agree, yes.
Okay. And if you look at item 3, you're talking about this grease line that we've heard about. Is that right?
Yes, that's correct.
Okay. And you say towards the bottom of this paragraph, and correct me if I get this wrong, but I think these are your words. You says, as it sits currently, the pitch for both lines do not meet current code. You see that?
I do.
Are you aware of any representation by the landlord, the Conservancy, that this building and all of its attributes met current code?
I'm not.
Okay. And you go down in the very last paragraph, and there's a bold and underline. You say there is no money in the budget to cover any bold underline base building deficiencies. You see that?
I do.
And again, that's your construction budget, the budget and bid that you provided to Be Our Guest.
Correct.
You assumed that Be Our Guest was carrying a construction contingency.
I mean, yes, there'd be some kind of assumption there, I guess.
You looked at some photographs with Mr. Halsey, and I think you said it was your understanding that the void before it was excavated was approximately 10 feet deep. Did I remember that correctly?
Roughly, yes, sir.
If we could, I'd like to introduce into evidence. You should have a binder in front of you.
Mhm.
And I'll have you identify this before moving to introduce it. If you could turn to tab 3 in that binder. What is this document? It's marked as Defendants 307. Can you tell me what this is?
This appears to be a picture of them shoring up the sinkhole.
Okay, you
Two
understand,
workers shoring up the sinkhole.
and you understand this to be in the area in the Solshine space?
Yes, sir.
Okay. I'm going to move to tender into evidence Defendants Exhibit 307.
Any objection?
No objection, Your Honor.
307 is admitted.
If we could publish that, please. You said, Mr. Norton, that this appears to be workers beginning the shoring process in the void, correct?
Yes, sir.
Okay. So they would have, you can tell just on the periphery or the circumference of this material, shoring material, looks like the side edges have been cleaned up a little bit. You agree with that?
We weren't involved in at this point, so I mean, I can't really say they have or haven't been.
Okay. You agree that it looks like they've started the work of excavating down?
I never saw the hole without the grout filled and the slabs removed, so I can't answer that.
Okay. So to the extent you have testified that you believed the void to be 10 feet deep, that was really just your best guess?
No, we stuck a tape measure down and we had a board sticking out of the hole, some of the previous exhibits. So
Yeah.
you could measure that.
That board was a 2x4, right?
Yes, sir.
What's the standard length that a 2x4 comes in?
They come in varying lengths.
Okay. Do you know if it was an 8-foot or 10-foot 2x4?
That particular one, I don't know what size it was.
It didn't go all the way down.
Did not go all the way down.
Okay. You might have been exaggerating when you indicated this was a 10-foot deep sinkhole.
No, sir.
Okay. We talked about the double slab in the community center. You became aware of that, Mr. Norton, after as I understand, the first crew had a smaller blade or a smaller machine. They were cutting to install plumbing, and I think your testimony is it's unusual, but they identified that there was another slab underneath the first slab.
Correct.
When you found out about that, that didn't cause you to believe there was any structural concern with the building, correct?
No, sir.
Okay. Let's go some more pictures I'd like to admit. If we could turn Mr. Norton to tab 5 in your binder. This is pre-marked as defendant 73. This appears to be, at least starts as an email from someone named, strike that. Not sure who these people are. I'd like you to turn, we can disregard the email. I'd like you to turn to the photographs that are behind them. And I'd like you to flip through them, Mr. Norton. My question was, do these photographs accurately depict the condition of the walkers area in the late summer, fall of 2018, or about the time you demobilized from the site?
Roughly, I don't know when these pictures were taken, but roughly, yes, sir.
Okay. And I would move, Your Honor, to have defendant 73 entered into evidence.
Any objection?
Sorry,
Then it's
no-
73.
No objection, or
Admitted.
no objection.
Okay. If we could just pull these pictures up, I'd like to take a look at them with you, if you would, Mr. Norton.
Yeah.
Am I correct? This was a 14-week build schedule?
I don't recall the schedule.
Okay. Do you have a general recollection of what the scheduled completion date was? And I appreciate it's been some time.
Yeah. 14 weeks seems, for walkers seems way too quick, given the structure that we had to build. If I had to just guess, shooting from the hip, probably 20 to 22 weeks. I don't remember what it is, honestly.
Okay. That would be stated in the contract you had with BR Gas, correct?
Yes, sir.
Okay. If you look at this first photo, what are we looking at here?
You're looking at the walkers space. So the kitchen area is behind that plastic. We drape that over to kind of try to keep the weather out. And then the atrium, if you will, the dining room would be out in this location.
Okay. Are you able to tell the jury, where is Piedmont Road?
Piedmont Road would be here. So we're looking kind of south east on the building right now.
Okay. And I think you use the term atrium. Can you tell us what you mean by that?
Well, they had a very elaborate, it was a kind of a glass enclosure, almost kind of like a greenhouse. Probably the best way to describe it was gonna be the dining room.
And that was going to be an addition to the existing community center building?
Right, so it would come off this building and extend out this direction.
Okay. And ultimately, there would be a slab installed as part of that addition to the community center?
Yes, sir.
Okay.
I can't remember if there was, if it was I can't remember what the flooring was here. It could have been, it could have been brick. I don't remember.
Sure.
It's been a long time.
But at the time that you left the project, it was just soil.
Correct.
Let's move forward. We can skip the next picture. I'd like to go to the one showing it looks like some HVAC work. What are we looking at here, Mr. Norton?
This is, you're looking you're inside the Walker space, you're looking up, we've completed the demo, so you're looking at roof trusses. This is what we keep talking about with the roof trusses
Okay.
here. And then all the associated wiring, fire sprinklers, HVAC, those kind of items.
There's been a lot of discussions already about these roof trusses. Could you explain to the jury what a roof truss is?
Well, it's this wood structure here. So they're usually in the short, you've seen them on flatbed trucks, but they just make the roof of a house a lot of times, or a building. They can be whatever, but they're pre-engineered, meaning that they're engineered off-site somewhere. They come already assembled and we just erect them, put sheathing, which is plywood, OSB, and then, whatever your roof is, whether it be shingled or standing seam or whatever.
Okay.
But you're seeing these wood when I'm here, and I don't remember what the spacing was, but they're usually 2 feet, maybe 18 inches on center.
Okay. Let's go back. If we could, I'd like to show you a photograph. The last Bates is 753. Could you tell the jury what we're looking at here, Mr. Norton?
This is the interior space of the Walker's space. You've got, we've saw cut the slab, you can see here. So we're digging up, trying to get our plumbing in at this point. There's some existing plumbing. I don't know if these are roof drains or maybe they're vent stacks. But we're looking south inside the building right now. And so the atrium would have been this direction here.
Okay, and if I understood your testimony, this was going to be turned into the kitchen
The dining room kind of extended in. There was a bar here, as I recall. And then the kitchen was kind of back, maybe starting where these pipes were and then over this direction. So actually more the kitchen was kind of where these windows were, as I recall.
And I think you testified, Mr. Norton, the sinkhole was first identified in the Soulshine area sometime in July 2018, right?
That's correct.
And J.M. Williams continued its work in Walker's until it received a stop work notice in September.
I don't remember the exact date, but we continued to work, yes, until we got it.
Okay. And obviously you were authorized to do whatever digging you needed to do to install sewer piping.
Correct.
If be our guest or one of his geotechnical engineers wanted to do some coring or put some probes into that ground, there was nothing stopping, right?
Nothing stopping them.
Okay. There was some discussion about an effort to contract with the Conservancy for J.M. Williams to do the excavation work, shoring and excavation work down to the top of the rock sewer. Do you recall that?
We never got to that point. Because the contract was to remove the slabs and shore up the building. That's as far as the negotiations, as far as we got with those.
But there was a draft of a written contract that was exchanged between the parties, right?
Yes, as it relates to shoring the building and removing the slabs only.
I'm going to have you turn to tab 5 in your binder, if you would. Oh, excuse me, tab 4, Mr. Norton. And sir, if you could please let me know what this document is, if you recognize it.
It's a draft contract. A draft contract by the Association of Architects.
Okay, this is a form contract that folks in your industry use.
Correct.
Okay, you generally familiar with this AIA suite of documents?
Yes, sir.
And is this a red line of a draft contract that J.M. Williams was working on with the Conservancy sometime in the summer of 2018.
Yes.
Your Honor, we tender into evidence Defendant's Exhibit 371.
Any objection?
The moment, Your Honor. So send everybody else. No objection, Your Honor.
Submitted.
Thank you. The title, if we could put this on the screen, please. This document reads, the title of it at least, Determination of the Cost of the Work. You see that, Mr. Norton?
I do.
And if I say a cost plus contract, you understand what that means?
Yes, sir.
Could you explain that to the jury?
It's, what's paid to the contractor is whatever it costs us to do the job plus a fee, which could be some kind of percentage.
And are
Call
those,
it cost plus.
go ahead. And are those frequently used when it's difficult to determine what it's going to cost the contractor to do maybe a less defined scope of work?
Yes.
And you would agree that's an appropriate contracting mechanism for the type of exploratory work that was under consideration here?
Yes.
And Mr. Norton, the Conservancy was going to pay for this work, right?
Yes.
Okay. No one's saying that it was Be Our Guest's responsibility to fix the sinkhole at this point, right?
That's correct.
Okay. And I understand this all fell apart over an issue related to insurance. Is that right?
Yeah, I think that there's some strikeouts here in the back and the body, a boilerplate where they didn't want to pay for our insurance because there's stipulations on what can be charged and what cannot be charged. And there was some stipulations, strike throughs on paying for insurance, as I recall.
Okay, let's go to page 3. Is that what you're looking at, Mr. Norton?
I'm just flipping through it.
Okay, I'm looking at page 3. It's the first item under miscellaneous costs. Do you see that?
I do.
Okay. And that says premiums for that portion of insurance and bonds required by the contract documents that can be directly attributed to this contract. Did I read that correctly?
You did?
Okay. And JM Williams has general liability insurance, right?
Yes.
It has workers' compensation insurance.
Yes.
It has auto insurance.
Yes.
And JM Williams doesn't go out and procure typically project-specific insurance, does it?
All our projects are specific insurance, yeah, each job, because everybody wants to be listed as additionally insured. So every certificate, if you will, is, identify this person or identify that person or this group or that group or this owner or that owner.
Sure, but those certificates adding additional insured are issued pursuant to a standard insurance policy that JM Williams maintains, right?
I would say so, yes, sir.
JM Williams doesn't go to its broker and get a new policy for every project, right?
That's correct.
Okay, there are minimum required coverages that different owners will put into contracts as requirements, correct?
Correct.
And to the extent those minimums are in excess of what JM Williams has, JM Williams would need to say so and might need to go out and procure and spend more money to get additional insurance, right?
Correct.
And so as JM Williams was doing its work in the traditional build out of the Be Our Guest restaurants, it was required to have insurance as part of its contract with Be Our Guest, right?
Correct.
Okay. And did you ever come to believe that the Conservancy struck this provision because the Conservancy felt like there was already appropriate coverage in place, so it shouldn't have to pay for it?
I don't know why they struck it. It was never told.
Let's go to the very last page of this exhibit. And what I've done, you see these comment boxes, Mr. Norton?
Yes, sir.
Unfortunately, when you are dealing in PDFs, those are not real useful. So what we've done, we went back to the native version of this document and we generated this last page so you could see what this comment said. Do you see that?
I do.
Could you read it to the jury?
strike through cost of insurance and bonds covered in base contract.
Okay. The parties never agreed on this contract for JM Williams to do this work over a commercial issue, fair to say?
I'm not sure what you're asking there.
Well, it was about money. The Conservancy didn't want to pay for this insurance that was already in place. JM Williams wanted to be able to charge for that insurance.
Well, I think you're looking at apples and oranges, two different insurances. So, our basic insurance that we have on the project is one type, but now we're concerned that the building may collapse, which is a whole nother set of insurance. That was the issue.
What other insurance is that?
Well, just the limitations, the limits of the insurance.
Was the Conservancy requesting an increase in the limits of insurance compared to what we're carrying VR Castrol?
They weren't requiring it, but our insurance company, because we had notified them of the potential liability, they said, we're not going to insure you unless these premiums are met. And I don't remember what those costs were, but they were significant.
Were they ever conveyed to the Conservancy?
I don't know that we gave them the actual cost of those, but the reason that this contract, in my opinion, was not finalized is because the Conservancy was not willing to pay those premiums.
Okay. JM Williams wasn't trying to get out of this contract to perform this investigation work over any safety concern, right?
No.
You said you contacted your insurance broker about potentially performing this work. And I think you said they might have even come to the site. Did your JM Williams liability carrier ever tell you that you could not keep working in the Walker space?
No.
Want to show you another exhibit that Mr. Halsey spoke with you about. It's plaintiff's 80, if you could find that. And I think what your testimony was, Mr. Norton, that you were passing along some subcontractor quotes that you had received during the time when you were potentially going to be performing this shoring and excavation work. Is that correct?
Yes, I don't know I can't remember because we couldn't come to terms on the contract, that we just went ahead and gave the Conservancy our numbers so they could contract directly with them.
Right. You were trying to be helpful.
Trying to be helpful. Yes, sir.
And the version of this email, plaintiff's 80, it doesn't include any of these attachments, right?
It does not.
Okay. Let me have you turn, if you could, to tab 20 in your binder. Very last one, Mr. Norton. This appears to be an estimate that is addressed to JM Williams, correct?
It is. Yes, sir.
Okay. And it's from a company called Sinkhole Atlanta-Concrete Solutions. Is that a company that JM Williams had done business with before?
We had not.
Okay. And that's because JM Williams really has no experience in remediating sinkholes, correct?
That's correct.
Okay. And so do you recognize this document as a quote that JM Williams received for purposes of this company serving as a subcontractor to perform sinkhole repair work?
Yes.
Okay. I ask that defendants exhibit 148 be tendered into evidence.
Any objection?
No objection, Your Honor.
148 is admitted.
Okay. Um, Is this one of the documents, Mr. Williams, that was attached to your email to Mr. Banta of September 11, 2018?
I don't know. That's been a long time ago, but it probably was.
Okay. Well, if you go to tab 19, I don't know that we need to admit this. This is another version of the September 2018 email where you had indicated you're being helpful. You're sending along some quotes to Mr. Banta, correct?
Yes,
And if you go to page 2, it indicates there are 4 attachments. Do you see that?
I do.
Okay. And the first one is proposal Piedmont sinkhole. Do you see that?
I do.
Okay. And there are 2 for hydraulic shoring, and another just says scanner and some numbers. Do you see that?
I do.
Does that help refresh your recollection in any way as to whether this sinkhole Atlanta proposal was an attachment to your September 11th email?
It doesn't. I mean, the Atlantis is probably a subcontractor. It doesn't say sinkhole Atlanta, so I can't say for certain.
Okay. But again, on that date in September of 2018, you're trying to be helpful. You're forwarding along some subcontractor proposals to the Conservancy for their information.
Correct.
Okay. And J.M. Williams had received this estimate from Sinkhole Atlanta. And did you have an understanding of what Sinkhole Atlanta was proposing to do to repair this sinkhole?
I didn't. I believe I was on vacation when they actually came to look at the site, so I didn't actually speak with them personally.
Okay. So they were going to, if I'm looking at the description, they were going to remove the 2 concrete slabs inside the hole, correct?
Correct.
They were going to excavate all debris and dirt to expose the top of the storm drain. And they say that's up to 15 feet deep, right?
Yes, sir.
And they gave a lump sum of $12,500 to do that, right?
Yes, sir.
Okay. And then they're going to inject flowable fill. And they are going to charge flowable fill with line pump $210 per yard installed, correct?
Correct.
And you don't have a lot of information, Mr. Norton, about what the city of Atlanta's contractor actually did.
I do not.
You know, they injected a flowable fill.
Yes, sir. I can see it.
And that's the same thing that Sinkhole Atlanta was proposing to do as a subcontractor to J.M. Williams.
Yes.
Want to show you plaintiff's exhibit 3. Mr. Halsey showed this or had a discussion with you about this. It's the aerial, Mr. Norton.
Oh, okay. Got it.
And I believe you testified, sir, that you were not aware of the location of these City of Atlanta sewer lines shown in green before the sinkhole was discovered, correct?
That is correct.
But you understand that this information if I say GIS data, you know what I mean?
Yes, sir.
What do you understand that?
Which is it's mapping.
And this is public, right?
This is public. Yes, sir.
Okay. If J.M. Williams or Be Our Guest wanted to understand where sewer lines were vis-a-vis this building, it's not a hard thing.
It's not difficult.
When I took your deposition back in 2022, Mr. Norton, we had a conversation about your superintendents on the site. I think their names were Chris and Scott.
Yes, sir.
Are they still with the J.M. Williams?
Scott is, Chris retired 2 years ago.
Good for him. We had a conversation about those two individuals sort of looking over the shoulder of the city of Atlanta's testing crews during the July dye testing. You recall that?
Yes, sir.
And I think you testified today, J.M. Williams wasn't running that, wasn't really involved, but because you were the contractor doing work in the Walker space, your people, Chris and Scott, were there, right?
Yes, sir.
And I asked you at your deposition, if you had any recollection of a positive dye test. Do you recall that?
Talked for a long time. I mean, I don't recall that specifically, but
Okay. And you didn't recall it specifically then, but I asked you, I showed you an email where Mr. Banta, it's one we looked at earlier, where Mr. Banta was saying to Abed Mayor at the city, we were verbally told there was a positive dye test. And you said, well, I don't remember that, but now that you show it to me, I remember now. You remember that?
I do not.
You know there was a positive dye test in July of 2018.
No, sir.
You don't know one way or the other.
I don't know. I never saw a report that said we poured dye upstream and we saw it in the hole, or we poured dye in the hole and saw it downstream. I've never seen a report like that.
We saw one just a moment ago from Mr. Palmer, or I'm sorry, from Mr. Hagberg, dated September of 2018. I appreciate you didn't see that at the time, but you've seen it today, right?
From a structural engineer, I mean, I haven't seen where he got his information from.
Okay. You don't know about Mr. Hagberg's experience before dye testing, right?
I do not.
Thank you, Mr. Norton. That's all I've got.
Mr. Halsey, can this witness be excused?
We have a couple of questions on redirect, Your Honor.
All right, how much time do you need?
Maybe 10 to 15 minutes, Your Honor.
Anyone from the jury need a minute, or you can stand in place if you need to, stretch out, else we'll charge forward. All right, let's keep going.
He said 5 times he done. Okay, well, I will clarify. If I'll make that clear.
Okay.
I want to start sort of where we ended, or close to where we ended, defendant's exhibit 148. Can you bring that back up and yes, the council kindly represent that on the screen.
Yeah, we're happy to.
Thank you, sir. Council just asked you about this document. Do you recollect it?
He already asked about it. I think we know that he does.
Yes, sir.
And I think there was some suggestion here that the contractor or subcontractor upon whom you relied suggested flowable fill as a possible solution to this problem.
Yes, sir.
What's the dollar amount listed beside flowable fill?
0.
What's the dollar amount listed beside shoring?
12,500.
Is it possible that the only plan of attack here was to shore up and that flowable fill was not part of the plan?
Yes.
You were asked a significant number of questions around reports you don't recall seeing. Plans exhibit 97. Do you mind?
This is defendants 148, right?
Yes, sir.
right? And this is the September 18th Hagberg report, correct?
That's correct.
Let me start by asking this question. You said you don't recollect seeing this in real time, meaning you remember it from the litigation, but from not happening in real time. Are you not suggesting our client withheld it from you, are you?
I'm not, I don't recall seeing it.
They testified to the contrary. Would you disagree with that?
Um, I don't remember when, the day I received it. It's been a long time ago.
And a consistent refrain in your responses to Mr. McCleary was something to the effect of, well, if an engineer said it, I'm relying on it. And you really meant that, right?
Yes, sir.
In fact, in this case, did you lose money by not being able to proceed on this project?
Yes,
Because you had a large project scoped out that stopped pretty early.
correct.
Did you do that relying upon engineers in making those decisions?
Or the lack thereof. Yes, sir.
And why was that important to you to rely on engineers?
Because I'm not a soils engineer. I'm not a structural engineer. I'm a contractor, licensed general contractor. And I have to rely on those experts to tell me if I can build safely or not.
Clary asked you some questions about structural versus geotechnical engineers, suggesting perhaps they have similar backgrounds, maybe can do the same functions. Do you remember those questions?
I do.
You had, though, separate structural and geotechnical engineers, is that correct?
That's correct.
Why was it important to you to have those be separate engineers, not rely on one engineer to do it all?
Because
Objection.
one,
Assumes facts and evidence. He's asking if it's important to him. I think the evidence is that at least one of these engineers was not working for the contractor.
Second phrase.
All right. Why don't you do that, Mr. Halsey?
Were you relying during this project on whoever would retain them on a structural engineer and a geotechnical engineer?
yes,
And why was it important to you to be relying on the opinions of those two different types of engineers?
because they had two different fields that they work in.
Throughout this this afternoon, you've insisted you need to see a geotechnical engineer to be satisfied to move forward. Why was that important to you?
Because that's the soils, to make sure the soil is stable.
Now, in response to an inquiry about the September 18th Hagberg report, which you don't recall seeing, one of your answers, I'll roughly quote, was something to the effect, well, I'm not going to go against an engineer.
That's correct.
Would your position change if you found out that that engineer had issued two different reports dated the same date with different conclusions?
That would cause a big question, yes.
Another answer, or let me rephrase. Mr. McCleary had a line of questioning, is it not possible that certain work that was done could have filled the sinkhole, something to that effect? You recall a line of questioning around that?
Yes,
Were you prepared to move forward in this case on what was possible?
no.
What did you need for you to move forward and to advise our client to move forward?
I needed a report from a licensed geotechnical engineer saying that the soils were stable. That's all I needed.
Nothing else, Your Honor. Thank you.
Can you recross on those points?
Very briefly, Your Honor. Be Our Guest had a licensed geotechnical engineer on retainer at this site frequently during your work on the project, correct?
That's correct.
Are you aware of any effort Be Our Guest made during your work on the project to obtain a geotechnical engineer investigation and report that would satisfy you and allow you to go back to work?
On the sinkhole, no, sir, I do not.
Okay. Are you aware of any effort by Be Our Guest after you ceased performance on the work to have a geotechnical engineer come and do investigation and testing and write a report that would allow you to come back to work.
Say that one more time.
Sure. Are you aware of any effort by VRS to have its geotechnical engineer come out to the site, perform an investigation, and issue a report that told you the ground is stable and you can return to work after?
After it was, the hole was filled, yes, we had several meetings with the engineer, but nothing could be determined, soils engineer, but nothing could be determined because the hole had been covered up and no further investigation. We couldn't see anything. We couldn't determine the cause.
So
So
is your understanding that after the void was filled with the cellular grout by the city of Atlanta, it was not possible to determine the cause?
that's correct.
So what BRS was asking the Conservancy to do as a condition to resume work was not a condition that could be fulfilled.
No, they should have had it before they filled the hole. They should have had a geotechnical engineer there prior to filling the hole with some kind of prescription, do this, do X, do Y, and that was never provided for us. That's the whole summary of this case, in my opinion.
And do you know that Mr. Banta, in writing, let BRS know the city of Atlanta is back on the project doing work in September of 2018?
I saw contractors there, but I'm not privy to that.
Do you know that Mr. Lett personally visited the site and spoke with the Ruby Collins workers who were doing the excavation work?
I do not.
Are you aware of any reason if BRS wanted its geotechnical engineer to observe the work of Ruby Collins, the city of Atlanta's contractor, in performing the excavation, performing the dye testing, and injecting the flowable fill? Are you aware of any reason that BRS could not have had its engineer present?
No.
Thought got it.
All right, Your Honor, if I may, those were both outside of direct and my cross. I have two questions, if I may. Those were new topics.
We can take it up during a break, and you can recall them if we feel the need to do that. So for now, Mr. Norton, you can step down, and unless the jury needs a break, we'll call your next witness. And so you'll remain under your subpoena, Mr. Norton, to the extent you have been, and you may be recalled in this case, okay?
Okay.
All right. All right, plaintiff may call the next witness.
Call Brian Harper, Your Honor.
I get the Harper.
What's that?
Oh, these are long.
That's the partnership.
If you've admitted them, I would say keep them with our court reporter, and then they can be retrieved as needed.
It's here. Hey, oh, I know, this one's irrelevant.
I do. Brian Harper, Brian Harper. Good afternoon.
Please introduce yourself to the jury.
I am Brian Harper.
Well, I guess I have to redundant. Tell the jury what you do.
I'm the national sales manager for an SBA department. which is a government lending, commercial loans.
That's who you work for today, is that correct?
Well, I didn't say who I work for today, but so I currently work for Cadence Bank as the national sales manager for their SBA lending division. Yes.
Let's move back to 2000. Period. Did you become involved in financing a project for BR Guest to build 2 restaurants, Walker's 1834 and Soulshine?
Yes.
And do you recall how you became involved in this lending project?
I believe they were introduced to me by a colleague.
Do you remember if you were at that time the banker for general contractor James Williams?
I was not the banker for J.M. Williams.
And you were, what was the bank you were working for back at that time?
Atlantic Capital Bank.
And tell us a little bit about Atlantic Capital Bank. Is it a national bank, local bank? What can you tell us?
We're a small local bank based here in Atlanta.
And you're in lending, you said, what kind of projects do you, are you involved in lending funds?
Lend funds for business acquisition, startup businesses like restaurants, commercial real estate purchases.
If I may approach, Your Honor, I am going to hand you, Mr. Harper, what's been marked as Finance Exhibit 121. Sir.
I'm sorry, counsel, you said one.
Finance Exhibit 121.
Okay,
And if you recognize this exhibit, sir,
I do.
how do you recognize it?
I recognize that this is a letter that I wrote.
Well, let me first see if I can tender this in evidence, move to tender claims 121 into evidence.
No objection.
Admitted.
Let's put this up on the screen. The date of this letter, sir?
October 29th, 2018.
You wrote this letter, who was it directed to?
It was directed to Ms. Gillette. Yes.
Was this for the project we talked about for the Walkers and Soulshine?
Yes.
And from looking at this letter, just looking at the first line, what was the line of credit you all extended for this project?
This was not a line of credit.
Maybe the wrong terminology. What was the amount loaned for this project?
The loan amount was $1,500,000.
And this reflects that there's a principal balance, talks about some numbers. Does that suggest the loan is already underway here? In other words, this is not the beginning. This is somewhere in the process that you're already loaning out funds.
Yes.
And what I want to bring your attention to is in the second paragraph. And if you will look specifically at the second sentence of that second paragraph, if you can raise that up on the screen and pull it up, please. And if you would please read that paragraph or that line, I'm sorry, to the jury.
We will not fund additional construction advances until we receive confirmation from a third-party geotechnical engineer that the sinkhole cause has been properly repaired, remediated, and poses no life safety issues.
First of all, how did you come to this point where you gave this instruction to the client?
I was made aware of the sinkhole at the property that they were leasing, and in discussions with my credit partners and our third-party construction management firm, this was our position.
And can we infer from this letter dated October 29th that by this point you had received no third-party geotechnical engineering report?
correct.
And I'm going to show you now what's been marked as plaintiff's exhibit 166. You recognize this exhibit, sir?
Yes,
And how do you recognize this, sir?
this is a letter that I wrote.
And, well, let me first move to tender into evidence, plaintiff's exhibit 166.
No objection.
Permitted.
We can bring that up on the screen. And what is the date of this letter, sir?
July 26, 2019.
Does this relate to that same loan to be our guest for the Soul Shine and Walkers project?
Yes,
And if I can take bring your attention to the second paragraph, second line. Can you read that second line, please?
we will not fund additional construction advances until we receive and review a third-party geotechnical report.
How did you come to the point of making this, I guess, or giving this direction to our client?
Nothing had changed and we still had not received the geotechnical report.
That's all the questions I have for this witness, Your Honor.
Cross-examination.
Mr. Harper, good afternoon.
Good afternoon.
Who is your current employer?
My current employer is Cadence Bank.
When did you leave Atlantic Capital?
Well, Atlantic Capital was purchased. We merged with South State Bank, and that would have been in March of 2024.
Okay, so Atlantic Capital Bank no longer exists. It was
Correct.
acquired.
Correct.
How did you find out about the sinkhole issue at the community center?
I do not recall.
Have you ever written a letter similar to this before, insisting on a particular type of third-party geotechnical or a particular engineering discipline as a condition to funding further progress payments?
No.
So this is pretty unique.
Yes.
Okay. And I think you said that this was issued after you became aware of the sinkhole issue at the community center and in consultation with some of your, I think you said lending partners and third parties. Tell me a little more about that.
It was in consultation with my credit partners and our construction management firm.
Your construction management firm, if I recall, is a firm called Partners. Is that correct?
Yes.
Okay. And Partners is you call them a construction management firm. They go out on behalf of the lender when a contractor issues a pay application. And they're generally there to make sure that the value of the work the contractor is invoicing for is in place, right?
Yes.
And they have expertise with the construction process.
Yes.
You as a banker do not, you rely on what your construction managers tell you with respect to what's going on with the construction site. Fair to say?
Not always.
Okay, tell me what you mean by that.
We don't always, I mean, sometimes we go out, depending on the size of a project, and do inspections ourselves. So from a generalization standpoint, it's not, we don't completely rely on them. I am not.
You're not an engineer.
No,
Have you ever worked in the construction industry?
no.
Okay. And so when you go out, as opposed to sending your folks with construction expertise out, why do you do that?
To see the progress of the project.
Okay, so you're there just to see how things are coming along. You're not there personally as the banker to look at something and say whether it's properly constructed. You would rely on your construction management firm for that.
Correct.
You said you don't recall how you came to understand there was a void or sinkhhole at the community center in 2018. Is that right?
Correct.
Okay. Do you believe Ms. Drolette may have told you about it?
I'm not sure when I first heard of it.
Do you know when Be Our Guest stopped work on the Walker's space?
I don't remember.
Do you know, well, let me just confirm, plaintiff's 121 here is dated October 29th, 2018, right?
Yes,
And this is the first time that Atlantic Capital Bank, the lender, told Be Our Guest that it wouldn't fund additional advances until it had this particular engineering report. Is that correct?
I'm not sure.
Have you seen any other letter or document at a different or earlier time where that condition is being conveyed?
No,
And Atlantic Capital Bank, to the extent it's going to issue a notice to its borrower regarding what it needs to advance funds, it's going to do that in writing, right?
I'm not sure.
Okay. Does Atlantic Capital Bank, when you were there, in your experience, did they condition loan agreements and terms of disbursements orally?
Can you repeat the question?
Sure. What I'm trying to understand is if there's a condition to a draw on a loan that your bank has issued, you're going to issue a written notice to the borrower to let them know, right?
Not always.
Okay. Can you give me an example of when that was done, not in writing?
I can't give any specific examples, but oftentimes there's conversations.
Okay. Do you recall having any conversations with anyone associated with Be Our Guest about this sinkhole prior to, let's just call it October of 2018?
I don't remember the dates.
Did Be Our Guest or any of its principals have a prior banking relationship with Atlantic Capital Bank?
I don't believe so.
Did you know Ms. Drolette or Mr. Dooley before they applied for this loan?
No,
Did anyone from Be Our Guest reach out to you and request that you issue this letter requiring this particular type?
no.
You hesitated, sir. Why'd you do that?
You asked if it was to be required.
No, I asked, did anyone from Be Our Guest reach out to you and say, we'd like you to send us this letter requesting a particular type of engineering?
I recall being asked to write a letter, but not specific to what was in it.
Who asked you to write that
Ms. Gillette.
letter? Tell me what you recall about that conversation.
I don't recall specifics.
But this letter only got written because Mr. Drolette asked it to be written, right?
Yes,
Is that the same with plaintiffs 166? About a year later, July 26th, 10 months later, 2019. Was there another request that Atlantic Capital Bank issue that letter?
Yes.
Was that request from Mr. Olet?
Yes.
Okay. If I could approach, Your Honor. Mr. Harper, I am handing you what's been pre-marked plaintiffs 123.
What is this?
I got an extra. Yeah. Do you recognize this document, Mr. Harper? And I appreciate it's lengthy, but just generally, do you recognize what this is?
I recognize what it is.
What is it?
This is let me just make sure I look at it first. Construction monitoring report.
Okay. And it's dated November 1st, 2018. Do you see that?
Yes.
And it's prepared for Atlantic Capital Bank, correct?
Yes.
And we've talked about the construction manager who's verifying what's been done in the construction process. And a big part of their job, I don't want to say all, but a big part of their job, again, is a contractor issues a pay application or an invoice. And before the bank funds that, they want to make sure that there are assets that have been put into the project to cover the secure loan.
Yes.
Is that part of what this document that we're looking at does?
Yes.
Okay. And this is issued and received as part of the bank's ordinary course of business, right?
Yes.
Your Honor, I move for the admission of plaintiffs 123.
Any objection?
We have no objection provided that this witness is able to say that he's seen and can testify to these contents. We have no objection on hearsay grounds. We would ask, as always, with any witness that they establish that he has familiarity and can speak to this document.
All right. So you're saying the entire document hasn't been authenticated, essentially?
Right.
All right.
I'm going to ask about one page of the document. I just wanted to produce it and tender it into evidence as.
Is
it was
that a
produced.
page that he has any idea of what it
Well,
is?
let me ask him. If you could turn Mr. Harper to page 4 of this document, section 3.0 site observations. You see that section 3.1 progress summary?
Yes.
Is this something, I'm not sure who makes the call on approving a draw. Is that something you do?
No.
Who does that?
Specific to this organization.
Well, I'm trying to understand do you approve that? I'm trying to understand what your role in the actual release of the money is.
It really depends on in the bank. It just different banks have different processes.
Well, let me ask, have you seen section 3.1 from this November 2018 partners report?
Yes.
Okay. You are able to read and you understand what the information being conveyed here in the ordinary course of business is.
Yes.
Okay. Your Honor, again, we move for the admission of plaintiffs 123 into evidence.
Mr. Halsey?
No objection.
All right, is that to 123 in its entirety or just a specific aspect of it? I want to just make sure I'm understanding if the objection is still, this is more towards plaintiff. Or actually, let me ask, what's being tendered at this point?
The entire.
The entirety, okay. And so back to the plaintiff, no objection to its entirety?
No objection.
All right, then 123 is submitted.
Okay. If you look down, and if we could pull this up now, I'd like to go to page 4. And again, this is dated November 1st, 2018. So it's just a couple days after the first letter requiring the geotechnical engineering report that Mr. Olet asked you to send. I want to look at the second bullet that says site work. You see that? It is first addressing Suite A, paren Solshine.
Yes.
If I could have you read the couple 3 sentences that stop before Suite C, Walker's 1834. If you could read that into the record.
Site work, Suite A, Solshine. Slab at sinkhole has been removed. Sinkhole has been filled with concrete. Project has been given the go-ahead to proceed.
Thank you, Mr. Harper. That's all I have for you.
Redirect.
Yes, Your Honor. Mr. Harper, let's, I guess, start where you ended. Mr. McCleary had asked you about the Palmer report, and specifically that paragraph about the site work.
Partner report, Scott. Partners.
Partners, right. Do you have any firsthand knowledge of what went into that? For example, did people go to the site or did people read reports? Do you have any idea what went into that site work conclusion?
I would be speculating.
I don't want you to speculate. I'm asking if you know.
No.
And in fact, that report is dated, at least the date of inspection is dated October 19th. Is that correct?
Yes.
And your letter to our client, the first one I showed you, plaintiff's 121, is dated October 29th. Is that correct?
Yes.
After this date. So whatever happened here, it was still the bank's position that you needed a third-party geotechnical engineering report when you sent this letter out. Is that correct?
Objection leading.
Overruled.
Yes.
You also asked, and by the way, that wasn't just once, but then it was twice, right? Again, you issued a separate letter, I mean, not a year later, but not far back, July of 2019, right?
Yes.
And then a question was asked of you whether Mr. Olet had requested the letter. Do you know if that request was basically to confirm or memorialize what you had already told her orally?
Objection, hearsay.
Sustained.
Well, let me just ask you, what you said was a request, Ms. McCleary asked if our client had requested the letter. Did our client request the contents of the letter be described as they were?
Objection, hearsay.
Let me revisit this and make a record. So if council can approach.
Come back.
All right, the objection is sustained. Plaintiff may ask their next question.
Yeah. Never take one more question. I have a question. Can you tell us what the bank's position was vis-a-vis this loan and the third-party geotechnical engineering?
The bank's position was what was stated in the letter.
All right, any recross on any new issues raised?
No, Your Honor.
Okay, can this witness be excused on behalf of the plaintiff?
On behalf of the plaintiffs, yes.
All right, on behalf of the defense?
Yes.
All right, thank you, sir.
Thank you.
All right, show of hands. All right, let's take a break. Y'all let us know when you're ready to proceed.
There are camels over there.
You get it all
Officer's flag still in red.
She doesn't turn over her nose.
Swear to the rest.
Just give us 1 minute. Let's just make sure we perfect the record. I'll give you all a break. Don't worry. I'm just trying to make sure we tie up any unfinished business. There was a request for a redirect on Mr. Norton, and I didn't want to put this in front of the jury, but my position would be that yes, generally cross and recross should be confined to the elements raised. But I think there needs to be a contemporaneous objection so I can stop it right then and there. And then just as a bigger picture, I thought that the witness was very much, and I think this is on both sides, being used just to talk about things that he had nothing to do with. And I think that was mostly the subject of the recross. And so I think that the points that I would imagine you can feel free to proffer if you disagree that you would be bringing out on redirect are going to be coming into evidence through more of a firsthand witness of those points. So I'll just put that out there. Is there anything else that you want to be heard on that point? And if there's a need really to bring Mr. Norton back, otherwise I would ask if he can be excused by the parties.
May I make this inquiry? I generally agree with Your Honor on all those points. If the specific issues that were noted for the future about bringing that up contemporaneously, if those issues that were brought up, I guess, come to our knowledge, become more central in this case, I guess we would ask to reserve the right, bring them back on rebuttal. I think that is highly unlikely, but just at least reserve that right if those became front and center. But
I mean, just the point being is a lot of the topics brought up through Mr. Norton were, in my mind, just questions that were driving home larger themes or other points that are going to be brought up again later through other witnesses. And it was just a point to emphasize things that will be brought up again. Specifically on the recross, it was just about efforts made by BOG to obtain a geotechnical report. And I just don't see how Mr. Norton is essential to establish or clarify that. That's going to come out one way or another later.
okay, what?
Your Honor, one more clarification, just because something you said that caught me off guard. My understanding, in Georgia statement is cross is not limited to direct.
No, that's not my point. It's on recross.
Okay.
Right? Recross. Same, and that's the point I'm making. And also, I'll add this. I think your objections on leading, they're not necessarily unfounded. It's just that I believe it's the trial court's discretion that I can allow leading questions in the interest of time and efficiency. And when there's so much to get through here, I'm going to be very inclined to allow that. Unless this is some susceptible lay witness, that can just be so coached by counsel that we need to avoid leading questions. I haven't seen that yet.
Thank you, sir.
But any other clarifications on this point?
No, sir.
It just felt Mr. Norton, we was,
No, sir.
that was the reason. So if you're saying you want to, at this point, you want to hold off on excusing him, so be it. And we'll go from there.
Thank you, sir.
All right. Then with that, we'll take a few minutes. Let's not go too far. And maybe we can have the next witness ready to go. All
What
right.
time do you want us back? Ryan?
Yeah. Let's just take a 5. And again, just go ahead and bring in your next witness when you're ready. Be in recess.
How long is it gonna be today? He says. Yeah. All right. All right. That's good, brother. We might just have to do a floor sweep.
Okay,
I might be done by the time 8:05, but we'll see.
okay.
All right.
All right, where's the gallery? So. Let's get rid of all of this. Let's be decent. This I know it's off your house. This is mine.
Unless
Yes.
you make notes. of this.
I can see mine.
Okay.
Oh, and then there's another.
Oh, this-
It's first 7. And we're there.
Okay, cool.
I think we looked at objections about this. I think I looked at them this morning. I don't think they have any objections to the new contract.
I don't think so.
Maybe just that one that I flagged.
Oh, yeah.
Oh, yeah, those. Oh, it's just. You should think about that. That's spring. That's fantastic.
John, you're fine with most of these exhibits. We do have an objection to, the 719 Yeah, these, yeah. I don't think this witness authenticate. He's told us many times he hadn't been there since 2019. None of this was built in 2019.
Good.
You mean like I? He didn't take it.
That's where they are.
Everything, all this stuff is right there, just grab one. Folders in the line, it's just fine. You need to see the outline of my water.
Exhibits for Howard.
We're working on it, yep.
So the one they have an objection to photos that were close to the 2023. Some the cracks in the floor of these.
Well, that'll come in through settles, right?
I think he was.
Well, there's object to that too. because the
Yeah.
pictures
Okay,
ain't-
fine.
yeah. So all these witnesses.
All we can say is the true and accurate representation of how the place was on the soft, that's all they need.
But so the objection, Howard doesn't.
But we'll come to order and then see it.
So. Yeah, I think we have to, yeah.
All right, we're back on the record. Why don't we go ahead and have our next witness make their way to the stand? You can call them while they're already up there. And as that witness is coming in, we can bring in our jury.
We can call off Kimberly Peak. Focus on this. I'll get one of them to call off.
Right, adjourn.
Thank you, Deputy Scott. All right, plaintiff may call the next witness.
Thank you, Your Honor. We call Mike Ballard to stand.
You swell. That you get it for
I do.
Please state. Please state, spend the first and last name.
William Ballard.
Mr. Ballard, could you please introduce yourself to the jury?
I'm William Michael Ballard.
And Mr. Ballard, what is your job and your title?
I'm Chief Engineer for Atlas Technical Consultants.
What is Atlas Technical Consultants?
Atlas is a fairly large, multidisciplined engineering firm that provides infrastructure engineering type support across the country.
How long have you been in that role, sir?
I was actually the president of Piedmont Geotechnical Consultants for 25 years. Atlas acquired us about 5 years ago, and I've been in this chief engineer role since that time.
Where are you based?
Atlanta, Georgia.
And are there particular industries in which Atlas works?
It's actually a wide range of industries.
What type of services do you provide to your clients or customers?
I specifically, I'm a geotechnical engineer by education and by experience. My background is to investigate the ground to see how it will support different types of construction, and also lead teams of people that do inspections during construction, anything that's structural in nature about the building.
Go to college, sir?
Auburn University.
And do you have any licenses or certifications?
I'm a registered engineer, PE, in the state of Georgia.
What steps did you take to get those certifications?
So I have a master's degree from Auburn. So with a master's degree and at that time, 3 years of relevant experience, you can take a test. And if you pass that test, then you're designated as a professional engineer.
How long have you worked in the field of geotechnical engineering?
40 years.
And can you tell the jury what you mean when you describe geotechnical engineering?
Geotechnical engineering is the engineering of assessing how ground is impacted by construction or how construction will impact the ground.
Have you been, so we're here today, of course, about the walkers and soul driving park. Before we get to that, have you been involved in other construction projects?
For 40 years, that's what I've done.
Have you served as an expert in other cases?
I have.
Your Honor, at this time, although I think it may already have been technically admitted through the court's prior ruling, but just to make sure, we would tender Mr. Ballard as an expert in engineering.
Other than the objections previously preserved for the record, any objections? Any further objections?
None further, Your Honor.
All right, you may proceed.
Mr. Ballard, will you tell us how you know the plaintiff, Mr. O'Leary, in this case?
Yes, our firm was retained to provide inspection services during the construction of her project. That's my initial, that's when I met her. I don't, it was 6 or 7 years ago.
And do you recall if you were retained directly by her or by another entity?
I think we were retained by the entity be our guest, but I'd have to look back on our files to know.
And tell me about what your involvement was in this construction project.
In this construction project, there was supposed to be several minor types of structural work done, and our firm tests that types of work. If they're pouring concrete, we make sure it's strong enough. If they're erecting steel beams, we make sure they're structurally attached so that the building does what the building is supposed to do.
So there's been some discussion on this point before you came in today. I want to get clarification around this. You said you came in for structural purposes. You said you're a geotechnical engineer. How are you qualified to be involved with these structural issues?
So you can look at the geotechnical part of construction inspections having two components. We initially inspect all things that are ground related before the building starts to be constructed. And then as the building is constructed, we actually inspect the structural components. We don't design the structure, but the structural engineer has designed the components, and we check to see if the concrete has the correct strength or if the number of bolts in the beams are the correct number of bolts and that type of thing.
Good. Bring up on the screen. What's already been admitted is plaintiff's 120. Mr. Ballard, if you have any issues seeing these things, I can also bring a hard copy. But let me ask you, are you able to recognize this image?
I think it's the ground floor plan of the proposed construction space that B, our guest was going to renovate.
Recall there being two separate spaces.
Yes.
And looking at this image in particular, are you able to recollect, as we sit here today, approximately where that sinkhole was?
I can't on this drawing.
Objection, this is cumulative and quite frankly is not in dispute. So I'd like to be respectful of the jury's time.
All right, Mr. Halsey, if we can, the kind of the window dressing aside, let's get to the opinions.
Like crazier things happen and somebody witnessed people not thinking we're talking about the same thing. So just make sure if we all accept that, then we'll be glad to move forward here. And so did you, Mr. Ballard, have an opportunity? So let me back up. You mentioned previously working at Piedmont Geotechnical. Is that where you were working at this point in time?
Yes.
And your role there, the same, were you a geotechnical engineer?
That's correct.
At that point in time? Did you have an opportunity yourself to go to the sinkhole and look at it?
I did.
And tell us about what you saw upon your visit.
So the contractor had cut a piece of slab to do part of the renovation. The slab had fallen down into a hole, and I was called on site to take a look at the overall condition, and I did.
We can bring up to the screen Plans 85. And does this look familiar to you, sir?
I can't actually see that very well, and it's not showing up on my screen. Yeah, that's a piece of the slab. They had cut the slab loose, and a piece of the slab had fallen into the hole that was not known about that was below the slab.
And did you have somebody working for you at that time who went out to the side of the sinkhole to make observations?
Yeah, an engineer, Jonathan Sharp, was the initial person that was on site to take a look at this. And so he let me know what had happened, and either a few days later, I went out and saw it myself.
And when you go out to look at a scene like this, what is, first of all, I guess, what was your remit at that time? What was it that, why did you go out to the scene?
I was the most senior engineer that we had, obviously, and when we run into something that unusual, it's fairly common for our project engineer, if he hasn't seen something like that, to let me know. And if I have the time and if I think it's worthwhile, then I'll go out and look at it myself.
In this case, you made a decision it was worth your while to go out there?
Yes.
And why is that?
We had a potential sinkhole under a building.
So, what did you do at that particular time? What was your role at the time of your first visit? Did you make any reports back to anybody? Did you talk to anybody? What were you doing?
It's been a long time. It's been at least 6 years. I don't remember if we had a discussion with the project superintendent at that time. We would have followed up with either a field report or a written letter report about the conditions that we saw.
You recall being asked at least around that time to do anything else?
Ask the question again. I didn't hear you.
Do you recall around that time being asked to do anything else after making your initial observations and field reports?
Not immediately at that time.
Do you recall being at a later point in time asked to review some additional reports that have been generated regarding this sinkhole?
Yes.
Okay. Let us put up on the screen what's already been admitted to evidence. Plaintiffs 97. Actually, sorry, before we go there, my apologies. Can you bring up what's already been admitted? Plaintiffs 24. Just so we have a clear record of timing and what happened. You mentioned having somebody that worked for you reported to you going out to the scene. Is this the field report that person would have generated, Mr. Sharp?
That is correct.
All right, and what's the date of this?
July 13, 2018.
And what were the at least initial observations from your team?
I think Mr. Sharp identified that this was, he'd looked on the plan, realized there was a very old City of Atlanta sewer that appeared to be immediately underneath this sinkhole feature, and that he suggested that some steps be taken to evaluate that sewer as being a possible cause of the sinkhole before any other steps got taken.
Let's now bring up the plaintiff's 97. We'll take a look at this, sir. This has already been admitted to evidence. Do you recollect being asked to take a look at this report?
Yes,
Okay. Who asked you to look at it? For what purpose were you asked to look at it?
I'm sure our client asked us.
Okay. And did you in fact review that report?
I did.
I'm going to bring to your attention another item that's already been admitted to evidence. It is plaintiff's exhibit 109. You can bring that up on the screen. And is this another report that you recall reviewing as part of your mission here?
Yes.
Okay. And what is this report?
It's a report from the City of Atlanta that I think transmits information from one of their contractors about doing some various types of investigation of the sewer.
I think we talked about your on-site visit, a observation by your Jonathan Sharp report to you, the September Hagberg City of Atlanta report. Do you remember reviewing anything else, taking other visits, doing anything else before rendering opinions about the sinkhole?
No.
And so, based on all of that, what opinions did you form about the sinkhole?
That it was likely caused by some current or past malfunction of the city sewer, and that until it's fully investigated, there would be no way for me to be able to predict how the ground is going to perform in the future, and thus how the building will perform in the future.
Show you what has been previously marked as plaintiff's exhibit 130. Who recognized this report, sir?
Yes,
And tell me how you're able to recognize this report.
this is a report I wrote after I looked at the information that was provided to me.
And when we tendered evidence, plaintiff's exhibit 130.
Any objection?
Your Honor, we believe this is hearsay. And I'm not immediately coming into any exception that would apply.
The plaintiff's 130? All right, Mr. Halsey.
Witnesses on the stand, he's available to certainly be crossed about it. It more formally captures his analysis. And so I wanted to ask him about additional detail that was contained in this report.
No foundation for a
Okay,
hearsay.
I'll try to keep asking the questions, but if the city can't recall, then we can go through the exercise of refreshing on the election. So let's,
Okay,
we won't put that.
All
up
right,
on the
so
stand.
be rephrased for now.
I'll turn that report over. We're gonna test your memory. Do you recollect first of all, did you alert our client to your findings about the sinkhole?
Yes.
And when did you alert our client?
Either immediately during my site visit or immediately after my site visit. Although our client had already been warned by Jonathan in the field report that he'd issued immediately after his site visit.
Did you first get an oral report, a written report, both?
I do not recall.
And does November 7th of 2018 sound about right?
Sounds about right.
Do you recall, first of all, making an observation from your site visit about the size of the sinkhole or void that you saw?
I do not recall.
Is there anything to refresh your recollection about the size of the void or the sinkhole?
There are several reports that I have seen that I recall having seen that talks about the size of the slab and the hole, but I don't recall what those numbers are.
What you generated reflected that. Would that be helpful in refreshing your recollection?
It would.
With that, Your Honor, may I ask this witness about that?
You can direct him accordingly.
So let me start by asking this. Looking at this report, does it refresh your recollection about the size of the sinkhole?
Yes.
And what was the size of the sinkhole?
The report says about 6 feet by 10 feet in length, in dimensions.
Consistent with your memory?
Yes.
By the way, we're using the word sinkhole. Is that appropriate word to use here versus void? Can you explain if there's a difference in how you view that?
Sure. From a purely technical standpoint, a sinkhole is typically described as some kind of ground feature caused by a dissolution of the rock that's under the ground, and then the ground falls into the hole caused by the voiding of the rock. Here, it's not a natural condition. We don't have that kind of rock in Atlanta, so it's not technically a sinkhole, although we've generally called it a sinkhole in this process.
Do you recall observing as part of your investigation, either directly or through the reports, being aware of a possible rock sewer underneath the ground?
I was aware of that from both reviewing Jonathan's report, reviewing the plans after the fact, and talking to him.
And did that have a significance to you in your investigation of the sinkhole?
Yes, this sewer is now over 100 years old. You can imagine the construction is an old rock and mortar brick sewer, and the history of those sewers in Atlanta for the last few decades has been that they're increasingly frail and subject to failure. And so having a sewer of that generation and of that construction type immediately below the sinkhole lent us to believe it's likely the cause of the sinkhole.
The Palmer Engineering Report of September 2018 and the City of Atlanta report, were you looking specifically with an eye toward whether that might be the cause of the sinkhole?
Yes.
And what did you determine after reviewing those reports?
Well, the Palmer report just addressed things that they had not done any inspection themselves other than visual inspection of the sinkhole. The City of Atlanta report could have been useful, should have been useful. The city's contractor did several types of tests on the sewer. They ran a camera through the sewer, and in theory, if we had a hole in the sewer that caused this loss of ground, we should have been able to tell from that video what's going on. They also ran different kinds of water tests and smoke tests on the sewer. All of those tests came back inconclusive in that they did not identify any defect in the sewer from their reports.
At that point in time, from the reports you read from your site visit, were you aware of what the cause was of the sinkhole?
No.
Of course, you were made aware through the city report that grout had been applied or filled into the sinkhole. Was that significant to you? What did you make of that?
Yeah, it was not in the city. Well, at some point it was in the city report. And the issue there is filling the hole with, the city had a contractor fill the hole with grout. Maybe as a means of just keeping the hole from getting bigger. I don't really know. But what it did is it covered up the interface between the hole and the sewer below, which made it impossible for me to be able to look to see if I could see anything that would help us understand why the sinkhole occurred and whether it might occur again in the future.
Your ultimate you said your ultimate recommendation was cannot predict whether a future loss of ground would occur and whether it might impact future performance of the building or its safety. Can you explain what goes into that recommendation?
So what I'm trying to do as a first step is I'm trying to decide or figure out the likelihood. This is not a naturally occurring thing, and it's not a hypothetical thing. This actually happened. So my first step is to try to figure out why this happened, because only in understanding why it happened, and I'm able to predict why it will or will not happen in the future and how big another cavern might get or not get. So without knowing the cause, it's hard for me to be able to predict future performance of the building and whether we'll have another cavern or already have another cavern and how that might impact the safety of the building. I was not able to determine that because the hole was filled with this flowable fill that prevented any visual observation from me of what was going on.
And when you're talking about safety, what are we talking about when we're in the context of discussing a sinkhole?
So we're not talking about necessarily imminent safety this second. What I was talking about is the fact that this sinkhole continues to form because we haven't found the cause, we haven't fixed the cause. We have potential for another episode of loss of ground, which if it moves itself over to underneath one of the footings instead of underneath the slab, then we actually have potentially a safety condition relative to the building itself.
With those being your recommendation about what needed to occur, did you ever learn during the course of this matter, not the litigation, but when back in time when you were involved with the investigation sinkhole, did you ever learn that the recommendations you had put forward had been followed by the Conservancy?
No.
Did you continue to stay involved in this project beyond the November report?
One or two conversations. I think I submitted a proposal to do some additional investigation. But other than, and that was not, we were not authorized to do that work. And other than that, we've had no other involvement.
Yes, you can take a look. Show you plans 133. You submitted 133. Mr. Ballard, do you recognize this exhibit, which has already been admitted into evidence?
Yes.
Tell us how it is that you were able to recognize it.
I've seen it over the course of the project or over the course of this litigation.
When you reviewed this, well, first of all, is this something you reviewed?
I have reviewed it.
Okay. Do the opinions that are contained, well, let me, if you had time to read it like just now, I know it may have been a minute since you read it. I want to give you a moment to read this.
Okay.
Did the opinions that are contained in this report from Mr. Eric Hagbert on November 15, 2018, change your view about what needed to be done in connection with the sinkhole?
No.
Okay, can you tell us why?
Because even he identifies here that the cause or the source of this sinkhole has not been found. But he doesn't really conclude anything about that except the building is safe as it is, and the implication is as it is right now.
Show you latest exhibit 144. Sir, if you recognize this exhibit, and if so, how?
It's an email from me, so I do recognize it.
tender into evidence plaintiff's exhibit 144.
No objection.
144 is admitted.
All right. Let me first ask you to scroll to the back of this email, or maybe you might say the beginning of the email. And I'm going to ask you if you see that this report we were just looking at, whether that is attached, the Palmer Engineering report.
It is attached.
And was that, there was an email in the middle dated February 13 from Ms. Drollet to you and Mr. Sharp. Did you see that, sir?
Yes.
And is this, where Ms. Drollet wrote this report?
Yes.
I want to take your attention to the beginning of this email chain, or the end of it, I guess, when I look at it, but we bring it up to February 14th. So email from you to Ms. Drollet.
Well, that part of it is actually, okay.
Yeah, actually, that's not the
Got it.
top of it, but I
Yeah.
guess while we're there, what did you understand this to be?
This is I had the Palmer report. This is my response back to Ms. Rolette in regard to the Palmer report.
And in your response, you say a couple of things. You say, these assurances to be the best Palmer can say, never gonna get any better way than this letter states. What did you mean by that?
I mean, Palmer's, in my opinion, gone way out on a limb and made some statements that the building is safe. And my opinion to my client is that no one is ever going to say anything better than what has been said here. We certainly would not, and I don't think her structural engineer would either. And that's the intent of my email.
I want to break that down. When you say something, nothing better, what does better mean? What does better qualify?
So Palmer in their letter made some statements, but then they qualified it certain ways. And what I'm saying here is no one is ever going to give you any better assurance than what Palmer has attempted to give you in their letter.
They said it safe or something close to that. You're saying that is as good as it's going to get.
That's what I was telling her.
Does that mean, in your view, at that point in time, you thought it was safe for Ms. Drollet and her team to resume construction of the site where the sinkhole is?
Objection.
No, it does not.
Sorry, well, hold on.
Objection. This witness has no opinion on the safety of the community center. Closed and told me in his deposition, he has no opinion on safety.
All right, Mr. Hulsey, if you want to come perfect your record, you can approach and just read it in.
So he's re-referencing structures being one of the areas I was reading that, so I think he's actually said that on exam already.
Yeah, tend to think that that's just a code part of his opinion. He is very careful. Just he has no opinion on safety. That's the only thing he is willing to say. Mr. Lesson's guarantee of safety, and she's never been here. No opinion regarding safety is disclosed. Yeah, that doesn't really indicate. You know, safety is the core of whether the void is coming back or not. That's what everyone's opinion is. Safety. Anything else you want to reference or something here?
And then we have the disclosure.
Writing the installs, I think you need to dance around that line.
We supplemented our disclosure, but the disclosure was he would testify to matters that were covered in his previous deposition, in which he covered everything we're talking about today.
Disclosure for this, because there was no change. There was some disclosure changes.
So. Can you? Yeah. All right.
I think they're drawing.
But I mean, it's just more of the notice issue. I mean, can you show me where that's been updated, Mr. Holiday?
And yeah, it is cheap. It's correct that it was the other one. Actually, it was a supplement. So this was, we did one. You're correct.
All right, so I think just in terms of the framing of the question, if you can align it more to what was actually disclosed, I think you're gonna get to the same point, that it just needs to be a little more binary. Of what it means. All right, members of the jury, the objection that was previously noticed is sustained. I'll ask plaintiff to ask their next question, and I'll direct you to disregard the response that was previously given.
In your report of November 7th, you've testified without knowing the source of the void, cannot predict future loss of ground and future impact, performance of the building or its safety. Do you recall that being in your report?
Yes,
Does this email suggest that as of February 14th of 2019, you had changed your view about that?
no,
Do you still hold that opinion as of the date of this email?
yes,
In your email, you further say, with subsurface conditions, there can never be a guarantee,
right,
right? Does that mean you never can give anybody the green light to move forward on a project?
no,
So there's green lights and red lights on a project and whether you can move forward or not. Is that fair?
it would all be dependent on your expectation and level of risk.
If this did not satisfy your level of risk, you were prepared to sign off on.
No,
Do you recall, actually, let me grab these, did it? Show you what the mark is, one. Do you recognize this exhibit, Mr. Ballard?
I do.
Tell us how you were able to recognize this.
It's a proposal I wrote for doing a limited subsurface investigation.
And well, this be in the evidence, putting us one to three months.
No objection.
151 submitted.
All right, and sir, what is the date of this letter?
April 5, 2019.
And who's this letter directed to?
be our guest who was our client.
And what, without reading the whole thing to the jury, what is the gist of this?
We propose to do a limited investigation of the area around the sinkhole using a particular type of subsurface investigation method called, I don't remember if this was ground penetrating radar or electrical resistivity, but some method to try to investigate whether there are additional caverns underneath the slab.
And why did you make this recommendation?
We were asked if there was some method, now that the hole had been filled in, that we might go through and do some kind of investigation of the ground.
And what would be the potential of this sort of testing? What might it help reveal?
One of the concerns is that the city's contractor had filled in this hole, but that does not necessarily mean it filled in the entire cavern, as it were. If there were additional cavern, and we weren't saying that there were, but if there were and they were close to the slab, meaning not very deep, this is a method that can be investigated by running this equipment across the slab that can see voids at a fairly shallow depth below the slab.
And was one of your concerns that in addition to sinkhole, there might be some in other parts of the building outside of the leasehold?
Outside of the hole that was filled in, yes.
So maybe not limited to just the walkers and Solshine.
I don't know.
This is so small, they can't read this. Well, let me ask this question. The proposal was running the ground penetrating radar. If that had found no voids, first of all, was your proposal ever acted upon? Were you authorized to go do this?
We were not.
And do you know why?
I don't.
Okay. If you had been permitted to do that, you'd run GPR, and not found voids, what would that tell you?
So that's part of the issue in this proposal is that this technique.
Okay, Supervisor, there's been an objection. Just speak up so we can hear you. That's overruled. All right.
So this type of investigation is good at looking at fairly shallow depths, but the sewer's down 10 or 15 feet in the ground. If we had additional voids close to the sewer, this technique would not have found them. It would only have found something that had manifested itself very close to the slab. So my concern is it's almost like having a false negative. We would detect no voids, but that would not necessarily mean that we had really done everything that we needed to try to figure out if there were voids. It's very limited.
Show you what's been marked as plaintiff's 150. Like me, you may not.
Oh, no.
Let me, I guess, find out if we have any objection to 150, and if not, maybe just have to blow it up and look at it.
Any objection to 150?
Plaintiff's 150.
Well. No, other than it's, hopefully we can enlarge it.
Yes. Okay.
All right. So it's P 150 is admitted without objection.
So let's bring this to speed and obviously pull it up. Right. Start from the beginning or bottom of the email chain, please.
Is this the same exhibit that's on the screen?
No, that's. No, it's different. Yeah, it's just a longer exhibit, so it's the first in a series of.
I don't know if that's it.
Okay, I just thought I was seeing confidentiality redactions and I don't see that in mine, but
Do we want to get to? Is that the part we want to get to?
No, we want to get to the part between.
Yeah, it's
Yes.
right here. Wait, hold on. All right, so let's scroll to the top. Just a moment, Judge. Sorry. Okay, that's good. Man. You can scroll just below the exhibit 150 number. Down to here, guys. We can scroll to here.
Okay, so the bottom of the page.
Just put them on there, yeah. Okay. I think we've targeted what we want to look at here.
I just want to clean this up. Is there a issue with 150 and the previous lack of an objection? Are we all looking at the same exhibit here?
I think we are, Your Honor. I'll note if not. I'm just struggling because it's unreadable on paper.
All right.
But no objection.
All right. Well, unless I hear otherwise, 150 is admitted and you can ask your next question.
So, sir, are you able to read what's on the screen in front of you?
Yes,
Okay, and this is an email from Ms. Drollet, what directed to you and your colleague, correct?
that's correct.
All right, and what is going on here in this email?
She's asking for a proposal for us to do some type of investigation.
All right, and what is the date of this?
April 2019.
Is it your understanding she was still trying to get this project to move forward at that particular point in time?
Yes,
Scroll up. And is this your response to Ms. Drollet?
that is correct.
All right, and what are you are conveying to her in this email?
That because the hole had been filled in, it prevented any kind of reasonable access for me to do any visual inspection, and that the next best thing I could come up with to do would be to do this ground penetrating radar test.
And let's go up to the email above that. All right, and what is this still the same day? Is that correct, sir?
April the 4th.
Right? And do you recall if you provided a quote?
I did. It's this proposal dated April the 5th.
Got it. Okay, the thing we looked at a moment ago.
That's correct.
So if we can take a look at this whole email here, sir, if we can bring that to the top, Lisa, of this one. Back down, Lisa, sorry,
Catherine, here are my thoughts. Keep going down.
going down. Go on. A little bit further. Thanks, Lisa. But here are my thoughts. Is what we're doing.
Right.
Okay, can you tell us, I just want to make sure we bring out, whoop, we just passed it, I think. So your thoughts about moving forward. So thought about the possibility of conducted GPR. Let's keep scrolling down. So what did you intend to convey in this email communication to Ms. Drollet?
That the GPR, the ground penetrating radar, is one technique we could use to look into the ground, but it has its limitations, and I wanted to make sure she understood the limitations before we proceeded with any work like that.
Just a moment, Your Honor. Apologies, all the other exhibits working right. This one was a problem, obviously. Apologies. So we need to scroll down just below
Right
that,
there.
right there. Okay. I think that's the last thing we'll ask you about this email, sir. So this is between, all right, hold on.
You had
Let's
it.
shrink it back down. Sorry. So this is between you and Mr. Olet. Is still the same date, right? April 4th. And what's going on here, sir? What are you intending to communicate here? Or what did you understand from Mr. Olet?
This is just a response to her responding to me about the limitation of the GPR and or whether we might have to do something additional other than GPR. I talked to her before about if we can find voids, if we do find voids with the GPR or we don't, there might still be a next step in this process to do boreholes through the building slab to see if we can physically find or prove there are not voids.
So was it your opinion, this is your opinion, that there still were steps, even though the backfill had been applied, that could be taken to get to a possible solution here so that the parties can move forward?
We had two issues. One is the fact that we had a defect that caused a loss of ground, and that's something that happened, and that we had not found the source of that defect, so we can't predict how that's going to happen again. The second thing we could do while we're still trying to sort that out is see if that defect had created other voids underneath the slab or had not. And so it's kind of we're trying to answer two different questions.
Obviously, at some point, backfill had been applied. You already talked about the backfill and implications of that. My question is specifically, after the backfill had been applied, was there a path to still possibly figure out the cause of the sinkhole so the parties could remedy it and move forward?
Yes. Well, potentially, yes.
No further questions, Your Honor.
All right, and just for planning purposes, any estimation of the length of cross-examination or time limit wise approximately?
I would say approximately an hour.
All right.
Maybe a little more.
Okay, understood. All right, so members of the jury, we've covered all the ground we can today. So I'll excuse you with the direction to please don't do any research about this case and don't discuss the case with anyone, including amongst yourselves. We will be back tomorrow. We'll say 9 a.m. And same as before, just give us updates if you run into anything out on the roads. Any other concerns before I let you go? Seeing none, we'll see you tomorrow. All right, Mr. Ballard, you can step down. If we can see you back here right on that stand at 9 o'clock tomorrow morning. And you can discuss the case with counsel, but you shouldn't be discussing testimony that's happened before or discussing anything with any of the potential witnesses in this case. All right? Thank you, sir. All right, turning to the parties, anything on behalf of the plaintiff before we break for today? And y'all can be seated.
Nothing from us, Your Honor.
Okay, anything from the defense?
Well, one thing, Your Honor, maybe two things. There has been some suggestion regarding City of Atlanta, former or current employees who the plaintiff intends to call as witnesses. I have not received copies of any subpoenas that have been issued. I would like to not spend a lot of time preparing for witnesses who are not going to appear. And I don't frankly believe that City of Atlanta employees are going to show up here voluntarily. So
They're on the witness list, though?
are.
Okay. All right. Well, I'll say it was agreed to in the pretrial order that there was going to be 48 hours notice. So I think the parties agreed to that. Any position on the part of the plaintiff?
I think we're abiding by that, Your Honor, and of course, we reserve the right not to call witnesses if we get to that point and make a strategy decision, but right now we intend to call the witnesses that are listed on our witness list.
Okay.
But my concern, of course, is receiving 48 hours notice of a bunch of City of Atlanta potential witnesses, spending a lot of time preparing for them, and those witnesses not appearing.
No
Well-
intent, yeah, I'm sorry.
Oh, no, go ahead. You can respond.
No intent to sandbag anybody. That if we
Yeah.
decide we're not calling somebody, we'll make it known as the moment we know it, but we're not going to be rushed into making decisions.
All right. And I mean, I think at this point, I haven't seen any indications of gamesmanship. And I think it's evidence that both sides have put work into the case and everyone over prepares, and that's just part of going to trial. So if you want to re-raise it, because I would say at least, day of, that would be an issue. But if they're telling you the day before, it's going to be hard for me to see how that's going to cause any prejudice, even if it is a strict violation of the pretrial order. But noted.
And the only other thing that I'll say is that is just timing. Again, we're trying to make sure we know when we're gonna get started with our case and
Mhm.
witnesses. We expect certain witnesses and then all of a sudden 5 aren't being called. That would obviously make a difference in timing. So we're gonna. And the only thing that I wanted to raise with that, and Scott, perhaps we can just talk about it, given that we are a little bit behind schedule from what you disclosed. I just wanted to get an understanding of who it is you're planning to call tomorrow, if that order has changed, given I don't know what your witnesses restrictions are on appearing. So if we could just talk about that, we don't have to do that here, but that'll help us plan accurately.
We'll handle that, Your
Yeah,
Honor.
and I certainly think that the next day's lineup is fair game, and even with a little buffer. To that end, I did want to flag something perhaps that also could be a point of discussion for the parties. A good chunk of the plaintiff's witness list is all the prior counsel to address attorney's fees, and I understand that the whether they're justified, the reasonableness, and the amount are all reserved as jury questions and will be on the verdict form. And what I'm wondering, though, is to push a little more. I understand that there may only. I'm wondering if the amount is not something that can be agreed on, not conceding their reasonableness, but that the foundation of this is how much we build is something that cannot be agreed to, with still reserving the ability to come back and point to which ones you think are unreasonable. So I just want to put that, actually be, I guess, to both sides. And maybe you could even further note, drill down, and if there's a specific time period that you think you're really honing in on and saying these are unreasonable, such as the things related to the dismissed claims, do we really need all of the prior lawyers, or do we just need the lawyers that handled that aspect of it? So I put that to the floor.
We're happy to give that some thought. I think that's a good suggestion, Your Honor. Again, we would not be stipulating to reasonableness, but I think what you're saying is perhaps the parties should not force each other to add up every dollar to get to the total amount. And I think that's a good suggestion.
I mean, precisely, and more also to reasonableness, perhaps that there are some portions you could say are the target of what you consider unreasonableness, unless you're saying all of them are, and then fair enough. But if it's really only certain segments you're saying are, then perhaps those are the only attorneys we actually need here. I don't know. That's your case. But at a minimum, I would think the amounts and the addition and subtraction.
Or we can work on the latter, unlikely.
All right, and I'm the same, I think, issue over on the plaintiff's side in terms of the amounts and whether you're saying some are reasonable or not unreasonable.
We're certainly open to simplifying the presentation on that front, so we'll consult with counsel.
All right, then with that, if there's nothing else to be discussed on the floor, we'll see you back. I'll go ahead and say 9 o'clock as well. I have some criminal status hearings I'm hoping to get through on Zoom and be able to kick things off more like 9:10-ish, 9:15-ish. We'll see how we do. We'll be in recess until tomorrow morning. Thank you all.
John.
Are we keeping the same order or are we now?
We'll have to,
Recording?
loosely, but we need to, confer amongst ourselves.
And we'll finish that one first. And then do you still think it'd be Erickson next?
If you'll, I largely think it's gonna follow the same order, but I need to confirm with the team because I don't know
Okay.
if I have time restrictions,
Yeah.
but we will, again, we're not planning to play games. It's gonna be close to that, but we'll get you, we have.
Yeah. Try to get that by like 6:30 to us so we can plan accurately.
We'll do the best we can.
Okay.
Yeah.
Yeah.
No, yeah.
No, I don't know whose this is.
I need, I can
I guess
actually.
he's over.
So let's bring it. Let's bring this.
On this table. Not the finder itself, but. I don't know, they just thought about the firm rates.
Oh, good. Okay. You gonna be with us for the trial?
Maybe, we'll see.
Someone's just telling you when to be here.
I'm full. All the stations are. I mean, all the stations get access to it.
I saw the judge.
Yes, so like, not everybody's here. Okay, hold on. Exhibit 73.
What do y'all, what's wrong?
We're just trying to get our exhibits clear.
Oh.
Let's do it in the morning. Nika? So, yes, yes, oh, definitely. We're tracking you. We're tracking yours as well. Yes, that's each of us. Yeah. All right, we'll get you our copies in the morning. Yes. Great. Okay. Thank you. Thanks, Lynn.